হ্যাঁ বল। আমি নয়ে আছি, নয়তে আসছি।
অ্যাপ্লিকেশন ভিতরে কি অন্যরা চেক করে নাকি? হ্যাঁ, চেক করে অ্যালাউ করে কেমন করে অ্যালাউ ক্রস দিয়ে দিয়েছিল, একটা এখানে বেরিয়েছিল যেগুলো রিজেক্ট হয়ে ক্রস দিয়ে দিয়েছে। হ্যাঁ, অ্যালাউ হলে তবে আসাম বেকা আবার করো, লিস্টের অনুযায়ী করতে হবে। একটু সামাল দিতে
Yes, column.
May I be permitted to mention?
Extension of interim orders, please hand over the slip. Yes, call on the list. Application also hand over. Application, extension of interim. No upgradation.
Lordship, auction notice was issued by the bank, the sale
Yeah.
of property.
Release on what ground?
May.
If it's a residuary matter, no. Other matter, other benches are equally placed. I'm sorry.
My lord,
Please call on the list.
my lord, I am,
matters monthly list to be.
my lord, item number 1344, my lord.
One
please
who is
release,
appearing.
my lord.
Item
My
one.
lord,
Come forward.
Lordship, auction notice was issued by the bank, this
My
sale
lord.
out my property 22nd.
You are in item number one. You are for the petitioner.
my lord, I am compelling circumstance, I am claiming for release of the matter, my lord. Item number 1344, my lord.
Yes.
This is pertaining to election, my lord.
আপনার কি?
কথা জানাতে এসেছি লর্ডশিপ আমি বরাবরই ইন পার্সন করে আসছি আর আমি সামান্য ওলা উবের বাইক ট্যাক্সি চালিয়ে দিন চালাই
আপনি কি বলতে চাইছেন বলুন।
আমি চাইছি যে আমার ম্যাটারটা আমি রোজ রোজ যদি কোর্টে এসে এরকম করতে হয়
আসবেন না কোর্টে,
আমার পক্ষে
অনলাইন দেখে নেবেন।
3 দিন
Yes.
My lord, item number 1344 kindly be released. This relating to election, my lord. Place of election to be rescheduled, my lord. Polling station rescheduled matter, my lord. Kindly be this matter.
You are
be
for the
released.
petitioner.
My lord, I am for the petitioner.
Yes.
My lord,
Please file your written.
My lord, I am for the Union of India.
You are also filing your notes. Yes.
Yes, I am also filing notes.
The written notes of arguments filed for the petitioners, the Union of India, and the added respondent today be kept on record. The hearing is concluded and judgment is reserved in the matter. Thank you. Next, two.
appearance extension of interim order item number 2
Yes. When does it expire? Interim order?
Lordship, I appear on behalf of this.
Very well. Interim order granted earlier is extended till June 30, 2024 or until further order, whichever is earlier. The matter be placed in the monthly list of June 2024 for hearing. Pardon, I can't hear you.
Kindly gives it a short date, your lordship.
Next matter.
upgraded matters item number 3 with 4
Yes. Who is appearing? Yes.
I am for the bank, my lord. Punjab National.
Yes. What is the matter?
My lord, this is my lord affidavit reply.
Your opposition has been filed?
Yes, my lord.
Yes, they have filed opposition.
My lord,
Lord.
the company was represented by Miss Roy Chaudhary, Porna Roy Chaudhary. She's
Miss?
Porna Roy Chaudhary.
Yes, yes.
Integra.
Right.
My lord, the
Yes,
petitioner,
what is the matter?
my lord, the petitioner before your lordship. My lord, he is an,
আমি অসুস্থ আমি আমি সাহেবের
মানে
সাথে
হি-
বলবো আমাকে নিবেদন করো আমার
1 minute.
পরিবার
আপনি এভাবে করতে পারেন না।
আমার
আপনি কোর্টে গন্ডগোল করছেন। আপনি এটা করবেন না।
অবজেকশন নিয়ে
আপনি
আসছি।
ইন পার্সন অ্যাপিয়ার করছেন মানেই যে আপনাকে আমায় অ্যালাউ করতে হবে মেনশনিং, এটা একেবারেই ঠিক নয়। আপনার ভুল ধারণা।
আমি তো অসুস্থ আমার পরিবারে
আপনি অসুস্থ, অনেক মানুষ অসুস্থ আছেন, কিন্তু তার মানে এই নয় যে তার ম্যাটারটা আগে। যাদের ম্যাটার আমি নিচ্ছি তাদেরটা ইকুয়ালি আর্জেন্ট। কথাটা বুঝতে পেরেছেন? আমি এখানে কারুর ম্যাটার নিচ্ছি না যারা শখ করে মামলা করেছেন। প্রত্যেকের আর্জেন্ট ম্যাটার, অনেক বয়স্ক মানুষ আছেন। কাজে আপনি কোনো অ্যাডিশনাল অ্যাডভান্টেজ পেতে পারেন না কোর্টে, জাস্ট বিকজ আপনি নিজে অ্যাপিয়ার করছেন। আমার কথাটা বোঝা গেছে? কোর্টে এভাবে ডিস্টার্ব করবেন না। আমার মেনশনিং শেষ হয়ে গেছে, আমি ম্যাটার কল করেছি, প্লিজ। নেক্সট, প্লিজ কন্টিনিউ।
yes, my lord. My lord, petitioner.
আপনি
before-
জায়গাটা ছেড়ে দিন অ্যাডভোকেটদের জন্য।
আমার তো
আপনি জায়গাটা ছেড়ে দিন অ্যাডভোকেটদের জন্য। আপনাকে পরিষ্কার বাংলায় বলেছি আমি। Yes, please
my lord, the
continue.
petitioner before your lordship is a sub agent
Yes,
of the my lord Punjab National Bank.
right.
My lord, in terms of the my lord government, central government policy and Reserve Bank guidelines. My lord, your lordship kindly come to the agreement at page 15, P1. That is the agreement. On the basis of that agreement,
Yes,
I was engaged as a my lord sub agent.
Right.
My lord, apart from the my lord sub agency, my lord, I was my lord engaged for my lord recovery of my lord amount, my lord PNA amount account, my lord from the the person who had taken loan. My lord, I have collected.
the bank was a party to the sub-agency agreement
Yes, bank was not a party. This was a agreement. Original agreement was
with Integra.
yes, with Integra. Integra entered into an agreement, my lord.
What is the cause of action?
Cause of action is, my lord, I made a, my lord, I collected the amount
Yes.
that was on the, I am entitled to get commission from the bank. Well, that was not paid.
If bank was not a party, they're not bound by the agreement, Mr. Singh.
My lord, bank was a party. My lord, bank entered into an agreement with Integra. Integra entered into an agreement. I have direct relation with the bank.
Show me from your agreement, where does it say so?
My lord, your lordship kindly come to page 15. That is the agreement.
15 is the agreement, which is the relevant
My lord,
clause.
my lord, my lord.
Show me the relevant clause, Mr. Sinha. Let
My
us
lord,
not waste time.
Your lordship kindly consider. My lord, this sufficiency, my lord, is in terms of the agreement. My lord, that I was entrusted to collect the amount in terms of, my lord, that is not within the purview of the agreement. That is directly with the bank. Your lordship kindly come to page,
Show me the liability of the bank from any document.
yes, page 29.
29.
They paid the amount earlier, but now they are denying.
Acha, is there any written denial, Mr. Sinha? Any
No.
written denial?
No, they are not denying any written documents was.
So now you are asking for that money? The
Yes, I
dues?
am asking for the money, 12 lakhs and odd. I have repeatedly, I made a representation to them.
Yes, what is the stand of the bank? Yes.
My lord, there are two separate writ petition. One is that they are claiming this commission. It is from 2021 to 23, that period of time.
Yes.
And the second is they have certain allegations against Integra. Now, my humble submission before your lordship is they are actually, she has nothing to do with the bank. Why? She is an employee, she is recruited by Integra. Integra has raised several customer complaints against the person for unethical practices, defrauding customers, etc., for which they had sent a mail and we had blocked her initially. Then, my lord, they had come before your lordship and Integra was not represented at that period of time, and subsequently your lordship had asked us to defreeze that blocking, and we have done that. Fresh complaints again started pouring in from 2024, pursuant to which we had again blocked him. Now, my lord, the document he is relying, what we are saying is whatever commission is due to her has to first be ascertained because account allocation needs to be done. I have the internal policies which I shall place with your lordship one by one. And second is the commission has to be routed through Integra. We shall not pay her directly. Now, this letter that he is showing, my lord, 23rd, dated 23rd, 5, 2022, I have a copy of it. It says, Purushottam branch has verified, recommended, and forwarded a bill of 84,000 whatever, submitted by the said agency for payment against recovery. Not agent, but agency.
Where do we find it?
This is the document he is relying upon.
Page
Just now-
29.
Yes.
Let us
That
come to
marks-
that page. I don't find
Yes,
it
my
here.
lord. That is showing agency. That word is agency. Hukumani, as such, we request the release of this.
It says payment of commission to bank correspondent agent. You admit her to be a bank correspondent agent.
We admit her as a bank
On the
correspondent.
basis of recommendation, the competent authority has approved the bill of Saroj Kumar Bera. We don't know Saroj Kumar Bera.
That is the second person.
Yes. Acha.
There are two persons against which the allegations are founded.
Very well. And Kukumani Patanayak.
I have this copy also. This may
No, if you have not annexed it to the
No,
opposition,
no, this is not
then
a
I won't
relevant
look at it.
document actually.
no.
Now, my lord, if your lordship kindly comes to my
It's your
affidavit.
decision to pay directly to her.
No. Affidavit, if your lordship kindly comes to the affidavit.
Yes.
My affidavit.
Right. Opposition টা কোথায়? Here. Bank এটা. US no. Page. ছেড়ে দিন। হ্যাঁ।
Yes, my lord.
Which page?
Yes, my lord. First, my lord, I shall rely on the internal policy dated
Give me
18/4/2020.
the page.
Yes, my lord, page 3.
Page 3.
It specifies the internal policy dated 18/4/2023
Page 3 of what?
of my affidavit in opposition.
You're the Punjab National Bank.
Yes, my lord.
Page 3, yes.
It starts from paragraph 5.
Right.
I state that as per the bank's internal policy dated 18/4/2003, via its
Is that
circular.
policy annexed here
Yes,
also?
my lord, it is there.
Show me from the annex here.
Okay, my lord. Then, my lord, page 20.
Yes.
Page 20, my lord. It says 0.2.4.1.
Right.
Selection of corporate business correspondent, CBCs. All BC agents will be, my lord, the second last paragraph.
Right.
All BC agents will be appointed under a corporate BC framework, and bank will not enter into any agreement separately with any individual BC. It is to be ensured that such BC agents, whether individuals or entities, are selected after proper due diligence by the base branch before recommendation. This is number 1, my lord. Then, my lord, clause number 2.4.5.
Yes.
That has the fidelity insurance. Fidelity insurance covers losses caused by dishonest deeds of the BCs. Though for any dishonest deeds of the agents, the corporate BC will be held responsible, and any losses to the bank and customer will be recovered from their payouts. But it is recommended that the corporate BC will maintain fidelity insurance cover.
Corporate BC is the isn't it? Right.
Now, my lord, the next paragraph, 2.4.6. Performance of corporate BC shall be reviewed on quarterly basis through a meeting with the head of the corporate BCs. In case the performance is not found satisfactory, their services may be terminated by serving suitable notice by the bank. In such a case, the security deposit would not be refunded, and the performance would be reviewed from time to time. Now, my lord, the next circular, 26/2/2001. This is the most relevant one in this context.
Yes.
It starts from page 29, and the relevant page is page 33.
Yes.
Allocation point number 5, 5.1. Allocation of job / withdrawal of accounts from CBC BC agents. Bank has already executed agreement with CBC for functioning as BC agent. A separate agreement or an addendum will be signed by the corporate BC at headquarters for the purpose of recovery through CBC or BC agents. Invoice will be raised by CBC to respective base branches for payment of commission regarding recovery made in the accounts of the base branch. A new revenue subcode is to be created, commission paid to recovery agent. Now, the next point, 5.2, allocation of account. For NPA accounts having base balance up to 1 lakhs, the branch head can allocate the account. The next having balance above 1 lakh. So basically, there has to be an allocation. That has to be done by the base branch upon recommendation of the CBC. Directly, we cannot. Now, my lord, the next one, the next part of the circular, my lord. It starts at from page 52, my lord.
Is it your case that the corporate business correspondent has not raised the bills?
Yes, my lord, I shall show. Otherwise, I'll get confused myself. My lord,
Yes.
page 52.
Yes.
Point number 2.2. The 10, 15, 16, 17, 18, the next page. Performance of BC will be reviewed on quarterly basis in case of BCs. In case performance of BC agent is not found satisfactory, their services may be terminated prior to the period of contract by serving suitable notice by the bank to CBC. The period of contract can be further extended on request from the CBC, subject to their satisfactory performance and review by the bank at the exclusive discretion of the bank. We are not answerable. If we find somebody guilty, then we can terminate. Circle head is authorized to appoint and terminate a BC agent. And the last, my lord, the next page. Page number 54, my lord. The last 3 points, my lord, starting from point number 4. Person engaged by corporate BC shall not be the employees of the bank, and the bank shall not be responsible in any manner for payment of wages, remuneration, nor payment of PF, EPF to such person. Next point, corporate BC should not in any way convey to the BCs that they can get jobs with the bank. And the next one, the CBCs will have to enter into the agreement with the bank. The agreement with the CBC would specifically prohibit BC agents from charging any fee to the customers directly for services rendered by them or on behalf of the bank. Now, my lord, we therefore cannot proceed directly. What has been done in 14 years annexed, TDS certificate and all that, 14, 15, I am not bothered with, because then how the bank performed a function, I am not aware. But post the agreement with the CBC, the Integra, we have to proceed by the internal circulars, which may be modified from time to time.
Sorry.
And last, my lord, thereafter, my lord, the termination letter was there, the blockage was there, all that was there.
Termination letter was issued by whom?
Integra. And then not really termination, disengagement.
But as per page 20,
Yes, my lord.
clause 2.4.1, the second last paragraph, will be appointed under a corporate BC framework. And it is to be ensured that such BC agents, whether individuals or entities, are selected after proper due diligence by the base branch. So selection is by you, and at page 53, termination is also at your behest.
Yes, but
Because the
in this
period of
case,
yes,
Integra had undertaken to select the person.
Integra is there in between,
Integra,
definitely.
yes, my lord.
But
And the allocation for recovery of whatever commission loan.
But it is you who review the performance of the BC on quarterly basis.
Yes, my lord. That is why we
And you terminate
we
her.
found her unsatisfactory. So initially,
Definitely, you have a right to do
prior
that.
to the first writ, my
But
lord.
selection by you, termination by
That
you.
is what I'm saying. Prior to the first writ, my lord,
Yes.
we had already blocked her. Thereafter, allegations, we asked the Integra to forward us with the allegations, what has actually happened, because complaint had come to
Definitely, you
and
can take steps.
thereafter he had filed a writ petition and unlocked, the code was unlocked.
During the period which he worked, why can't you pay him
Yes,
for
my
that?
Now, my lord, annexure P6, page 80. This is utilization of BC agents for recovery in SMA.
Right.
Right? My lord, the last two paragraphs, in line with the above instruction, this is valid from 4/2/2021 to 3/2/2024. In line the above instruction guidelines and a meeting of the Circle Office Committee approval for BC recovery, a meeting was held on 16th August 2022. It is for Purbo Midnipur for approval of certified BC for purpose of recovery. It was further unanimously decided to engage BC for different branches for recovery in SMA. Allocation of accounts to BC to be done as per details given hereunder. Now, my lord, page 82 has a list of BCs. This does not have the name of Kukumuni Pattanayak. So, under which circumstances could she recover from customers? Because her name doesn't feature here. Allocation of accounts have not been done. And she is relying on a document at annexure P3, that is that to whom it may concern. That is how, bank does not issue. It is a manufactured document, maybe to defraud the customers. That I'm an agent of the bank, see, I have been authorized.
All right.
It does not have the...
She claims for the period 2021 to 23.
23, and her name of allocation list does not feature her name.
Does not appear.
Does not appear. So how, under which authority?
Very.
And my lord, the letter she's relying on, that to whom it may concern, it's a
You are
manufactured.
challenging the veracity.
It is the manufactured document, but it doesn't have the bank this format also, the letterhead also.
Right. Let me hear Integra now. Yes, Mr. Chaudhary.
Lordship, in regard to the first writ petition, my lord, may I draw your lordship's attention?
What are the two writ petitions about? Why two?
My lord, one is directly, my lord, their claim is directly against the bank. That regarding the commission, my lord, for NPA recovery, my lord, I would reiterate that it is NPA
Yes.
recovery. My lord, that amount, my lord, the petitioner is claiming that she is entitled to that claim directly from the bank. My lord, I say Integra has no role to play in the for the NPA recovery. My lord, I like to draw your lordship's attention to, my lord, page number 29, which is the circular of the bank, my lord, from the affidavit in opposition, my lord, filed by my learned friend, my lord.
29 years.
My lord, this is a circular, which is a policy on engaging corporate BCs or BC agents for recovery of NPA and SMA accounts. My lord, in regard to this circular, my lord, the corporate agent, that is Integra, my lord, has no role to play. As my learned friend has shown before your lordship, that they have the power to recruit a BC agent, and my lord, they have the power to review that. In between that, my lord, no correspondence has been made to the corporate agent, which is the Integra. My lord, whether any work of NPA recovery has been assigned or not, my lord, the Integra was kept in dark. Integra never knew that the BC agent has been selected for NPA recovery. My lord,
The assignment is done directly by the bank.
directly by the bank, my lord, in this writ petition. My lord, I'll show it from the circular itself. And my lord, we were not informed either by the agent nor by the bank that any kind of recovery work has been assigned. My lord, I have stated specifically in my opposition, my lord. In regard to this, my lord, the Integra has no role to play, because, my lord, the agreement from with BC and, my lord, the Integra, that is in relation to separate kind of work. My lord, that work comes under the purview of Pradhan Mantri Jan Dhan Yojana, because, my lord, to the villagers and to the all the other rural people, my lord, to whom the bank services are not
What is
being
your
made
stand on
available.
that? What is your stand on that demand?
Well, on that demand, my lord, I would seriously dispute the contention of the petitioner. My lord, because the petitioner has seriously defrauded many customers of the bank. My lord, I have stated in my opposition, I have annexed relevant documents, my lord. I'll show clause-wise that they have violated each and every clause. In
Did you
spite,
give her an opportunity of hearing?
lordship, we
That
did.
was given.
That was given. My lord, it's in the second writ petition. I'll show from the annexures itself. My lord, as of
The opposition have annexed that.
I have annexed in my opposition, my lord, they have also relied upon that document in their writ petition, my lord, which is the second
So
writ
hearing
petition.
was given, after that you tell.
Hearing was given, my lord. She has went before the bank, my lord. She did not choose to cooperate. She has not disclosed any of her relevant credentials. That is why, my lord,
What about her payments during the period which she worked previous
my
to
lord, the
termination?
payment during which she has worked, my lord, at the time when she was unblocked, my lord, the procedure is that we would make a representation to the bank. The bank would clear the payment to us, my lord. We will pay directly to the BC. So far as the time when she has actually worked, my lord, payment will be made in that regard. My lord, they have not claimed for payment in the other writ petition. They have claimed for unblocking of their code, which has been blocked, my lord, on getting several complaints from the other.
So can I record that for the period which she worked, you will be paying her?
Well, that has already been paid. They are not claiming any payment in the other writ petition. They're claiming for unblocking of the code. And, my lord, regarding this, my lord, the bank have directly engaged that. My lord, whether the letter which is at Annexure P3, whether it is right or not, my lord, of the record, since I appear for the bank, I know, my lord, in that way, no letter could be given to a petitioner. But, my lord, this particular document, my lord, this particular circular shows that bank has the power to engage a BC agent directly. If at all, my lord, the petitioner was engaged, and, my lord, the petitioner has worked. Whether the petitioner has worked or not, my lord, the bank is the answering respondent there. But in regard to this work, my lord, the Integra has no role to play, because the agreement with Integra clearly specifies, but like a mini
Which
deposit.
writ petition is for NPA collection against the bank?
My lord, this is the first writ petition which your lordship is at.
Number?
My lord, 3697.
3967.
3967.
3967.
Let me hear Mr. Sinha.
Lordship.
Yes.
My lord, the agent, my lord, he has admitted that he has nothing to, no role to play. My lord, this is, my lord, the petitioner before lordship was directly engaged by the bank, and, my lord, render service, and payment was made for certain period, and thereafter, my lord, I placed a demand. My lord, that is my writ application. Your lordship kindly come to page 31. 48,734. But they are admitting that, my lord, they have engaged by that document showed page 29. I have shown to your lordship, and they have paid 74,000 and odd for 2 months. And there is a, my lord, there is a provision, my lord, in the, my lord, the circular, that they can directly appoint in special circumstances.
Yes, page 33 is there. Either corporate or you directly. Very good. So this is your. Ms. Mitra, I'll ask you a short question only on the reply to Ms. Raichodhuri's contention regarding your payment. Now, apparently you appoint, you terminate. You have your hand in these two stages, at these two stages. And that NPA circular at page 33 of your opposition, it says you'll CBC stroke BC agents, branch heads to allocate eligible NPA accounts to CBC stroke BC agents. They're disowning. Now, what about your payment regarding this quantum at page 31 of the writ petition? Why, how can you withhold that? Page 31 of the writ petition,
As
the
per my
39,
My
yes.
only thing is, as per what has been done in the past is not to be,
No.
I personally do not have the information. But as I get to see from the circulars, my lord, there has to be an allocation of account
You
Now-
say from that document that her name was not there at all.
at all. So she has to show me some allocation in her name. Privately, what she's doing with a particular branch manager or, I don't know, customers is not my concern.
That document will not reflect my name because they have engaged me directly.
That is what officially I have
Engagement,
to
if they engage you directly, Mr. Sinha, what are you saying? There has to be some document on record.
see.
That documents I have
You
shown.
cannot be engaged without a document.
No, my lord, some documents there, that is, my lord, with them. My lord, they have not.
He
My lord,
has
the
connected
documents,
to whom
my lord,
Mr. Sinha, file a civil suit. You can ask for interrogatories and discoveries.
no,
Writ court cannot decide this.
my lord, I am not.
I'll put your arguments and
My lord,
the
your lordship,
petitioner-
kindly consider, my lord, this admit.
I'll consider everything.
My lord, that amount has been admitted and they paid some amount, my lord.
The
obviously what has
said
been
two
done.
writ petitions have been filed by a single petitioner. First of WPA 3967 of 2024 has been filed
My lord, second petition is separate, my lord.
primarily against the respondent bank, alleging that the petitioner acted as a business correspondent stroke recovery agent for the said bank. However, despite the petitioner having functioned in such capacity, upon such appointment, the payment for recovery of NPA accounts has not been paid to the petitioner. Next para, learned counsel relies on a claim raised by the petitioner annexed at page 31 of WPA 3967 of 2024, which fixes the quantum allegedly due from the petitioner at 12, 48, 734 rupees such and such. Next para, learned counsel places reliance on a document dated May 23, 2022, annexed at page 29 of the writ petition, which indicates that a part of the amount was paid directly by the bank to the petitioner. However, subsequently, the bank is trying to take shelter under an agreement entered into by the petitioner with Messrs. Integra, which was an agent which had appointed the petitioner at the behest of the bank, to disown the bank's liability. It is argued that for the purpose of NPA recovery, it was the bank which directly appointed the petitioner and had also disbursed a part of the payment, which itself indicates that the bank cannot disown such liability. Next para, insofar as WPA 5495 of 2024 is concerned, the petitioner claims similar rights. The petitioner was appointed a business correspondent through the respondent stroke Messrs. Integra Microsystems Private Limited, the latter being a corporate business correspondent of the bank. It is argued that the petitioner functioned in terms of the agreement between the petitioner and Messrs. Integra during the period from the year 2021 to 2023, but was not paid the due amount. Next para, it is submitted that further the petitioner's code has been blocked by Messrs. Integra, thereby precluding the petitioner from collecting the due amounts. Next para, learned counsel appearing for Messrs. Integra categorically disowns the liability of the said concern insofar as the alleged dues of the petitioner with regard to the NPA account collections is concerned. It is argued that the petitioner was appointed directly for such purpose and allotted work by the bank, comma, if at all. Full stop. Next para. Insofar as the claim against Mr. Sintigra on the other aspect regarding the PM Jandhan Yojana work done by the petitioner is concerned, comma, it is argued that Mr. Sintigra had already cleared the previous dues of the petitioner. Full stop. However, comma, on repeated occasions, it was found that there were several allegations and complaints lodged against the petitioner on the ground that the petitioner has been abusing the appointment by collecting amounts in an unauthorized manner. Full stop. Next para. As such, comma, the ultimately Mr. Sintigra was compelled to block the account of the petitioner, comma, however, comma, upon giving opportunity of hearing to the petitioner. Full stop. Next para. Learned counsel for the bank denies the liability of the bank for payment on either score and places reliance on the agreement entered into between Messrs. Integra Microsystems and the petitioner. Full stop. Learned counsel for the bank takes the court through a policy on business correspondence of the bank annexed to the affidavit in opposition of the bank, full stop, in clause 2.4.1 thereof, comma, it is argued that all BC agents within bracket in the present case, the petitioner purports to be one, bracket closed, will be appointed under a corporate BC framework and bank will not enter into any agreement separately with any individual BC. Full stop. Next para, in clause 2.4.5 of the same comma, fidelity insurance is contemplated to cover losses caused by dishonest deeds of the BCs. Full stop. Clause 2.4.6 contemplates performance of corporate BCs to be reviewed on quarterly basis through a meeting with heads of corporate BCs, and in case performance is not found satisfactory, comma, their services may be terminated by serving suitable notice by the bank. Full stop. Next para. Learned counsel for the bank also places reliance on a policy for engaging corporate BC stroke BC agents for recovery in NPAs and SMA hyphen Roman II accounts, also annexed at page 31 of the opposition of the bank. Full stop. In terms of clause 5.1 thereof, comma, bank has already executed agreement with CBC for functioning as BC agent. Full stop. Next para. By placing reliance on the said provision, comma, it is argued that invoice is to be raised by CBCs to respective base branches for payment of commission regarding recovery made in accounts of the base branch. Full stop. Next para. Clause 5.2 deals with allocation of accounts. Full stop. Learned counsel, by placing reliance on the said provisions, comma, submits that the bank did not have any direct liability vis-a-vis the petitioner in respect of payment or otherwise, comma, at any point of time. Full stop. Next para. Learned counsel for the bank also places reliance on a document annexed at page 82 of the affidavit in opposition of the bank, which is the relevant list of BCs within bracket business correspondence during the period 2021 to 2023. Full stop. It is argued that the petitioner's name does not find place therein, as such belying the contention of the petitioner that the petitioner had been appointed directly by the bank as an agent for collection of NPA dues. Full stop. Next para. Insofar as the annexure dated May 23, 2022 at page 29 of the writ petition is concerned, comma, the veracity of the same is categorically denied by the respondent bank, and it is submitted that conspicuously, comma, the same does not contain the letterhead of the bank. Full stop. Next para. Upon hearing learned counsel for the parties, comma, certain aspects of the matter come to the fore, FORE. Full stop. Next para, insofar as NPA collection is concerned, comma, the respondent bank has the leeway to directly appoint business correspondents instead of channelizing such appointment through the corporate business correspondents within bracket in the present case Mrs. Integra Microsystem bracket closed. Full stop. Next para. Moreover, comma, the bank holds the ultimate key KUI to the decisions as to appointment and termination of BCs, comma, although the same has to be done through proper channel via the corporate business correspondence. Full stop. Next para. Thus, comma, insofar as NPA collections are concerned, comma, the bank cannot disown its liability altogether as a general matter of principle. Full stop. Next para. However, comma, in the present case, comma, the very document on which the petitioner relies, dated May 23, 2022, has been categorically alleged by the bank to be fictitious and manufactured. Full stop. Next para. That apart, comma, the bank also relies on a list of business correspondence during the relevant period for which the petitioner claims dues, comma, which also prima facie indicates that the petitioner's name is conspicuous by its absence from the said list. Full stop. Next para. Thus, comma, evidence is required to substantiate the contention of the petitioner that there was any actual appointment of the petitioner for collection of NPA accounts during the relevant period, comma, either by the bank or by Messrs. Integra. Full stop. Next para. Moreover, comma, the bank is also to substantiate its allegations that the purported document dated May 23, 2022, produced by the petitioner is fictitious. Full stop. Next para. Insofar as the claim against Messrs. Integra is concerned, comma, the latter categorically denies any further liability, comma, since according to it, the past dues of the petitioner have already been cleared and the amounts claimed by the petitioner and the challenge against Mrs. Integra does not claim any dues but only seeks to cancel the blocking of the petitioner's code by Messrs. Integra. Full stop. However, comma, it transpires that the affidavit in opposition of Messrs. Integra discloses sufficient prima facie material to indicate that upon giving an opportunity of hearing to the petitioner, comma, Messrs. Integra took a decision to terminate her services on the ground of certain misappropriation of funds and certain irregularities in the operation of the petitioner. Full stop. Next para. In the event the petitioner seeks to challenge the same on merits, comma, evidence, hard evidence is required to be adduced, which cannot be appreciated properly within the limited means of this court. Full stop. Several documents have come up on record to indicate that those are required to be formally proved in a regular civil suit and an opportunity be given to the corresponding defendants to dispute the said documents and or cross-examine the witnesses proving such documents. Full stop. Next para. The same being beyond the trappings of a writ court, comma, cannot be decided within the scope of the present writ petitions. Full stop. Accordingly, WPA 3967 of 2024 and WPA 5495 of 2024 are disposed of by granting liberty to the petitioner, comma, in the light of the above observations, comma, to approach a competent civil court making its claims. Full stop. It is made clear that if such suits are filed by the petitioner, comma, the same will be decided in accordance with law without being influenced on merits regarding the allegations and counter allegations of the parties in any manner whatsoever. Full stop. No orders to cause urgent certificate.
My lord, so far the second writ petition is concerned, my lord. Your lordship, kindly, I had no opportunity to, my lord, make my submission. My lord, your lordship, kindly consider, my lord, I have challenged the terminate, not temporary suspension of my lord.
Blocking of your account has been challenged, Mr.
No, my lord, your lordship, kindly consider this. Your lordship, kindly come to page 45. They have issued a letter, my lord, my lord, temporary suspension of my lord, the
Yes.
court. My lord, in terms of the agreement, there is no provision for.
Mr. Asira, go to a civil court. Call on the next one.
Well, there is no provision
Item
for
number five.
suspension.
Yes.
Only they can terminate.
Please, your lord.
I can convert that suspension to termination if you want. Yes.
My lord, suspension, I have
দাও
challenged.
but কল হয়েছে?
My lord, item 5, I appear for the private respondent
Yes.
number 6.
Mr. Bhattacharya, yes, what is the matter?
No, this is challenging, my lord, a proceeding initiated by the by the registrar of Unani Council. My lord, calling upon me to give an explanation. My lord, apropos a complaint, the complaint was never disclosed to me. It has been disclosed by the way of the affidavit in opposition. The complaint was not disclosed at the stage when the notice was served on me. Now, my lord, rightly, wrongly, without raising that point, my lord, I participate, saying
Affidavit in opposition you have filed.
Yes, your lordship, on the last occasion, I filed affidavit in opposition.
Right, yes, I've got it.
that
lord,
my
only
reply is
one
being
thing,
affirmed.
my lord,
It is being affirmed. But
annexure,
my lord, your lordship will proceed with the hearing because I cannot, my lord, seek more time on this. In the
Yes.
reply, I have only raised the point, my lord, that
No,
this.
come with the reply. Mr. Bhattacharya, what is the use of wasting time and then finding some that your reply is not there? Come back tomorrow.
only one thing, my lord, when I filed my affidavit in opposition, I have annexed annexure A. On that annexure A, my lord, one page, my lord, inadvertently, my lord, loosed out. My lord, I have served the other side, my lord, with that copy. May I, my lord, hand over the copy to the
Do it.
court, your lord.
A missing annexure, a missing page of an annexure to the affidavit in opposition filed today be kept on record. Full stop. The time for filing affidavit in reply is extended for a day. Full stop. The matter shall be taken up for hearing under the same hearing tomorrow.
Deeply obliged, your lord.
Next.
Item number 6.
6, my lord, I appear on behalf
Item
of
number
the
6, I
petitioner, my lord.
appear on behalf of the
Yes.
CSC.
Yes, what is the case?
What has happened, my lord?
Well, firstly,
Yesterday
I
only we have
apol-
been
I
supplied
apolo-
with a affidavit in opposition, my lord. I need only I'm seeking only, my lord, a week's time to file the reply, my lord.
It comes under the regular heading now. The affidavit in opposition filed today by CSC Limited be kept on record. Full stop. The time for filing affidavit in reply on the prayer of the petitioners, comma, is extended for a week from date. Full stop. The matter shall next be placed under the regular heading on May 13, 2024. Next.
My lord, may I file the police report?
My lord,
My lord, may I file the?
No. Next.
item number 7.
Yes.
I'm for the petitioner.
Yes.
Last question.
But give your name, please, for the state. Give your name. You're appearing. Give your name. Appearance. Yes, Mr. Kutubuddin, what is
My
that?
last question, lordship, directed to whether my pump is not, but
No inspection held.
The inspection has been held. The pump and everything is in order. Only 5 PCC poles are needed. Quotation has been generated. Let him
If they pay, you will give it.
pay.
What will be a reasonable time for installing the poles? 1 month?
My lord, minimum of 180 days is required.
No, 180 days is for cultivation. So the maximum cannot be given to you. Cultivation is over now.
90 days, my lord.
oh, no.
Learned counsel for the petitioner submits that the petitioner seeks electricity connection to operate his submersible pump. Full stop. Initially, a stand was taken by the WBACDCL that that no submersible pump was found at the relevant location. Full stop. However, comma, after a fresh inspection having been held pursuant to the direction of the court dated April 30, 2024, comma, learned counsel for the WBACDCL submits that the submersible pump has been located and a quotation has been raised, taking into account that 5 electricity poles are required to be installed
The quotation has not been raised.
Quotation has been raised.
for giving the connection to the petitioner.
No,
Full
this
stop.
is not-
Next paragraph, learned counsel for the petitioner submits that no copy of the quotation has been given to him. Full stop. Please give a copy to him right now. Learned as such, comma, learned counsel for the WPACDCL hands over a copy thereof to the learned advocate for the petitioner here and now. Full stop. Next para. Since the WBACDCL is of the opinion that for installing the said poles, some time is required as cultivation is going on, comma, it would only be appropriate if 90 days is given to the WBACDCL for giving such connection to the petitioner. Full stop. Next para. Accordingly, WPA 10316 of 2024 is disposed of by directing the petitioner to comply with the formalities, including the payments to be made by dint of the quotation raised by the WBACDCL within a week from date.
My lord.
Full stop. Upon such formalities being complied with, comma, the WBSEDCL shall give the electricity connection after taking due measures, comma, including the installation of necessary number of electricity poles, comma, to the petitioner within an outer limit of 90 days from the date of compliance of formalities by the petitioner. No less to cause
My
urgency.
lord, not 90 days, not kindly.
90
It
days.
is 15 or 20 days, it will be over.
Next.
New
Get-
motion
get
item
full
number 8.
Yes.
Get-
Services on all the respondents have not been completed, Lordship. I am paying for 1 week time.
My lord, I am mapping for one election commission India, my lord.
Since service has not yet been completed on all the respondents as per submission of learned counsel for the petitioner, and as apart from the Election Commission of India, comma, none of the other respondents are represented through counsel, comma, let the matter be adjourned till till May 20, 2024.
I'm grateful, my
20th
lord.
May. Yes.
Item number 9.
I appear on behalf of
WBS. I am appearing for the petitioner. Service has not been completed.
Service has not been completed as per submission of learned counsel for the petitioner. Let the matter stand adjourned and shall next be listed in the monthly list of June 2024. Next.
Item number 10.
My lord, I am for the respondent number 5.
Item number 10, I am praying for 1 week time on behalf of Mr. Tushar Kandi, or he is seriously ill, my lord. Only 1 week accommodation, my lord.
And a week apostrophe accommodation is sought by the petitioner who submit the matter be placed in the monthly list of June 2024.
Item number 11.
Yes.
My lord, I'm led by Mr. Madhumita Patra, my lord.
Start the matter.
Service is not yet been completed.
Service is not yet complete. Full stop. Let the matter be listed in the monthly list of June.
Grateful.
Item number 12.
Yes, Mr. Dotto, what is the matter?
My lord, I am for this.
Yes.
First round of lead petition, the same petitioner.
Whether
apply-
private respondents were served or not.
Yes, served.
Please check up Mr. Dotto or
Because
ask you.
if your lordship passed any order, that will affect to the private.
Obvious.
respondent.
Yes.
Yes, served. All served. এদিকে নাও একবার।
দেখে নাও।
All solved, one reflects addressee cannot be located,
Out of all of them, one.
only one.
But they are of different addresses.
Yes,
Same locality.
same locality, two adjacent houses.
File.
First writ petition,
Service Tadin.
Fine.
Yes, first is please.
first
First
writ
one is-
petition, writ petitioner comes before this court, gets new connection from on the land of his own occupation, poles are being installed. Second writ petition, the private respondents come up and say that they also want the electricity through the same poles. High Court refuses and says for the last 20 years, a route is being used for electricity connection. Electricity board is to give through that route. Now, these are in 2014. Now in 2024, suddenly one pole is being uprooted by the private respondent and they themselves draw the line through my pole. This is the only allegation.
You have complained before the WBS?
Yes, yes.
What is that?
Page 50A is the typed copy. My lord,
My lord, my instructions is
it's towards
we have
the-
not installed any pole.
Yes.
Only
No,
me.
no, his instruction is also same.
Yes. Only pursuant to the order of this honorable court, we have shifted the meter.
কারণ
No,
মানে
that is different. He's not saying. He's saying that one pole has been uprooted
yes.
and connection taken through his pole. But this is entirely against the private respondent, Mr. Dotto. How does a writ petition lie at all?
My lord,
I'll direct the WBSEDCL to take measures. I mean,
the same
because
pole.
this is tampering with the electricity. This is
Yes.
unauthorized use of electricity.
No, that was not instructions. My instructions also, my instruction is that is false allegations, as I have instructed.
That has not been done.
That's my instruction. That is false allegation.
I'll go by your instruction only. How can I know?
Yes, that's my.
You have to. You cannot disown your own instruction.
Yes.
মিটার বোর্ড কি চেঞ্জ হয়েছে?
No, meter was shifted.
Mr. Dotto, I'll direct you to lodge a complaint with the police authorities. Let them investigate and
Yes, that will
Only
be
one thing,
appropriate.
there is a civil suit pending, status quo order with
Obviously.
regard to a passage before 2014.
Your
what-
suit, your suit.
Yes, my suit.
So you
With
take
regard
out
to a
order
passage.
39 rule 2A, everything.
Yes, my lord, that is there. Only thing is whatever decision they take or the outcome of the police,
Now I'll record their submission that
Well,
they are denying it.
that your lordship grants that let there not be a right created over that suit, whatever be the outcome of
That
their
will be in my observations.
Yes.
That is general observation of your
That
lord.
is-
The petitioner contends that in a previous round of litigation, the petitioner had got electricity connection over certain electricity poles, full stop. The private respondents had come up before this court with a grievance that they also wanted electricity connection through the same poles. Full stop. However, this court held on the previous occasion that since over a long period of time, there is a separate existent route over which the connection could be taken by the private respondents, the private respondents were directed to be given electricity connection over such route. Full stop. Next para. However, it is alleged by the present writ petitioner that in defiance of such arrangement, subsequently the private respondent has uprooted, the private respondents have uprooted one of the electricity poles of the petitioner and taken electricity and shifted their own electricity connection over one of the through one of the poles of the petitioner. Full stop. Next para. It is argued that despite a representation having been made to the WBACTCL, the WBACTCL has not taken any steps on the same. Full stop. Next para. Learned counsel for the WBACTCL on instruction submits that the WBACTCL is not aware of any such act of the private respondents. Full stop. It is categorically stated that the WBACTCL had no role to play even if such act has been done. Full stop. Next para. Be that as it may, since the allegations of the petitioner tantamount to serious allegations of criminal nature of tampering with the equipment of the WBACTCL, the petitioner ought to have liberty to approach to file a police complaint formally in order to initiate inquiry stroke investigation into the matter. Full stop. Next para. That apart, since learned counsel for the petitioner submits that a civil suit is pending at the behest of the petitioner, where the petitioner is enjoying an order of status quo, in any event, it will be open to the petitioner to take due steps for alleged violation of such status quo before the said civil court. Full stop. Next para. Thus, WPA 11773 of 2024 is disposed of by granting leave to the petitioner to approach the local police with the complaint as made in the present writ petition. If such an allegation is made, the police shall make due inquiry into the matter by treating the same to be a criminal complaint, if necessary, involving the WBACTCL in such inquiry as well. Next para. It will be open to the WBACTCL, if subsequently convinced of such allegation, to take their own independent steps under the Electricity Act 2003 in that regard. Full stop. It will also be open to the petitioner to approach the competent civil court where the petitioner's suit is pending for taking appropriate action for violation of the order of the said court. Full stop. Next para. The merits of the allegations and counter allegations have not been gone into, and since no affidavits have been invited, it is deemed that the allegations of the writ petition are not admitted by any of the respondents. Full stop. Affidavit of service be kept on record. No orders to cost.
Only thing is
Grateful.
status quo over the passage. Your lordship has indicated status quo, but status
I'll keep it vague. Status quo.
Grateful.
If you find out subsequently passage and something unnecessary
it is my
corrections.
duty to clarify.
Status quo, I've stated
My lord.
status quo. I have not specified electricity or anything. Yes, next.
Item number 30.
Madam, for the writ petition.
Yes, Mr. Chakravarti. What is the matter? Yes.
The service to the, my lord, this is every service. Follow sir.
All of that, right. What is the matter, Mr. Chatterjee?
My lord, kindly come to page 21. My lord, tender number 18 was my lord, invited by the BDO Raghunathganj to Panchayat Samiti, whereby my lord 16th number of bid were floated. page 21. My lord, there are, my lord, 16. My lord, petitioner participated, my lord, 3 bids. Now, my lord, I am referring, my lord, second bid, number 2, serial number 2. My lord, this bid, my lord, petitioner submitted his bid documents. My lord, thereafter, my lord, kindly come to page 24. The schedule was fixed for page 24 bottom. My lord, submission of bid
Yes.
30th 11th 23. My lord, bid opening date was, my lord, 8 December 2023. My lord, date is vital, my lord. 8 December, on that, my lord, technical date will would be open. And thereafter, my lord, now petitioner kindly come to page 30. My lord, after technical bid, my lord, before opening of, my lord, financial bid, my lord, the video directed the petitioner along with other, my lord, the participants.
You are
on-
qualified in the technical bit.
Yes. Otherwise, I would not have been, my lord, called by them.
Right.
My lord, the video, my lord, directed the all participant, 29 participant, hearing, my lord, 17 number, serial number 17 is the mark construction. My lord, it is the petitioners, my lord, enterprises were directed to be present.
This might be at the technical stage itself.
Itself.
Is there anything to show that you were selected as successful in the technical stage?
My lord, that is the, my lord, dispute. That is the dispute. Either I would have been, my lord, rejected, or, my lord, after, my lord, technical bid, my lord, successful. If I got become successful, they will, my lord, consider my application for, my lord, financial bid. My lord, this is, my lord,
Yes.
this is, my lord, violation. This notice is, my lord, before, my lord, financial opening of financial bid. They cannot direct the my lord, petitioner along with other to undersign to be present for submitting of their documents, my lord. Bid documents.
So there is no violation, there is no discrimination. All have been called. Why can't-
Original, my lord,
What is the difficulty if they
why,
call it?
my lord? Why, my lord? I am referring, my lord. Subsequently, I am referring. Why, my lord? My lord, it appears that on 22nd December, my application was not rejected. It appears. Otherwise, I would not have been called. My lord, kindly come to order of rejection. My lord, page 35. I called for verification on, my lord, 26th December. To be present for 28 December 2023, but, my lord, kindly come to page 38.
Yes.
My lord, 35, my lord, my application for case 35. This is, my lord, tender 18 reference, and, my lord, title is, my lord, serial number 2. Petitioner, my lord, first block, item number 3, my enterprises rejected technical, my lord, on 10th of December.
No, submission date is 10th of December.
Thereafter, my lord, rejected. Yes,
Rejection is there is no date.
my lord, I am referring again. I am referring. My lord, kindly come to. My lord,
I am at page 35. Please look at that page 35 which you are placing.
Yes, yes.
The submission date is mentioned as 10th December, not the rejection date. The
Yes.
heading is submission date,
But they
submitted date.
did not mention the date of, my lord,
No,
rejection.
that is what I told you. There
Yes,
is no
my lord,
mention.
my lord, I am referring the, my lord, finance department circular, page
This was
31.
uploaded subsequently.
Subsequently,
After 26 December.
my lord, there is a gross, my lord, mismanagement and, my lord, fraud conducted by the, my lord, concerned video, and video is asking 11%, my lord, cut money. That is why those who are allowed to, my lord, pay that cut money, they are allowed to. That is why my lord, I made a complaint to the all authorities against that particular video. My lord, my lord,
When did you make the complaints?
Yes. Page 41.
When?
My lord, on, my lord,
I don't find any date here. Nice print, nice spacing, but no date.
I have seen, my lord. My lord, I have seen, my lord. So, my lord, kindly, because, my lord, this is not the, my lord, copy which was sent. This
Cannot
is,
be
my lord,
entertained.
this is a draft,
Mr.
draft
Chatterjee,
copy,
cannot
my
be
lord.
entertained. This is an afterthought.
So, my lord, kindly, no, my lord, kindly allow me to file one supplementary
No.
affidavit, because, my lord, this is the.
You cannot improve upon what you
No, my lord, this is not the original copy. This is not the original copy. My lord, kindly have a look.
No, you cannot be permitted to
My
improve.
lord, 45, page 45.
Page 45.
Not very serious matter, my lord. Kindly, my lord, there's a mistake on
Really
part,
very serious. Very serious.
either my
Page 45. What?
my lord,
This
here
has
is
been
my-
typed. Might have been typed in your chamber. How do I know, Mr.
No,
Chairman?
my lord, this is, my lord, the signature and, my lord, stamp and date has not been given. My lord, in original copy, there is a signature and date, my lord.
Anyway, let us hear Mr. Bosumoli. Yes, Mr.
Well,
The technical bid opening date was 8th of December. Their allegation is on 26th December. How do you call them?
No, Lordship knows, my lord, in every
I don't
tender,
know
no,
anything.
in every tender, my lord, if
Yes.
anything, they find that's something which has
No,
been.
Mr. Bosumoli, my not general question. My question is very specific.
Lordship.
As per page 24,
My lord.
technical bid opening date is 8th of December 2023.
My lord.
Page 30 says on 26th of December 2023, which is after much after that date,
Yes.
you call everybody, including him.
Yes.
So, I mean, so you say that it was rejected subsequently.
Lordship. That they rejected subsequently, not only that, my lord, all the tenderers, my lord, successful tenderers already issued work order. They have already, work has been
That
started.
can be upset.
Now, no, my lord, now, my lord, the fact is, my lord, he has made an allegation that 11% cut money and all these things, my
Can
lord.
it be reduced a bit?
I don't, no, not the question. Now the
That
fact,
is also, we can
No,
modify the prayer.
no, well, the fact is something else. He went to the office of the BDO, threat him for dire consequences, for which, my lord, FIR was lodged against him. He has been arrested. Subsequently, my lord, police has been filed charge sheet. I have all the details. All the details I have, my
Mr.
lord.
Chatterjee, no interference.
I have stated everything, my lord.
My lord,
My lord, kindly
I have
come
all
to
the
page
details.
31. Page 31.
No, no, I'm not going by their complaint. That might have been a backlash to your allegation.
Maybe,
I'm
maybe.
not going by that,
My lord,
but
I have
I don't find any
suppressed. I
irregularity.
have stated that due to protest, my lord, PDO
No,
lodged a
Mr.
complaint.
Chatterjee, no interference. Such.
My lord,
The petitioner participated
page
in a bid.
31, my lord, financial,
The petitioner participated in a composite tender process which contemplated several works. Full stop. The allegation is that the technical bid opening date was December 8, 2023. Full stop. Subsequently, on December 26, 2023, all the bidders, including the petitioner, were called upon to produce certain documents for verification of hard copies thereof. Full stop. Next para, it is submitted that the same indicates that the petitioner's bid had not been rejected till then. Full stop. It is also argued that the issuance of the said communication was dehors the terms of the tender document. Full stop. Next para. Subsequently, however, the petitioner learnt that the petitioner's bid had been, with some other bidders, rejected. Full stop. The said tender summary report was uploaded on April 13, 2024. Full stop. Learned Counsel disputes the veracity of such rejection, by citing the fact that even as on December 26, 2023, which is about 18 days after the technical bid opening date, letters were being communicated to all the bidders, including the petitioner. Full stop. Next para. On a more serious level, the petitioner alleges that 11% cut money was asked for by the BDO, who was in charge of the operations for the tender process, which not being given, a backlash occurred by filing of complaints against the petitioner, for which the petitioner had to be arrested even. Push up, it is argued that due to such malafidez, the petitioner's bid has been rejected. Push up. Next para, Learned Counsel for the respondents controverts such allegations and submits that the petitioner was never declared successful in the technical stage itself. Push up. Next para, in order to ascertain certain shortfalls in the tender, in the bids, all the tenders were universally called upon by the communication dated December 26, 2023. Full stop. It is denied that any cut money was claimed from the petitioner, semicolon, rather, the petitioner created a scene in the office of the BDO upon being rejected, for which complaint had to be lodged, which resulted in the apprehension of the petitioner by the police. Full stop. Next para. Upon hearing Learned Counsel for the parties, it is evident that as per the tender document, December 8, 2023 was fixed as the technical bid opening date. Full stop. However, the date for original verification, technical evaluation and opening of financial proposal within bracket online bracket closed was to be notified later as per the schedule of the tender as annexed at page 24 of the writ petition. Full stop. Therefore, when the petitioner along with all the other bidders were called on December 26, 2023, it is evident that the petitioner had not been declared to be successful at the even at the technical stage till that point of time, since otherwise, all the bidders would not have been called. Full stop. Next para. Evidently also, the attempt of the tender issuing inviting authorities in the letter dated December 26, 2023 was to further verify the documents produced by the bidders, which was obviously a part of the original verification and technical evaluation contemplated in item 7 of the schedule of the tender, the dates of which were to be notified later. Full stop. Next para. As per the tender summary report annexed at page 35 of the writ petition, the rejection of the petitioner's bid was uploaded on January 5, 2024 at 4:17 p.m. Full stop. Next para. Thus, I do not find any irregularity in the chronology and timelines of the said events to palpably vitiate the tender process on such count alone. Full stop. Next para. Insofar as the petitioner's purported representation to the respondents is concerned, the annexure at page 41 of the writ petition, which claims to be such representation, is undated. Full stop. Thus, it cannot be ascertained as to what document was posted to the respondent authorities, regarding which postal status has been annexed at page 49 of the writ petition. Full stop. Next para. Thus, the petitioner has failed to prove beyond doubt that any cut money was claimed from the petitioner or that there was any irregularity in the tender process. Full stop. Next para. As such, there is no scope of interference in the writ petition. Accordingly, WPA 11778 of 2024 is dismissed on contest without any order as to cost. Sorry.
Grateful, Lordship.
Next.
Item number 14.
My application.
Yes, Savanaji.
In this matter, Mr. Kamal Kumar Chattopadhyay appearing for FCI has not been able to come to court because of some personal medical reason. If this can be kept.
You are there, you move.
I just got the copy of the brief now. I don't know what the matter is.
Let him come prepared tomorrow. File the affidavit service. Affidavit of service file today be kept on record. Full stop. An adjournment is sought on the ground of illness of learned counsel appearing for which respondent?
Respondent number FCI, food by respondent number 1.
Of respondent number 1, the Food Corporation of India. Full stop. Accordingly, let the matter stand adjourned for the day and shall be listed tomorrow under the same
It
heading.
will be on the 9th, my lord. Because Mr. Chattopadhyay just told me that.
Very listed on May 9, 2024.
My lord, could I just pray for only one thing? In the meantime, when they take instructions, they'll find out if they have an estate officer. That's all that the writ is about.
I'll take instruction.
That is all the writ is about.
Grateful.
Item number 15.
I am for the petition.
Yes.
We have the WBS.
My lord, this quotation has been issued in the year 2018, my lord. I have deposited for January 2019. Till date, my lord, I have intimated all have been complied.
The intimation has been done on 30th of April 2024. Subsequent to that, on 2nd of May, we have done an inspection. And according to regulation 46 clause 4.2d.
No, he says that the quotation was raised in 2019.
Subsequent to that, the electrical wiring, meter board, and the installation and submersible pump was not done. It was done through an intimation on 30th April 2024.
That intimation was by them.
Yes.
30th April 24.
Yes. And subsequent to that,
You won't get 180 days now. Cultivation season is over.
90 days. Madam, kindly have a look at regulation 46 clause 4.2d. For
So this augmentation is necessary.
Hello?
time limits for new connection where augmentation of the distribution line and or extension of feeder line will be required. That is necessary
Yes,
here.
my lord. Here, my lord, we need, my lord, 3 number of PCC pole and approximately there is around 120 meters, my lord. For, my lord, kindly consider clause D.
Yes, I've seen D.
My lord, that 90 days is required, my lord, we'll give, my lord, subject to, my lord.
What is the notification number?
46, regulation 46.
Learned counsel for the petitioner argues that the application for electricity connection to operate a submersible pump of the petitioner was made in the year 2018 and a quotation was raised in 2019. Push up, even after compliance of formalities, comma, the connection was not given by the respondents. Push up next para, learned counsel for the WBACDCL controverts the timelines and submits that an intimation was given by the petitioner only on April 30, 2024 regarding all installations including the submersible pump for which the connection was sought, comma, having been done. Full stop next para. Thus, comma, it is not the fault of the WBACDCL that the matter was delayed so much. Full stop. In any event, comma, due quotation has been raised by the WBACDCL and a period of 90 days is required as an outer limit by the WBACDCL to give the connection to the petitioner. Full stop. Next para. Learned counsel for the WBACDCL places reliance on clause 4.2 capital D of regulation number 46 of the WBERC, which speaks about the time limits for new connection where augmentation of the distributing main and stroke or extension of feeder stroke line stroke cable will be required. It is submitted that in the present case, comma, several PCC poles and other installations are required to give the connection to the petitioner. Accordingly, WPA 12596 of 2024 is disposed of by directing the WBACDCL, comma, subject to compliance of all formalities by the petitioner, comma, to give electricity connection to the petitioner within 90 days from the date of compliance of such formalities positively. Full stop. No orders to cause urgency report.
Every service kept on it.
I'm grateful.
Every service file today be kept. এটা ফেরত দিয়ে দিতে হবে।
No, no, দিয়েছি।
এখন
Item number 16.
My lord, I am for the petition. My lord.
Yes.
This is also new quotation as well as issued.
But if you like to see the instruction, my lord, what happened, my lord, we are ready to provide the connection, but we need, my lord, 5 poles has to be installed. But due to, my lord, agricultural season going on, my lord, no, my lord, we cannot, my lord, install, my lord. But we will do that, my lord. Kindly 180 days is the time limit, my lord. Kindly give us some time, my lord. But kindly see the instruction, my lord.
Learned counsel for the petitioner submits that the petitioner applied for electricity connection to operate a submersible pump which has not been given by the WBACDCL. Full stop. Learned counsel for the WBACDCL hands over a written instruction and submits that as per the governing regulations, comma, the outer limit for giving connection is 180 days in case there is adjoining cultivable land and cultivation is going on. Full stop. Hence, comma, the respondents submit that for the purpose of giving electricity connection, several electricity poles are to be installed, which would require some time due to the ongoing cultivation. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that in any event, comma, as per clause 4.2 of regulation 46 of the WBERC, comma, in case augmentation of the distribution main or extension of feeder stroke line stroke cable is required, comma, the distribution licensee gets a period of 90 days to give the connection. Full stop. Since the cultivation season is midway and 180 days would not be required for giving the connection, comma, it would only be appropriate if the statutory period of 90 days for installation of the poles, etc., are given to the WBACDCL. Full stop. Accordingly, WPA 12601 of 2024 is disposed of by directing the WBACDCL to give electricity connection to the petitioner by undertaking all installations as required for such purpose within 90 days from the date of compliance of all formalities by the petitioner positively. No arrest to cause certain certified
But
copies.
only one thing at the time of installation.
Yes.
But only one thing at the time of installation, my lord, if we register, my lord, then we will take the recourse of 3.1 my lord before the district magistrate, because the pole has to be installed but in the other land.
Needless to say, comma, if any resistance is faced at the time of giving such connection, comma, it will be open to the WBSCD cell to take recourse to Rule 3 of the Works of Licenses Rules 2006 by approaching the concerned district magistrate for appropriate permission in that regard. Therefore, no address to consent.
I'm good.
Next.
Sir,
Number 17.
স্যার আমি একটা কথা বলতে চাই।
এরম ভাবে করা যায় না। Call on the next matter.
Item number 17.
May I please, your lordship, my lord, this is my application, my lord. My lord, I have served, my lord, I have served of the learned government pleader, as well as I sent the other respondent. This is some urgency is there, my lord.
Sent, but if the other respondents have not received, then how can you?
Yes, but my lord, some rule 27, I prayed for rule 27.
When did you send?
To on second, my lord. Second this month, my lord.
Very well. What is the matter? You are appearing for the state.
For the state.
Yes. What is it?
My lord, the petitioner approached before the bank, my lord, Punjab National Bank, for credit subsidy loan, my lord. The bank directed to deposit 90 lakhs, my lord. The petitioner deposited 19 lakhs to the banks, my lord. 19 lakh, 19 lakhs, my lord. 18 lakhs, 84,000,
Right.
my lord. My lord, thereafter, my lord, the loan was sanctioned. It is the duty of the bank to deliver the agro machineries. We have installed a custom hiring project, my lord. As such, the agro machineries are necessary to continue the custom hiring, my lord, custom hiring project, my lord. The bank, my lord, forwarded the same of their own, my lord, dealer, the respondent number 5, Bhagirathi Agro, to supply the same, my lord. But without supplying the same, my lord, since 2021, my lord, the petitioner has been suffering, my lord. By that time, my lord, the bank issued a notice under the Surface Act, my lord, that is page 50, my lord, to deposit all the amount without giving me the cash, without giving me the machineries, my lord. The person has been suffering immense trouble, my lord.
You have to approach the tribunal under section 17. I'll give you that liberty.
Yes, my lord.
Affidavit of service
My
filed.
lord, my humble prayer, my lord, within 45 days, my lord, the bank will take position, my lord. In the meantime, my lord,
You approach tomorrow. Get an order from the surface from the tribunal. Move your interim application. Affidavit of service filed to be kept on record. Full stop. Learned counsel for the petitioner submits that the petitioners are agriculturists. Full stop. They approached the respondent bank allegedly for credit facilities and deposited an amount to the tune of more than 18 lakhs. Full stop. However, comma, although the bank was to provide agro machineries for the custom hiring project of the petitioners, comma, the bank sent its own representative, the Bhagirathi Agro
mission.
Full stop. Next para. However, comma, subsequently, the bank did not perform its duties through the said agent or otherwise, but a surfacey proceeding was initiated against the petitioner. Full stop. Next para. It is submitted that without providing the credit facility to the petitioners, comma, the surfacey action itself is bad in law and without jurisdiction. Full stop. Next para. It is seen from the affidavit of service that although the state is represented, comma, the other respondents have not yet been served. Full stop. Next para. Be that as it may, comma, the petitioners have an equally, comma, if not more, efficacious alternative remedy in the form of an application under section 17 of the Surface Act 2002 before the concerned tribunal. Full stop. The said remedy would be more efficacious than the writ petition in view of the tribunal having the liberty to enter into disputed questions of fact and look into documents and other materials, comma, if so necessary, to ascertain the contention between the parties. Full stop. Hence, comma, WPA 12710 of 2024 is disposed of by granting liberty to the petitioners to approach the concerned debts recovery tribunal with a challenge under section 17 of the Service Act on the issues as raised in the present writ petition and or other issues if raised by the petitioners over and above the same. Full stop. It is made clear that the merits of the contentions of the parties have not been gone into by the petitioner by this court, and it will be open to the tribunal to decide all questions in accordance with law in due process. Full stop, no address to cause sudden second.
My lord, only
Only record as state.
And in the first line, I've stated, although you are representing.
my lord, may I pray for 7 days the status quo, my lord?
No.
Only 7 days, my lord. My lord, kindly.
No.
Wait.
Item number 19.
Yes. আচ্ছা উনি কি আপনি এগিয়ে আসুন হ্যাঁ কি বলছেন বলুন 1 মিনিট প্লিজ
স্যার আমি গ্রামীণ চিকিৎসক আমি পেশেন্টদের যখন দেখেছি স্যার কনসেন্ট নিয়ে দেখেছি কিন্তু স্যার আমি যখন পেটের ফটো তুলেছি স্যার তখন আর আমি
এখন কি হয়েছে
কনসেন্ট নেইনি স্যার তখন আর এক্সট্রা করে পেটের ফটো
এখন কি আমার কাছে কি চাইছে
এখন স্যার আমার নামে পুলিশ ওখানে আমার নামে সিআর কেস হয়েছিল স্যার ওখানে শ্রীরামপুর কোর্টে স্যার আমি নাকি শ্লীলতাহানি
আপনি
করেছি
কি রিলিফ চাইছেন
আমি রিলিফ চাচ্ছি আমাকে রেডিও ফ্রিকোয়েন্সি ওয়েভলেন্থ দিয়ে আমাকে রেখে দেয় বাড়িতে স্যার স্যার জানেন মাথা ব্যথা হ্যাং হয়ে যায় হার্ট রেট বেড়ে যায়
আপনাকে তো একটা অ্যাপ্লিকেশন ফাইল করে কোর্টে নজর আনতে হবে সেটা অ্যাপ্লিকেশন না
স্যার,
ফাইল করে
আরেকটা জিনিস আপনাকে বলছি স্যার আমি সাধারণ মানুষ আমি কি করে বুঝবো পুলিশটা কবে কোর্টে এসে কেস ফাইল করবে আর পাড়ার লোক আমার পেছনে লেগে
আপনি একটা ছোট রিট পিটিশন ফাইল করুন দুপাতার একজন কোন অ্যাডভোকেট বাবুদের কারো সাহায্য নিন নিয়ে একটা ছোট রিট পিটিশন ফাইল করে এখানে ফাইল করলে এখন কারেন্ট ম্যাটার উপরে উঠছে আপনি ফাইল করুন তা নাহলে এইভাবে তো আমি শুনতে পারবো না
স্যার,
আমরা তো ঠিক মানে ওরকম ভাবে নিতে পারি না ডাইরেক্টলি আমাদের সেই এখতিয়ার নেই
বাবা নেই আর আমার মা অসুস্থ মা ব্রেন টিউমার
মাকে আনার দরকার ছিল না তার জন্য আপনার কথা আমি বিশ্বাস করতাম কিন্তু আপনাকে একটা ফর্মাল অ্যাপ্লিকেশন রিট পিটিশন কোন উকিলবাবুর সাহায্য নিয়ে ফাইল করুন সেইটা যখন কোর্টে আসবে তখন আমি শুনতে পারবো
স্যার আরেকটা কথা
আর
আপনাকে
কিছু না এখন রিট পিটিশন ফাইল করুন তখন আমি শুনবো
একটা কথা শুনুন স্যার আর আমি কিছু বলবো না আর স্যার এই যে পুলিশটা যেদিনকে আসবে এখানে কেস তুলতে সেটা পাড়ার লোকই আমাকে আমার সামনে দিয়ে বাড়ির সামনে দিয়ে বলে যেত স্যার সেগুলি শুনেই আমি ফোনের
আমি কিছুই শুনতে পারবো না যতক্ষণ না এটা রিট পিটিশন ফর্মে আসে
মধ্যে
হ্যাঁ
ফোন হ্যাক হতো স্যার ফোনের মধ্যে আমি সেটা জেনে আমি ফোনের মধ্যে লিখে দিতাম এই ডেটে পুলিশ যাচ্ছে
আপনি সব অ্যানেক্স করে একটা রিট পিটিশন ফাইল করুন
ঠিক আছে স্যার
ওটা এলে আমার কাছে তখনই আমি শুনতে
স্যার
পাবো
আমি তো বেশি টাকা খরচা করতে পারবো না স্যার
কম টাকার উকিলবাবু দেখুন বা লিগাল এডে অ্যাপ্রোচ করুন লিগাল এডে আপনাকে লয়ার দেবে
সেটা কিভাবে করব
এখানে খোঁজ নিন উকিলবাবুদের কাছে বাইরে আপনাকে জানিয়ে দেবে লিগাল এডে অফিস আছে এখানে আপনি বাইরে পুলিশকে জিজ্ঞেস করলে ওরা দেখিয়ে দেবে ঠিক আছে নেক্সট ইয়েস
my lord.
প্লিজ দিস ইজ আইটেম নাম্বার 19
Yes, my lord, I am for the petitioner. This
What is the matter, please?
service, my lord. My
all have been served
petition-
all served yes
He is appearing.
please move your matter
My lord, petitioner is the one owner of the property, my lord. Suddenly, my lord, honor decided, my lord.
yes
Two poles, my lord, 33.
Mr. Ghosh, can you please use the microphone can you take the
Ah,
microphone a bit closer mic
Yes.
yes
My lord, two poles, my lord, electricity is placed, my lord, 33 voltage, my lord. I'm drawing the words, my lord. As a result, my lord, petitioner is affecting and he is faced, my lord, so many problem, my lord.
no 2 poles have been installed on your property to give electricity to others
No, my lord, just, my lord, my house, my lord.
you are not enjoying electricity from that
No, I am not 33 voltage, my lord. This 33,000 voltage, my lord. So I made my complaint to the petitioner, to the respondent authority, page, my lord, 14, my lord. This is my problem, my lord.
I can relegate you to subject to what your learned friend says. I can relegate you to the district magistrate for adjudication of the dispute. Yes, what do you say, Mr. Rai?
I am,
Let us hear them.
He said that it is a 33,000 kV, then it will be transmission line. Therefore, my lord, let the regional manager, he made a representation to the regional manager.
Oh, he has made it.
Yes, yes.
I'll direct that to be decided within a limited period.
yes. That
Very.
is-
If it is 33, then it will be a transmission line. It is not the distribution line.
No, no, it is not distribution.
Yes, then the WBSCTCL is not a then the WBSCTCL will be a party. Distribution company, that will be transmission company.
I have been instructed that he has not located the which pole he has asked for.
Well, I'll direct the
my
the regional manager to decide it.
In
Well,
presence
you
of the
want-
petitioner.
Petitioners.
Learned counsel for the petition alleges that electricity pole carrying about 33,000 voltage has been taken near the petitioner's house, thereby causing extreme risk to the petitioner and his family. First up, next para, a representation was given to the concerned regional manager as well as the district engineer, but to no effect. First up, next para, learned counsel appearing for the WBSCTCL submits that if it is if the line is of the voltage as alleged, comma, in all probability it would be a transmission line and not a distribution line. Push up be that as it may, comma, since a complaint has already been lodged to the regional manager
On 31st August 2000.
regional manager won't be able to
Divisional.
the regional manager of the WBACDCL, comma, it would only be appropriate if the respondents who should look into it, regional manager, I'll direct them. I'll
Engineer, actually, he should be
very well,
divisional engineer.
very well. The regional manager stroke divisional engineer, comma, ought to look into the matter immediately. Push up next para. Accordingly, WPA 24907 of 2023 is disposed of by directing respond number 3, the regional manager, regional office, Purbo Medinipur WBACDCL, to immediately look into the complaint of the petitioner as depicted in the representation annexed to the writ petition at page 14 thereof, comma, personally or through the concerned district engineer. Such exercise shall be such complaint shall be disposed of upon giving an opportunity of hearing to the petitioner and all concerned, comma, as expeditiously as possible, comma, positively within 6 weeks from date. Full stop. No address to cause certain certificate copies. Mr. Rai, from this date, 6 weeks from this date. Mr. Ghosh, please ensure that this is communicated individually also. Mr. Rai will communicate, you also communicate direct with a copy of the writ petition because the representation is annexed here. Next.
Item number 20.
Item number 2021, my lord. I am for
Comment.
the petitioners.
Both matter, my lord, the admission that surface applications are pending. That's all.
Surface is pending.
My
They are,
lord,
Yes.
my
Yes.
lord, I am for the petitioners, my lord. I am praying for accommodation under unavoidable circumstances. I
What
am
is-
out of station for my mother's treatment, my lord. So kindly give adjournment for 2 weeks, my lord. Only 2 weeks.
Mr. Mondal, since the surface action is pending, why should it entertain the matter at all?
Yes, surface. In spite of the pending of the two surface application in respect of the two writ petition, my lord, it is the issue on the two issues, my lord, whether the order of the district magistrate was communicated. We first issue or second issue within 16 days,
Mr. Mondal,
60 days.
on his mother's ground, an adjournment is sought due to personal reasons by learned counsel for the petitioner. Push up accordingly, let the matter stand adjourned and be listed in the monthly list of June 2024.
I'm deeply obliged.
Thank you.
Deeply obliged.
Item number 22.
None appears for the parties at the time of call. Let the matter be listed in the monthly list of June 2024.
Item number 23.
Let's see, I am for the petitioner. Senior counsel Mr. Shantiranjan Das is in virtual mode. I filed an affidavit.
All have been served.
Yes.
I have checked up, all have been served.
Not all have been, my lord, the bank has been served, the bank branch has been served, and the government pleader has been served.
Acha, what is the matter?
My lord, the petitioner is a PT card driver. He has a fixed deposited through his wife's council price, 1 lakh. And he has a account, private account, savings account in the Punjab National Bank State University branch, Barasat, my lord. But only 600. He there is a allegation against him. The 600 rupees for, but 600 on that day. On that day, 600 has been a transaction made by the vehicles owners. He has gone with a vehicle owner and day fees, and therefore you lordship kindly turn to the page 26, then page last page 33. I have sent the representation to the bank manager. Have you lordship?
What will the bank manager do, because they are acting at the behest of the police?
Yes,
Should-
my lord. There is no basis of allegation, and he is surprised to receive this letter dated, Your Lordship, kindly turn to the page 26. Allegation only 6,600. He has, have Your Lordship got the page?
Page
Then
yes.
Your Lordship come to the bank documents. 600 has been
600.
600, only 600. My lord, Your Lordship, page to the turn to the page 22, 24. Dated, transaction dated 29 April 2023, only 600. His day fees of vehicle, as a vehicle driver, by the respondent number 10. Transaction has been done.
You are a vehicle driver.
Yes, my lord. Earlier, before Corona, he was the driver on monthly basis. Then after, in the Honorable High Court at Calcutta, of one advocate, and then Your Lordship, after vacation, he has done the work day basis when he get the vehicle. So he's a PT driver, my lord. Your Lordship, see the annexure, page 28, transaction receipt.
What you are a driver with a private person or some organization?
A private person.
What is the salary? What do we get the monthly salary?
Monthly, earlier he was the before Corona, he was the driver of the one of the advocate as a monthly basis. After Corona, he has done the work on day basis when he get the vehicle. Then he brought the respondent number 10 on that day, and 600 rupees as a day fees for vehicle, for driving of his vehicle. Your Lordship, say come to the page 28. And then Your Lordship come to the page, last page 33. I have made the party to the vehicle owner, Dipannita Sarkar. Have Your Lordship got it?
Rupee for fraud, his account has been frozen.
Lordship, this is the intimation that we have obtained from the
Who is
state.
appealing
Your
for the
Lordship.
state?
The state has to answer. My lord, because the letter at page number 26, my lord, clearly shows that we have worked only as per the instructions of the state. The police authority has given us instructions, my lord, and we have complied with that.
My lord, there is absurd.
Affidavit of service filed today be kept on record. Full stop. The facts of the case are peculiar. Full stop. The petitioner is a car driver acting for individual owners of cars, of vehicles. Full stop. Next para. Despite the petitioner's paltry income, comma, the petitioner managed to open a fixed deposit with the respondent bank and also have an account with the bank. Full stop. However, comma, all on a sudden, an intimation was given to the petitioner indicating that on the allegation of a fraud of an amount of rupees 600 only, comma, the account and the fixed deposit of the petitioner has been frozen by the bank. Full stop. Next para. Despite service, none appears for the state. Learned counsel for the bank submits that the bank, comma, under the banking norms, comma, has no other option but to comply with the request of the police authorities. Full stop. Next para. Although the bank's stand is justified, comma, the action on the part of the investigating authorities is not. Full stop. From the annexure at page 26 of the writ petition, comma, it is clear that even from the intimation made by the cyber crime department of the
Bidhannagar Police.
This, my lord.
commissionerate, comma, the quantum of fraud was rupees 600 only. Full stop. For such paltry amount, comma, the freezing of the petitioner's fixed deposit and account in its entirety, comma, which was obviously a knee-jerk, KNEE-jerk, knee-jerk reaction of the police, comma, was grossly disproportionate. Full stop. Next para. Since the state chooses to remain unrepresented, comma, the matter is taken up for hearing in the absence of the state. WPA 25071 of 2023 is allowed, comma, thereby setting aside the freezing of the account of the petitioner and the fixed deposit of the petitioner in terms of prayers A and B of the writ petition. Full stop. The respondent bank shall now permit the petitioner to operate the said bank account and the fixed deposit respectively. Full stop. However, comma, it is made clear that any allegation that might be subsisting under the criminal laws of the country against the petitioner have not been commented or touched by this order, and it will be open to the investigating authorities to proceed with their investigation in due course and take necessary action as contemplated under the law regarding such investigation otherwise. No orders to cause.
My lord, just one thing, my lord. Item number 20 and 21. Both I am appearing.
21 এ কি করেছি? 2021 have passed same order.
My lord, grateful. Much
I'll
grateful,
come
my lord.
this matter after 5-6 minutes.
Item number 24.
Well, pay for leave to file my affidavit of service.
Yes.
Well, here in this case, my lord, when the order of the Ombudsman of November 12, 2020, my lord, was violated by the, my lord, bill was raised in not compliance with the order Ombudsman, I moved the writ petition before my lord. Page 55.
The IPR for WBACTCL, Mr. Lord, not WBERC. It's
Not?
not WBERC Commission. His grievance apparently appears against my lord.
Let us see. Yes.
My lord,
Page
my lord's
55.
order from the beginning, my lord.
Ombudsman was directed to give an
Yes.
opportunity of hearing and decide. Yes.
Hearing. Well, thereafter, my lord, I approached before the my lord Ombudsman, which application page 58 onwards, annexed P10. My lord, thereafter, page 70. Order passed by lord by the my lord Ombudsman, where my lord, everything has been dealt with. But my lord, here in this case, Ombudsman passed an order. My order in position, my lord, page 70 last. The forum passed final order 12/11/2020. The petition approached before the Honorable High Court, Calcutta, for non-compliance with the order of the Ombudsman. So the order of the forum remains unchallenged. In this connection, it is noted, if the order of Ombudsman is not strictly complied with, as alleged by the petitioner has a liberty to file application under section 142 of the Electricity Act. Accordingly, the forum find no necessary to enter into the on the point of the such compliance. So the petition filed by the petitioner is rejected. Inform both the parties. Here in this case, Malad, since 142, Malad Commission is the authority. Malad, I under section 142, Malad made application before the commission, Regulatory Commission, which Malad start from page 73. Application received on 25 May 2023. Malad, what is happened, Malad, here? Malad, that Malad commission, Malad, without application of mind, in violation of principal nature, without hearing. A letter has been communicated, page 85, which allegation in the from the year 2020, 21. That report, my lords, has been annexed, page 86. 86 onward. But here in this case, my lord, second paragraph, reply non-compliance of order on 10/12/2000.
Page 80?
Page 86.
86, yes. Second paragraph.
Second paragraph. My lord, here, in compliance of the order dated 10/9/2020, licensee accepted 40,000 as ad hoc payment paid by the petitioner on 22nd of September 2020. The subsequently replacement of old meter such and such on 3/1/2021 by new meter number such and such. Licensee shall regularly bill the disputed period as per actual consumption recorded in the new installed meter for the period of 1 year without claiming LPSC. No disconnection took place. It is not the issue, was not issue. No disconnection took place on 10/12/2020 as claimed by the petitioner against the concerned service connection as per available record of the licensee. Next one, the inspection was done on 4/3/2021 at the premises of the petitioner by the licensee. Standing green crops were found all over the field of the petitioner. Photographs taken during the field visited and enclosed.
Give another notice to the commission.
Here in this case, what is the 2021 complaint?
What is the compliance you want? Because this is for compliance, for non-compliance.
I made for compliance of the order.
What is the non-compliance you are alleging?
Alleging, but
what are you alleging? What is the non-compliance by them?
Ombudsman passed an order with a request upon the licensing company to bill according to without that disconnection period. But here in this case, the report which has been annexed, which has been
No. What is your allegation? What is the non-compliance?
Non-compliance been here. Here.
Show me the ombudsman order, the first order.
This is start from page 29 onwards. Page 31. Here, the service connection of the petitioner, paragraph Roman 3.
Page 49 was the culmination of that.
No, that order, that final order, page 29. 12/11/2020. Draft order on 10/12/2019.
Yes.
Page 29. And next date of final order, 12/11/2020. Here, my lord, it is recorded that line was disconnected, but here in this case also the pass the order,
Page 36 is the ordering portion.
36%.
No, not page 36.
But it is recorded page 35, paragraph 19, and my lord, page 36. Though the case was scheduled to be finalized on that day, that due to some development in this case.
Let us come to page 38 directly, Mr. Dey. Page 38 is the ordering portion. They were to, all bills were cancelled, directed to regenerate. Have they done this? Regeneration has not happened.
No, because that period which was disconnected, that period also calculated. For that reason, I moved the writ petition. And my lord, here, my lord, the commission passed the order without application of mine.
Now, then what is that page,
Without hearing.
page 49, 51? What is that? That is a different order. Page 49? Or the same order, certified
Yes,
copy?
yes. My lord,
Same.
No, that order is different. At the initial stage, the ombudsman passed an order directing the petition to pay the 40%, then line should be restored. Line restored. But at that very point, the line disconnected. So, my lord, I mailed grievance before the commission. And that grievance application, my lord, I'm coming that, my lord. My lord, page 40.
This was prior to the order at page.
Yes. That is earlier. According to draft order, 40,000 are paid.
So you say they have not generated the bills, regenerated the bills, which is the grievance. So now let me see what order I passed. Let us come back there. That is page 55. Yes.
55. Go to the
As ombudsman was directed to, yes.
Yes. Ombudsman said, since under section 142, I am not authority, but High Court directed, so matter maybe, my lord, made application by the petitioner under
Ombudsman order you are not challenging. You are challenging the order of the commission.
Commission. That commission without hearing.
Show me your application before the commission.
Yes.
Complaint petition under 142. Page 86. 86 is your complaint.
No.
Where is your complaint?
Complaint start from, my lord, page 73. 73, my lord, acceptance of the application, the receipt.
No, non-regeneration of bill, where do you say that?
Page 74.
Yes.
Well, page 82 of the prayer. To declare that the regenerated bill dated 10/5/2022 are bad and illegal in the law and set aside the same. To pass an order that the licensing shall raise charge 00 unit bill amounting in regenerated bill during that period from the month of January 2019 to 2022, when there is no supply of the power due to torn or overhead line as per norms of Electricity Act 2003 rules of the regulation. To pass an order regeneration of the disputed bill and outstanding bill or the bill from the month of January 2019 to the date of replacement of defective meter, that is on 16/10/2020, as per average consumption of new meter for the period of succeeding 1 year, that is 17/10/2020.
Now let us come back to the ombudsman order. Sorry, the commission order.
Commission order. This is not the order, only communication of the report.
85. This is something else. Where is the commission's order?
Yes, page 85.
85 is. Acha, 85 is.
This is not order, only later communication.
You have not got any copy of the order?
No order has been passed. Only communication, the report of 2021, which was submitted before the regulatory commission, when against my complaint that during that period, even after payment of 40,000, line was disconnected. Earlier application 2021, that has been communicated. No order has been passed.
Commission has been served.
Yes.
Despite service none appears for the WBERC. Mr. Nayak, I'll direct the remand the matter to the commission. It has to be decided.
And to hear all parties also.
Yes, definitely. Learned, despite service none appears for the West Bengal Electricity Regulatory Commission. Affidavit of service filed to be kept on record. Full stop. The petitioner's grievance is that the petitioner's order, the petitioner had approached up to the ombudsman for with its grievances, which culminated in the ombudsman setting aside the bills raised by the WBSEDCL for the relevant period and directing regeneration of such bills and restoration of electricity connection upon payment of a composite amount of rupees 40,000. Push up next para. The matter came up before this court and was relegated to the ombudsman. Push up the latter held that since the grievance of the petitioner was non-compliance of the order of its order, the remedy of the petitioner lay under section 142 of the Electricity Act 2003. Full stop. Next para. Accordingly, the petitioner filed an application under section 142, which is annexed to the writ petition. Full stop. In the said application, the petitioner sought, inter alia, that the regenerated bill dated May 10, 2022 be set aside, since it included the previous outstanding dues which were set aside by the ombudsman. Push up. The petitioner sought a further regeneration of the bill during the relevant period from the month of January 2019 to October 16, 2020, and for consequential orders, including penalty to be imposed on the WBSEDCL. Push up next para. However, the ombudsman by its the Electricity Regulatory Commission by its communication dated June 8, 2023 merely intimated the petitioner that the compliance report submitted by the WBSEDCL on March 5, 2021 was being forwarded to the petitioner, which was supposed to be self-explanatory. Pushed up. Apart from forwarding such compliance report, however, no order was passed by the ombudsman, by the regulatory commission, nor was any hearing given to the petitioner, thereby refusing to exercise its jurisdiction under section 142 of the Electricity Act 2003. Push up next para. Upon hearing learned counsel for the petitioner and the WBSEDCL, since the WBERC chooses not to appear or to controvert the allegations made by the petitioner, the allegations of the writ petition against the WBERC are deemed to stand uncontroverted by application of the doctrine of non-traverse. Push up next para. A bare perusal at the communication of the commission dated June 8, 2023 shows non-application of mind by the commission and refusal to exercise the jurisdiction vested in the commission under section 142 of the Electricity Act 2003. Full stop. The commission merely forwarded the compliance report double inverted, filed by the distribution licensee without adjudicating on the question as to whether there was actual non-compliance of the order of the ombudsman. Push up next para. Accordingly, WPA 25078 of 2023 is allowed, directing the, which respondent is the,
my lord, here.
Directing the West Bengal Electricity Regulatory Commission to decide on merits the application filed by the petitioner under section 142 of the Electricity Act 2003 upon giving adequate opportunity of hearing to the petitioner as well as the WBSEDCL. Push up. It is expected that such exercise shall be concluded within 6 weeks from communication of a server copy of this order to the respondent number 3, that is the secretary of the commission. Full stop. Immediately after such adjudication, the outcome thereof shall be communicated by the respondent number 3 to the petitioner as well as the WBSEDCL. Full stop. It is made clear that the merits of the allegations made by the petitioner in the petitioner's application under section 142 of the Electricity Act 2003 have not been entered into by this court, and it will be open to the commission to deal with all issues involved therein, independently, on its own merits, and in accordance with law. No others to cause.
Satisfied of this order, then commission.
হ্যাঁ আচ্ছা, প্রথমে যেখানে বললাম
85.
WPA such and such is allowed, তারপর কি বললাম? allowed by full stop করেছি। thereby directing এর আগে করে দাও, thereby setting aside. No, there is no order.
Because communication, they will say this communication has not been set aside.
আচ্ছা, very well. Directing এর আগে ঢুকিয়ে দাও ওই সেন্টেন্সই, thereby setting aside the impugned communication dated June 8, 2023 made by the West Bengal Electricity Regulatory Commission to the petitioner, within bracket annexure P13 at page 85 of the writ
Onwards.
petition, bracket closed. Yes,
85 onwards.
and directing যা বললাম।
I'm grateful to your lords.
Grateful lords. Next.
Item number 25.
Yes, Mr. Bhattacharya.
I'm for the petitioner, my lord. This is my video service.
Number 226, West Bengal Pollution Control Board.
One, service,
My lord, service is, my lord.
good service.
Yes.
Yes, Mr. Bhattacharya, what is the
My lord,
matter?
this is the petitioner allegation was that, my lord, there is the illegal running of a grill factory by the private respondent.
What
And
factory?
Grill factory.
Grill.
And my lord, the unbearable sound and horrible, my lord, sound, which is absolutely inhabitable, my lord, for the petitioner. Petitioner lodged complaint to the Pollution Control Board, page 32. And my lord, on the basis of the complaint, my lord, the Pollution Control Board initiated a proceeding, page 36, my lord, page 35. My lord, the notice was served. My lord, the initiation proceeding. Now, my lord, in the during pendency of the petition, my lord, the proceeding was concluded and passed a reason order in presence of giving opportunity of hearing to the parties, and my lord, by the all the parties, my lord, the private respondent also. My lord, these order, my lord, kindly see the supplementary. I have served, my lord, my learned friend of the state, and my lord, to the, my lord, public.
Now you are serving.
And my lord, the state, my lord, I am, my lord,
What will the state do?
my lord, with regard to, my lord, the order was passed, my lord, in presence
So
of.
file a substantial challenge, Mr. Bhattacharya, not
I am
in
not
this.
challenging that.
Oh, you are.
I accepting that. My lord, this is my favor. My lord,
So why did you speak for so long? This has become infectious then, in your favor.
no, my lord, only thing, my lord, for implementation of this, my lord.
That
the-
also I'll direct from here.
Kindly see, my lord, the direction, my lord, kindly see, my lord, the page, my lord, 6, my lord.
If it is not implemented, take steps in accordance with law.
My lord, you will also kindly see, my lord, there is certain measures was there given for the Pollution Control Board, and in the next page, my lord, kindly 7, the video of Mundir Bazar block may be kept informed this order and passed by the state board today, and the officer in charge, Mundir Bazar police station, is requested to oversee the compliance of the order in case any violation. My lord, in spite of that order, my lord, the dictatorship is going on, my lord, running, and my lord, without complying, nothing, no steps are not taken, my lord. My lord, there has been, my lord, directed.
That allegation is not there in the writ petition. In the supplementary affidavit, you allege that.
Supplementary affidavit, I mentioned that the order can be, or the order should be implemented, my lord. That is my prayer, my lord. Kindly see, my lord.
I don't find any apprehension that it will not be.
I state that the copy of the instruction is not served on, but there is some minor anomaly in the direction. Be that as it may, since there is a direction.
The petitioner, being aggrieved by alleged inaction by the pollution control authorities in not deciding a complaint of the petitioner, preferred the writ petition. However, learned counsel for the petitioner with leave of court files a supplementary affidavit annexing an order passed by the West Bengal Pollution Control Board, whereby the complaint of the petitioner has been dealt with and necessary measures have been taken. However, learned counsel for the petitioner submits that the petitioner apprehends non-implementation of the said order by the concerned BDO. Next para. However, from the supplementary affidavit, I do not find anything to apprehend at this juncture, that the order of the commission of the board shall not be implemented. In any event, if there is any non-implementation on the part of any authority of the order of the Pollution Control Board, it is always open to the petitioner to take appropriate action in accordance with law in that regard. However, since the writ petition has become infructuous due to adjudication of the petitioner's complaint by the West Bengal Pollution Control Board, WPA 25149 of 2023 is disposed of in the light of the above observations. No address to cause, Sergeant.
Great.
Thank you. Affidavit of service for
And deep level. Thank you.
indicating that so far the earlier stage was concerned.
No, I've not called upon you. No, I deliberately not called, because if you file that, that will create open a Pandora's box. But if they really take steps, then in that proceeding this will be real.
26.
Six, I'm
Yes.
appearing for the Public Service Commission. I'm appearing for the state respondent, Your Lordship.
Which for the petitioner? None appears for the
No, my
petitioner.
lord, I'm for petitioner.
All right. Yes. What is the matter?
My lord,
The mustache is new.
my lord,
You're keeping a mustache. Let us see whether it's lucky or not. What is the grievance?
my lord, petitioner is a Anganwadi worker, my lord, for the post of
Is it
promotion.
Anganwadi worker?
Anganwadi worker, my lord.
Yes.
My lord, for promotional post of Anganwadi supervisor, my lord, she applied for, and examination has been held. My lord, she done well, my lord, but declared unsuccessful. Thereafter, my lord, she applied under Right to Information Act, my lord, to supply the answer script. My lord, that is pending, my lord, without consideration, my lord. Page 16 is the application.
Lordship,
Is she entitled?
Lordship, that time the examination procedure, recruitment procedure was not completed. So we have replied her that as soon as the recommendation will completed, we will give them the copies of the answer scripts, Lordship. May I place that
Yes.
answer, Lordship?
Can you please give a copy of this to him also? Because he has denied this.
That is not. No.
Why can it not be provided right now? What
Lordship,
will be
there
the
is
complication?
there is a full commission decision of the commission, Lordship, that unless and until the examination procedure and recommendations are completed, they
Right.
cannot give the answer scripts to
So
the
when it is due to be completed?
Lordship, the results have been published, Lordship. I have taken instruction from the
Achha.
commission. Kindly give me a week's time. The commission shall give the
Fair
answer
enough.
sheets.
Fair
Lordship.
enough. Within a week. Learned counsel for the petitioner submits that the petitioner became unsuccessful in an examination for the post of Anganwadi worker.
Anganwadi supervisor. Anganwadi supervisor.
Anganwadi supervisor, push up. Immediately thereafter, the petitioner made a query before the respondent authorities seeking the answer scripts of the petitioner. Push up next para. However, such answer scripts have not been given, prompting the present writ petition. Push up. Learned counsel appearing for the Public Service Commission, West Bengal, hands over a copy of a communication dated November 21, 2023. Sorry,
23rd November
November
2023.
23, 2023,
But I have the instruction.
which was purportedly made to the petitioner.
I have the instruction. No.
Lordship,
copy.
even even to
Yes,
the
give a
advocate.
copy to her. Give a
Lordship,
copy.
even to the advocate also it has been sent, Lordship.
Pushed up. Next para, by relying on the same learned counsel for the Public Service Commission submits that the commission has replied to the query of the petitioner to the effect that recommendation of candidates for the examination has not yet been completed and photocopies of the answer scripts can be provided after completion of the recommendation. Push up. It is pointed out by learned counsel for the commission that a copy of the said reply has also been given to the learned. Where do I find that from?
The receipt
Advocate?
copy is not there, my lord. Only the name is.
The last sentence
addressed to me.
last sentence push up. Although learned counsel for the petitioner denies having received any such answer, a copy of the same is kept on record. Push up. Learned counsel for the Public Service Commission further submits that the results have recently been declared and the commission is ready to furnish the answer script sought by the petitioner within a week from date. Pushed up. In view of such fair stand, the entire grievance of the petitioner is resolved, shall be resolved if such copies of the answer scripts are given to the petitioner within a week. Push up. Hence, there is no use of keeping the writ petition pending. Push up. The communication handed over by learned counsel for the Public Service Commission today be kept on record along with the affidavit of service. Let a copy thereof be handed over to the learned advocate for the petitioner by learned counsel for the Public Service Commission during the course of the day.
I will immediately hand over. I'll just take pictures. I have only one copy. I'll give it to him. You
Course
Lordship
of the
can
day?
record.
course of the day. Full stop. Next para. WP 825189 of 2023 is accordingly disposed of by directing the West Bengal Public Service Commission to furnish copies of the answer scripts in terms of the query of the petitioner to the petitioner within May 15, 2024 by acting on the server copy of this order without insisting upon prior production of a certified copy. No orders to cause certain certificate.
I'm grateful, my lord.
Thank you.
27.
I'm appearing
Yes.
on behalf of the
Service
my lord.
affected on all service.
Yes, my lord. Har sab ka. For new electric connection, my lord. Kindly see annexure A, page 22. All petitioner has already given service service connection charge as well as security deposit. Only on the
None of the WBSCTCL lawyers are there. Please give a notice to Mr. Naik or Mr. Debanjan Mukherjee. They appear for the WBSCTCL. Just find out Mr. Srijon Naik or Mr. Debanjan Mukherjee. Give a notice. I'll take it up at 2. 2 PM কিছু fixed আছে? Tell him to take instruction. Affidavit of service filed today be kept on record. Full stop. None appears for the WBSCTCL despite service. Full stop.
My lord, I have instruction, my lord, to appear.
Yes, what is your instruction?
My lord, no instruction, lordship. I am to collect a copy and, my lord, on the basis of the, my lord, I can proceed, if possible. My lord, kindly subject to my lord's approval.
None appears for the WBSCTCL at the time of call. Full stop. However, during hearing, Mr. Srijon Naik, learned advocate practicing in this court, comes forward and submits that he will
It's on instruction, lordship.
that he has instruction to appear for the WBSCTCL, although not on the merits of the issue. Full stop. Accordingly, the matter is postponed till tomorrow. Full stop. At the next hearing, learned counsel for the WBSCTCL shall make his submissions on the merits of the writ petition.
Grateful, lordship.
Adjourn for the day.
Lordship. At a copy.
Next.
28.
But I am appealing for the state in this matter.
Yes. Petitioner.
Well, this petition is infractuous. Well, no mandamus can be issued upon the respondent number 2. And they are the private party, my lord.
So what is the matter about? Let me hear it.
Here I have challenged a decision of the Apartment Owners Association. I made representation before the competent
How can a writ
authority.
petition?
Because I have made representation before the competent authority.
16B. Does it satisfy 16B? Let us see that. Where is that? That has not been decided as yet.
It's the internal policy. Internal policy, how can we decide, my lord? There is a
Say that. Reject the application by saying that it does not come under 16B. Do that at least. Affidavit of service filed today be kept on record. Full stop. The grievance of the petitioners is that being aggrieved by the decision of the respondent number 3 association, the petitioner preferred a complaint before the competent authority. Full stop. Next para. As of today, till date, the competent authority has not replied to the same. Full stop. Next para. Learned counsel for the state / competent authority submits that the matter pertains to a private dispute between the petitioner and the association, and as such, the writ petition is not maintainable. Full stop. Next para. However, it transpires that certain allegations have been made by the writ petitioner in its representation. Where is the complaint?
1st of August 2023, page 25.
Page 25, my lord, but it is
Writ petitioner
that was received by us.
writ petitioner to the competent authority on certain alleged irregularities in the functioning of the association. Full stop.
They didn't attach whether they have registered their association or not. Nothing documents is appearing in this writ petition, my lord.
Does not come within 16B. File a civil suit.
The
Yes,
question,
my lord, there is only the solution they can file civil suit.
may I say one thing? My lord, kindly come to page 20. My lord,
No, let me see your complaint first, whether it comes within 16B at all.
Whether the apartment registered, it has registered the association or not, nothing has been assessed with this
No.
registration.
File a civil suit, not like this.
civil suit will not lie.
A perusal of the complaint, complaint dated August 1, 2023, however, which is annexed at page 25 of the writ petition shows that the questions raised therein do not come within the purview of section 16 capital B of the West Bengal Apartment Ownerships Act 1972. Full stop. Next para. In the event the petitioners are aggrieved with the association, it is always open to the petitioners to approach the competent civil court with their respective disputes. Full stop. However, there is no scope for interference in the present writ petition on the grounds as indicated above. Accordingly, WPA 25291 of 2023 is disposed of by granting liberty to the petitioners to approach the competent civil court with their grievances against the association, if any, upon which the civil court shall decide the issue without being influenced in any manner on merits by any of the observations made herein. No rest to cause certain ceremony. This does not pertain to 16.
Grateful, my lord.
I think 16B will come.
I don't think so.
Because
Next.
my lord, the question was
Next.
yeah.
Yes.
My lord, annoying your lordship, may I say one thing? My lord, not about this matter. My lord, because I don't have any choice, so my lord, I have to. My lord, it's a question of life and death of a 8-year girl, my lord, who became
Of a
girl child who became pregnant, and my lord, her life and death is questioned. My lord, I have filed the matter. I have tried to mention. My lord,
when did you file it?
My lord, I have filed it on Friday. My lord, matter will come tomorrow. My lord, if that is be taken up in the top.
No. Daily matters, and that is that because of the reason I want to take up the daily matters, that's why I'm not allowing upgradation. That is the precise reason, because I could not reach daily matters. If it comes up, what am I doing now? What am I taking up now? Have you checked up what am I doing now?
I know, my lord, but
That is the reason I'm not upgrading any matter. So let me take up matters. Yes, call on the list.
29. I think here for the respondent number 22 only. I have been on behalf of the state respondent.
My lord, in this, এক মিনিট আচ্ছা এখানে who is appearing?
My lord,
Yes, what is the matter?
My lord, in this matter, the petitioner has a land adjacent near to a river, my lord.
Near to a river?
Near to a river, my lord. The land of the petitioner, agricultural
Yes,
land
yes.
of the petitioner, is situated nearby the river of the locality, my lord. What happened, my lord? That river embankment of that river has been cut illegally, and as a result, the river water, the saline water, since it is almost on the confluence of the river, my lord, it is on the North 24 Parganas,
coming into your agricultural land.
And that has been flooded, my lord. My lord, my specific prayer here is that, my lord, under the Embankment Act, the collector is obligatory upon the collector to repair the embankment. And here, my lord, since I have no alternative remedy, I have here before your lordship for draining out the water, my lord.
Collector is which respondent?
Collector, my lord.
Lord, I am filing one report by the.
Which is the respondent? Please don't keep your report with you.
My lord.
District magistrate is the collector.
District magistrate is the collector.
8. You have not mentioned that. Should have mentioned. Anyway, where is the copy of that act? Do you have a copy of that act under the embankment?
My lord.
You are appearing for the collector also?
Well, state respondent, not state respondent.
What is your report? Don't file it. Tell me.
Well, the report, it is a control all inlet water reservoir, and that is
Use
used
the
by
microphone. I can't understand you. Use the microphone, please.
it is used by the local farmer to cultivate their lands. And this is not the incident what he is alleging, my lord. And my lord, this is a report filed by the subdivision officer, my lord. So
No, you are saying water is coming. It's near the confluence, Mr. Mukherjee. Mr. Mukherjee,
Yes, man.
your allegation is confluence, due to confluence, salt water is coming.
Salt water is coming.
What is your answer to that? Which portion of the report?
my lord, 2 and 3, my lord.
You say old controlled inlet structure which has been misrepresented by the petitioner is illegally cut. Anyway, if salt water is coming, you repair the embankment. What is the difficulty? No test report has been found to be annexed regarding quality of water. You are to do that, not him. He's a farmer. How are they supposed to obtain any test report?
My lord,
Place the act, Mr. Mukherjee, quickly.
My lord, section 7, my lord.
You are for?
I am for the respondent number 22.
Who is he?
Well, he is one of the private respondents in favor of whom he has executed a lease deed for running the paddy and the fishery over there.
You are also affected.
I'm also, this is basically a water body which is being used for the boral cultivation, the type of paddy, as well as the fishery along with this millet.
No, you are also aggrieved by this. You are supporting the petitioner.
I'm not
My lord,
the representation is different. But his contention is this: the private respondents have illegally cut open the bank, and because of that, the salt water.
Acha, if that is ignored, if that is not accepted, do you have any other difficulty if the embankment is sealed up?
Embankment, my instruction is that there is no cut in the embankment. There is no the representation made by the petitioner is not true, Millet. That is my instruction.
You have been permitted to use it
My lord.
by him.
My lord, it is
So you are cultivating.
My lord. That should kindly see this. This is the rent receipt he has issued, Millet.
Yes, what do you say to this?
My lord, I oppose, my lord. I don't.
I'll direct affidavits in. Learned counsel for the petitioner submits that in terms of Section 7 of the Bengal Embankment Act, 1882, the controller has the power and the authority to repair any embankment if the same suffers from any damage. It is argued that the petitioner has been cultivating the subject land, but such cultivation is adversely affected due to an indentation being cut out in the embankment adjacent to the nearby river, which being in close proximity to a confluence, is resulting in salt water coming into the cultivable land. Next para, despite a representation being given to the controller / district magistrate, it is submitted that no action has been taken. Learned counsel appearing for the state files a set of written instructions where it is indicated that there is an old water inlet structure with gate-control facility in a crude form constructed by local people performing so-called sluice, SLUICE structure, and facilitate the local farmers to use the water of Buri River, BURI River, for cultivation, being their livelihood. Thus, the state disputes the allegation that the indentation has been made illegally. Next para, learned counsel for the private respondent number 22 places reliance on certain documents, photocopies of which has been handed over in court today, which are purportedly rent receipts indicating that the petitioner has leased out the land to the said respondent, and the said respondent, it is alleged, is in occupation of the property. So it is submitted that the allegation of illegal cut being made is squarely denied. Next para, since a factual dispute has arisen, the respondents are directed to file their affidavits in opposition by June 14, 2024. Reply, if any, shall be filed by June 21, 2024. The matter shall be listed in the monthly list of July 2024 for hearing.
My lord, some,
The documents handed over in court today be kept on record.
my lord, some precedents, my lord.
এটা ফেরত দিয়ে দিন। I could have decided right now, Mr. Mukherjee, but that would go against you. Let it come on oath.
My lord, my lord, since my lord, they have said that is Sluice gates are there, my lord. Since my lord, let it be decided, my lord. My lord, they have in
If
the
sluice gate is there, there is no question of an illegal cut. That is being
My lord,
operated properly then.
my lord, that is the
Anyway, Mr. Mukherjee, I have directed. Yes, next.
Item number 30.
deeply organized, my lord.
Thank you. Who is appearing for the petition?
Yes,
And this
I'm
not
the petitioner
appeal-
in person.
We are appearing for the.
Yes.
Yes, this is a service affidavit.
Yes, what is the matter?
Lordship, the issue is not receiving information under RTA Act from Eastern Railway Authority. And
What's the information regarding?
yes, I sought for inspection of records under purview of RTA Act. There are 5 items. My lord, please come to page number 19 of the petition.
Yes.
Yes. In that page number 19, my lord, attendance register, office orders, classification chart, workload analysis report, and duty rosters. These records are kept with the railway authorities, and I sought a permission to make an inspection of record under purview of RTA Act. Initially, it was denied by the public information officer. Later on, the appeal was filed. In that ground, the first appellate authority submitted that a report shall be filed whether the information should be furnishable or not. Then again on page number 38, I'm sorry, my lord, page number 38, the information has been denied. The matter ventilated upon the CIC. Then CIC, Honorable CIC passed an order. It is very interesting, my lord. Please come to page number 35 of the petition. The decision of the Honorable CIC.
It was remanded back.
Pardon, my lord?
Remanded. This is the first information.
No, this is the order of Honorable CIC.
Achha.
Challenging this order, I came to this spirit court.
This is the second appellate authority. CIC is the second appellate authority.
CIC is the second appellate
Yes,
authority.
yes. Let us see this. Yes.
Yes.
Decision.
Decision, yes. Keeping in view of the facts and of the case, and after perusal of the documents available on record and submission made by both the parties, the commission finds that an appropriate reply as per the RTA Act has already been furnished by the respondent, and hence no further intervention by the commission is required in this matter. For redressal of his grievance, if any, the appellant may approach an appropriate forum.
There is no other forum.
That is the forum.
You have approached that forum.
This is the read code is the forum. My lord.
Now, section 11, kindly see.
Right to Information Act. It must be there. Yes, section 11.
11, third party information.
Yes.
Petitioner is not the employee, petitioner is the outside. So that is my humble submission before your lordship. Section 11, third party information, where a central public information officer.
Under this, you have to give a notice to the third party.
Kindly see, provide.
We gave notice.
This is not the refusal.
Yes.
They refused.
Refused.
Section 11 says where a central public information officer or state as intends to disclose any information, when you intend to disclose, it starts with that.
And Maladi provided that except in the case of trade or commercial secrets protected by law, disclosure may be allowed if the public interest in disclosure outweighs in importance any possible harm or injury to the interest of such third party. My learned friend, another said the financial. Kindly see the page 34 and 24 also. They're asking for, my lord, in the RTI. Wow.
How does it affect?
Page 23. Page 23.
Page 18 is the query.
Page 23, my learned friends, office orders in favor of creation of concerned, my lord, post and necessary authority issued by the Authority of Finance, Government of India, to create such post under which the above named public servants are presently working. kindly see page section 24 and schedule 2. Act not apply.
Section 24.
Section 24. And schedule 2.
Yes.
Act not to apply to certain organizations.
Which one do you fall under?
Might fall under the schedule financial. Might kindly see schedule 2, 18. Financial Intelligence Unit.
Schedule?
Schedule 2.
Serial number 18.
Serial number 18.
First, let us complete section
Yes,
24.
yes. Sorry. Sorry.
Act not to, please place section 24.
Yes.
Place it.
Yes.
Yes.
I'm placing. Yes, sir. Proceed.
Shall apply, nothing shall apply to intelligence and security organizations specified in the second schedule.
Financial matter, this is my
Not only any financial matter.
Financial Ministry of Finance. Kindly see.
He is asking for information regarding the Southeastern Railway.
Eastern Railway, my lord.
Eastern Railway.
See, this is the clause. Kindly see.
What clause?
Kindly see page C. Type information, my lord, page 19.
No, from the act satisfy me that it is not, it cannot be given.
What Oxford office orders in favor of creation of concerned post and necessary authority
Everything is regarding your
by
Southeastern Railway.
Ministry of Finance, Government of India, to create such posts under which the above named public servants are presently working.
Yes.
Yes.
He is asking for the circular or government notification or whatever is there.
My lord, the
How do you
financial
come within you are not an intelligence and security organization.
Ministry of Finance, my lord,
Ministry of Finance is not protected.
Financial intelligence, my lord, the total serial 18.
Financial Intelligence Unit India is a specific unit. That's not the Ministry of Finance at all. And Ministry of Finance, definitely all public, it should be on the website of the ministry.
That is the available. But what, my lord, the website is available. That
If it is available, give it to him also.
See the
No,
website.
Financial Intelligence Unit, this is a ridiculous objection you are taking. What are you saying? Section 24 pertains to intelligence, security, intelligence and security. You are not an intelligence. No, I'll set aside the order, direct you to give the information. You're trying to suppress something, some irregularity in your function. Absolutely.
I have not suppressed. If your lordship desire, that is the attendance. It is attendance registered, my lord, 2,000 pages, 200 employees. It is not possible, but to my learned friend to fee.
He'll pay the fee.
To inspect.
Definitely it's possible. It's possible. He will pay the fee.
It is the implied to cost to put.
If you have a dispute with the cost, he'll pay the cost. You're varying your grounds during arguments.
Third party information, kindly see.
I've seen 81J. I've seen 81J. Have you seen 81J?
81J.
I don't think you have.
No.
And you are arguing the matter. 81J was the only ground on which it was refused. You say merely no. I'm really surprised. Yes.
Assumption from
Lordship, one
The
small thing,
petitioner
sir.
challenges. If you have not seen 81J before arguing, I'm sorry. I need not
Lordship,
hear you
may I
further.
submit for a while? Just a 1 minute. Please come to page number
Need
30.
not.
information is related to personal information, the disclosure of which.
I've seen it umpteen times. Sorry. Learned counsel for the petitioner challenges the order of the Chief Information Commissioner sitting in second appeal. The petitioner sought for the inspection of certain documents which, according to the petitioner, are registers and public records, from the Eastern Railway. Next para. However, the said information was refused by the first authority, prompting the petitioner to move the first appellate authority and thereafter the second appellate authority. Full stop. Next para. The refusal was apparently on the ground of exemption under section 8 within bracket 1 within bracket small j of the Right to Information Act 2005. Full stop. Next para. Surprisingly, the petitioner appearing in person with leave of court points out that the Information Commissioner in his decision, stated that he found that an appropriate reply as per the RTI Act 2005 had already been furnished by the respondent, and hence no further intervention by the commission was required in the matter. So for the redressal of his grievance, if any, the appellant therein within bracket present petitioner bracket closed was granted leave to approach an appropriate forum. Next para. Learned counsel appearing for the respondent authorities places reliance on section 24 of the Right to Information Act and argues that the said section provides that nothing contained in the act shall apply to the intelligence and security organizations specified in the second schedule. Learned counsel points out that in item 18 of the second schedule, within double inverted caps, financial intelligence unit, India, double inverted close, has been enumerated. Hence, one of the information sought by the petitioner in query number C being office orders issued by the Ministry of Finance, Government of India, it is submitted that the act is not applicable at all. Next para. Learned counsel next places reliance on the proviso to section 11 within bracket 1 of the act, which provides that except in the case of trade or commercial secrets protected by law, disclosure may be allowed if the public interest in disclosure outweighs in importance any possible harm or injury to the interests of such third party. Next para. Learned counsel next argues that section 8 within brackets 1 within bracket small j also speaks about public interest, which is entirely absent in the present case. Next para. Upon hearing learned counsel for the parties, it is clear that the argument of the respondents on section 24 cannot be accepted. Section 24 within bracket 1 of the 2005 Act provides that nothing contained in the Act shall apply to the within double inverted intelligence and security organizations, double inverted close, specified in the second schedule, S capital, S capital. Next para. The second schedule clearly enumerates certain specific institutions to come within the purview of such exception. Next para. In item 18, a specific unit of the government being the Financial Intelligence Unit, India, has been enumerated. Next para. However, the information sought by the petitioner from the Eastern Railways has nothing whatsoever to do with the Financial Intelligence Unit of India. Next para. Query C, which has been relied on by the respondents for such argument, merely seeks the office orders in favor of creation of the concerned posts and necessary authority which have been issued by the Ministry of Finance, Government of India to create such posts under which the public servants are at present working, as mentioned therein above. Next para. Although the notifications and office orders of the Ministry of Finance are supposed to be on the public portal of the said ministry, the petitioner herein seeks specific office orders on which the Eastern Railway relies on for the stipulated purpose as clearly enumerated in query C. Full stop. Hence, comma, the said office orders which are supposedly relied on by the Eastern Railway being public records, comma, there could not have been any objection on the part of the respondents to furnish the same on such count. Full stop. Section 24, comma, thus, comma, is not applicable by any stretch of imagination to the present case. Full stop. Insofar as the reliance on section 11 within bracket 1, comma, proviso is concerned, comma, the same is also entirely besides the point. Full stop. Section 11 within bracket 1 provides that where a central public information officer sub capse or the state public information officer, as the case may be, intends to disclose any information or record or part thereof on request made under the act, comma, which relates to or has been supplied by a third party and has been treated as confidential by that third party, comma, the rest of the provisions including the proviso follow. Full stop. Next para, the proviso merely qualifies subsection 1 of section 11 and does not add any further provision thereto. Full stop. The premise of section 11 within bracket 1 is that the information has to be provided by a third party and has to be confidential. Full stop. Both the said tests are not met in the present case, comma, since the attendance registers, comma, classification chart, comma, workload analysis report, comma, duty roster, and office orders issued by the Ministry of Finance on which the Eastern Railway relies on for the specific purpose as enumerated cannot qualify as documents provided by third parties, comma, nor can they, comma, by any stretch of imagination, comma, be deemed to be confidential documents of such non-existent third party. Full stop. Thus, comma, the reliance on section 11 by the respondent authorities is entirely misplaced. Full stop. Next para, the ground on which the authorities have refused the information was primarily section 8 within bracket 1 within bracket small j. The said clause provides that there shall be no obligation to give any citizen information which relates to personal information টা italics এ যতক্ষণ না বলছে italics এ করুন personal information the disclosure of which has no relationship to any public activity or interest, comma, or which would cause unwarranted invasion of the privacy of the individual. এই পর্যন্ত italics এ তারপর unless the information officers or the appellate authority as the case may be are satisfied that the larger public interest justifies the disclosure of such information. Full stop. Again, comma, the premise of clause small j of section 8 within bracket 1 of the 2005 Act is that the information, comma, for coming under the exemption, comma, has to relate to personal information, comma, the disclosure of which would have no relationship to any public activity or interest. Full stop. The information sought by the petitioner in any of his queries cannot be said to be personal information. Full stop. All the informations relate to the functioning of a public authority, the Eastern Railways, comma, which has to ensure transparency as an implicit condition of discharge of public functions. Full stop. Thus, comma, there being no personal element involved, comma, even regarding the attendance registers or duty rosters, comma, the said defense taken by the respondents cannot be accepted. Full stop. Accordingly, comma, WPA 25404 of 2023 is allowed on contest, thereby setting aside the orders of the second appellate, comma, the first appellate as well as the second appellate as well as the first appellate authorities, confirming that of the CPIO and directing the respondent number 3, that is the senior divisional operations manager cum public information officer, comma, Shialda division, comma, Eastern Railway, to furnish inspection to the petitioner regarding all the documents as mentioned in the query of the petitioner enumerated in annexure P1 at page 18 of the present writ petition, comma, upon giving prior notice to the petitioner of the date of such inspection, which of such exercise shall be concluded within an outer limit of 4 weeks from this date. Full stop, no orders to cause urgent certified copies.
Grateful, Your Lordship. Grateful. Lordship may kindly permit me, my lord.
4 weeks so that you can prefer an appeal.
No,
Yes.
1368.
During the election, that's why 8 is.
This information, Eastern Railway, they are not bothered with the election. They are
No,
bothered with.
by election is the duty to.
Very well. 4 weeks or 6 weeks. Korda.
No,
6 weeks, not 4 weeks.
Item 1368 was 29 last week, on Thursday. My lord, there is a very extreme urgency. My lord, the criminal matter is kept on 13th May. My bad luck, it was 29th.
Cannot make an
Friday. When overnight, my lord, because the monthly
No,
type
no,
gone 1000 below.
No.
My lord, the criminal
Because of
matter
the
is kept
filing.
on 13th May, my petition become infructuous, my lord.
No.
And it is not our, we have not taken adjournment.
No
It was 29.
No
Last Thursday, Lordship.
Last Thursday it was 29.
29.
29.
No, it is
You must have not been there when it was called on.
No, it was not called.
Because
Yes.
my lord was having
For
a criminal
that-
bench,
that-
division bench.
Yes.
Witness was Thursday.
With
Then
at
my lord,
court,
It was appearing under the upgraded heading.
no,
What heading was it appearing under?
No,
motion dated of that date.
30th
It was item
April.
number 29.
29 because of
Date
Lordship was in the
Can you give me a copy of that list? I'll hold an inquiry with my officers. Just during the course of the day, just hand over that copy.
We will hand over
The first page of the list and that page.
relevant page. Because Lordship was in
If
that.
it was 29, I don't know how it went down that
No,
far.
because of the.
I'll look into
change-
it definitely.
Because 2 days a month. The day of
Visually, ওটা দিয়ে গেলে visually
Lordship, with your leave, my lord,
Yes,
I
yes, please.
indicated the
Which is the date? What is the date of that?
second May was 29 and third May was 62.
2nd May 29.
And third May 62. And today it is 1368.
Thank you. I'll look into it. Give me 2 days time. I mean, after Wednesday is a holiday.
Yeah, that is all.
Please just come in the morning of Thursday. I'll look into it.
May I have my lord's kind leave to mention?
Mention
leave,
now, no.
My lord, leave an urgent matter, my lord.
No, sorry, no.
If it is not
No.
taken up today,
No, no, no.
thing will be in
Please call the
my
list.
lord.
Yes.
Fixed matter at 2 p.m. Item number 18.
Yes.
After a long gap, sometimes continuity or
Yes, difficulty. The Ms. Sengupta, I'll request you, all of you, to file short written notes of argument and just be brief on the point, because just see every day I'm having to refuse motions and all. So I'll be as fast as possible. We'll conclude the arguments and just I'll seek written notes of arguments on any date. I mean, yes, please just conclude. Yes.
Yes.
You are on rejoinder to their. I mean, they've given the reply. Oh, acha, acha.
I only, my lord, now today, technically, I have a listening brief because Ms. Sengupta was arguing on the merits of the matter, my lord. I only addressed your lordship on the maintainability point, my lord. I will still argue on that point along with the merits after she concludes, my lord.
Very good. Yes. Ms. Sengupta, you address the maintainability issue and as well as touch the
on
main.
the maintainability point, my learned friend argued on the first day because that was taken.
Yes, you answered that as well as the main merits.
My lord, that was answered and my lord was pleased to hold that it is maintainable. Then we started the final hearing. That was not recorded, but my lord,
I'll deal with that also. Put that in your written notes of argument.
I shall put it.
What about the merits? Yes.
Yes, my lord. Because thereafter we went into the merits of the case. And Mr. Go, my learned friend, argued first upon the maintainability. This is the system. Yes. Now, my lord, on the last occasion, I submitted, my lord, that the reason behind not to declare the election result of the petitioner is bad. Because the only reason they have shown that he requested for taking vote from home of a candidate, which she declined to give, and subsequently the respondent number 7 procured 2 letters from that lady. First, a letter which the presiding officer declined to accept.
Yes.
And declined also to cancel the registration of the petitioner. So again, they went there, the respondent number 7, and took another subsequent addition in the said letter that we did not request the petitioner for home collection. So on the basis of that, the cancellation of candidature of the petitioner is bad post-election period because there is no fraud, nothing. Somebody approached the petitioner that please send by home collection.
Yes, his approach is not a good sufficient ground. Plus, she did not vote at all.
She did not vote at all. Nobody was benefited.
That is the merits also, in fact.
Merits also. Similar when
What else?
these went bad, that then the election ballot box, which is kept under seal, that is to be opened, and below the counting should be done, and only thereafter the election will be completed. I am showing, my lord, the provisions of law in this regard. আরে বাবা আমাকে বইটা দাও বইটা একটু বইটা দিন না যার সাহেব কি ওয়েস্ট বেঙ্গল অ্যাপার্টমেন্ট ওনারশিপ অ্যাক্ট
অ্যাপার্টমেন্ট ওনারশিপ একটা আছে Which section, Ms. Sengupta?
Yes, my lord. My lord, Losses kindly come directly to bylaws 8. Election of managers. First 7, constitution of a board and its functions, and then election of managers of the board.
Yes.
My lord, 7 is that there shall be a board in respect of each association to carry on and manage the affairs and business of the association and to exercise all such powers of the association as are not required to be exercised by the association in a general meeting. And for that purpose, 8 is election of managers of the board within 15 days of formation of an association under clause 2 of bylaw 3. The apartment owner presiding over the general meeting referred to in the said clause serves notice upon each member of such association, fixing thereby the date from the date on issue of such notice. Well, for election, the election shall be held by secret ballot. Well, I am not reading much more. Then, well, Losses, I am kindly come to sub rules 4. That the election, 2 is election shall be held by secret ballot in accordance with the detailed manner decided under clause 1 of bylaws. Now, my lord, this clause 1, whatever is written here that regarding service of notice, everything was done. So, my lord, there is no fault or, my lord, errors in the process of election. That, my lord, lordship kindly come to fore that after the managers of the board are elected as aforesaid, the board shall, within 10 days of the date of election of its managers, hold its first meeting and elect its president, who shall be the chief executive officer of the association. The other office bearers of the association shall also be elected in that meeting. The president shall forthwith forward the names of the president and that of the other office bearers and managers of the board in Form 3 to the competent authority for his record. So, my lord, the Form 3 is the final stage. First is Form 1, where the association, after registration of the association, will send the names of the declaration of the members to the competent authority in Form A, that this is the meeting, and thereafter competent authority give a certificate of registration in Form 2. Form 2 of the competent authorities later is very important when there the competent authority said that you select a presiding officer for holding the election. And that page is, losses, kindly have a look. The competent authority certificate, page 26 of the writ petition. Page 26 and 27, Form 2.
Yes.
My lord, I hereby certify that Siddhartown Rajat Association having postal address. My lord, the postal address is also of the presiding officer's personal address, his flat address, in accordance with clause 2 of bylaws 3. And thereafter the next page, that is the direction given for election.
Yes.
My lord, the 1, 2, 3, 4, fourth paragraph, that it is further stated that within 15 days of formation of this association, you shall serve notice upon each member of the association, fixing therein the date on which the time and place within a special general shall be held for election of the managers. Just as I just read before, my lord, 8.1, this is the earlier part of 8.1 of the, and this association by secret ballot, and as may be decided in the said meeting under clause 1 of bylaws, and that
Yes.
yes, my
Then
lord,
the paraphernalia 7 has to be.
paraphernalias. Yes. So, my lord, everything was done. This is Form 1.
Yes.
This is Form 2. Thereafter, Form 3. When can the Form 3 be submitted? After the election is over. My lord, the petitioner served notice that there are many blocks, 29 blocks. So, my lord, 48 block representatives. Sometimes if 25 or 26 flat owners are concerned, then one block representative, and in where there are more flats, more block representatives, because we cannot do much more than 48 in number total. And in this case also 48 in number. And the election of this Magnolia block for only one block representative, and these block representatives after election, the elected members will be called the board of managers. And the board of managers, after completion of election in their first meeting, will choose the president, secretary, and other office bearers. And thereafter, the president will send this list of office bearers along with the board of managers to the competent authority under Form 3. So, my lord, the first part is the completion of election of board of managers. The petitioner as the block representative was one of the persons, candidate for to be elected as board of managers. So long that is not complete, in my humble submission, Form 3, the question of submission of Form 3 or constitution of office bearers cannot arise. Even the elected, some of the elected members cannot hold the first meeting. Everything.
Here, Form 3 has been submitted.
They have submitted the Form 3 on the basis of a misrepresentation, that are not representation by one of the member of the election commission, who claimed to be the sole member of the election commission, and that was given to the competent authority that all have resigned. As I am the sole member, I am giving this certificate that the election is complete. And
He was the sole member for Magnolia.
no, not for Magnolia.
Magnolia remains unrepresented.
Below, one thing is that Magnolia, they have chosen the other candidate. There were two contestants. So the other candidates, the respondent number 7, that block representative, not block representative, the election commission. There are two parts. One is block representative, and others is election presiding officer and the election team. So these election team or election commission, there were 13 members, one presiding officer, total 14.
Yes.
Now, Millard, I also made in my writ petition that mostly they have resigned. But from the certificate given by one election team member, it appears that he said that he is the sole member who has not resigned, and that is why I am giving the certificate of the winning combination of block representatives. After election, they are board
Who
of
was shown as the block representative of Magnolia?
Beloved, they have
Somebody
declared
else.
respondent number 7, Paushali Kontok, the other contestant.
Because you were excluded and the election went on behind your back
Behind, no, election was held.
properly.
Election was
after
held
election, you have been
election.
right.
After election, they did not allow the presiding officer to open the ballot box. They said that cancel the candidature of the petitioner.
There were only two candidates, you and
Only
Posh.
two candidates.
Right.
And that is why this was
So
done.
by default, the lady becomes the very.
That according to them. So that is why the lady was so impetus in getting the letter from that Veena Singh. Because she wrote that I went there. I convinced her to give the letter.
She herself, the winning candidate from block Magnolia, she herself obtained that letter from the Bina.
I am thankful to my learned friend that whichever underlying arrangements were not very clear to us, that is clear from their affidavit in opposition. So they have made it in their opposition.
Right.
That the respondent number 7 has filed the opposition. He said that yes, I went.
I went, yes.
I went first a letter.
Anyway, but it's very.
And we not in any even letter or no letter, representation or no representation. When nobody cast vote, nobody was benefited. The after election, the candidature cannot be cancelled, or the presiding officer cannot refuse to count the ballot box. Below the letter of Shubhadeep Mukherjee, the respondent number 6, we have made him, that is annexed at page 52 of the writ petition, that he said as the sole member.
Yes.
একটা পরিষ্কার কপি বোধহয় ওদের ইয়ের মধ্যে আছে, অপোজিশন।
And there cannot be any cancellation.
Yeah, cannot be any
Secondly, this was a bad ground for your cancellation in any event because that could not have any effect on the election. Plus, she did not vote at all, Bina.
But she did not vote at all.
These are the main grounds.
These are the main
Any
grounds,
other
and
ground?
my prayer is for counting of the ballot box. Ballot box is under sealed cover till now for Magnolia block.
After Form 3 has been submitted, what is the effect? The new body has started functioning.
No, because there is an interim order passed by my lord that the ad hoc committee will start. So there is no question. But competent authority, in fact, was swayed away by the misrepresentation of the respondent number 6, that as the sole member, I am giving this certificate. And that is why competent authority, they have annexed in their opposition the Form 3 they submitted before the competent authority, and by RTI they came to know that which is the valid one. The competent authority said this, and enclosed therewith the certificate given by respondent number 6. The competent authority was completely misled by the certificate. But in fact, we also, at the time of argument, when my lord was pleased to ask me that whether all have been resigned, I submitted that except one, because I also was misguided by this letter. I also thought that this Shubhadeep only alone did not resign, but so all others. But from their affidavit in opposition is found that 2 persons, they were not present on the day of election. Somebody's father was passed away, and other members, he was also silent. So all the 3, they were not known to us that they did not give their resignation, nothing, no, nothing, that's kept silence. Then when they kept silence, then 4 members are still in the election team. Then this Shubhadeep Mukherjee, how can describe himself as sole member of the election team and gave this certificate as page 52 of the writ petition with the list of board members declaring Paushali Kole as elected member.
So you want the outcome of the election to be cancelled, that Form 3 to be cancelled, and it to be reopened from the stage of counting your Magnolia votes. The
Magnolia
other votes remain intact. Only Magnolia votes have to be, the box has to be opened and counted, and then whatever.
Yes, my lord.
Right.
And my lord, so far this is so far fact is on the merits of the case. Now, my lord, the maintainability of the writ petition. My lord, there is no forum under this act to challenge any illegality or irregularity in the election process under bylaws 2022. Well, this is a subordinate legislation done under the West Bengal Apartment Ownership Act 1972. And when there is no other forum,
Right.
after one forum is after office bearers, after election, if any irregularity in their functioning, then only some appeal can be made. But this is not this stage. At this stage,
Irregularity under 16B competent authority has. That is different.
yes, that is different.
You say, they say that this also should come under irregularity. Must be saying that.
This is regarding election.
I understand. I mean, I was
This
trying
is
to
different
preempt
from
what they would say.
16B.
Very well.
Yes. So, my lord, in my humble submission, that when there is no other forum, and my lord, the election process, which is to be guided by these statutory rules, are amenable to this writ jurisdiction. My lord, I don't think any this is already decided matter. That's all, my lord.
My lord, I am permitted, my lord, I am respondent number 4, my lord, the presiding officer of this particular election. So,
You're not a party here?
yes, I am.
Yes, why not?
My lord, I have made presiding officer party, the respondent number 10, the contestant party, that Subodhip, who gave the certificate, respondent number 6, also a party.
Whoever is arguing, please put it in a bullet point argument. Note.
Here,
Yes.
my lord, on the
What is your stand?
Yes, my lord, because everybody is right now, my lord, pointing fingers to the presiding officer, my lord. I must, my lord, clear my stand, my lord, before this honorable. What happens here, my lord? That
Ms. Sengupta and company, please take your seats. Yes.
What happens here, my lord, the presiding officer, my lord, I was engaged, and after that, my lord, it is true.
Yes.
After this election was conducted in the evening, I was, my lord, put in the in a particular room, and I was, my lord, forced not to leave, and even I was threatened. My lord, I am a retired government engineer, my lord, so I was also threatened to be assaulted by the private respondents here, my lord. And accordingly, I had to say this. I can put it on affidavit as well. I had to, my lord, say that the candidature of the petitioner is cancelled.
Why didn't you file an affidavit? I directed all respondents to file affidavit.
I'll just take your lordship.
We are at the hearing stage.
Of this, because I somehow, my lord, I read today. Yes. So, my
You
lord,
should have put this on oath, because this is.
I've done already, but
You have filed your opposition. You have filed your opposition.
yeah, I mean, I'll take care of this. So, my lord, my lord, because I do not have the.
Ms. Sengupta, don't make the collusion so evident.
So, my lord, here,
Affidavit in reply has been filed by you. So in the reply, you have dealt with it.
yes, I do not have a copy with me, my lord. This is why I just could not assist.
No, very well. In your written notes, just give the page number, because your reply is on record.
And secondly, my lord, with respect to that, my lord, I have already stated on affidavit that I was compelled to do this. And after that, my lord, we are right now on some admitted positions that yes, this has been done after the election was done. Over this cancellation of the candidature was there. So my client stand is that, my lord, let there be a fresh election. Not even to the extent of my lord senior friend by saying that this
Only Magnolia.
Yes, only Magnolia. Let it be, my lord, entire new thing should be there with new election commission excluding me, of course.
Let us hear Mr. Ghoshal first. Yes.
Great.
Nutshell, Mr. Ghoshal, not so much preface and all
many,
these things.
Many things have been said, my lord. So it is my duty, my lord, to assist the court, my lord. I will take a little bit of your lordship's time, my lord. Lordship will kindly take my affidavit in opposition once, my lord. The documents that, firstly, my lord, my lord, since the point of maintainability is still open, my lord, and two other points, my lord, on the point of maintainability is, one is, my lord, the bylaws and the act does not have pervasive control unless there is no pervasive control, my lord. An election cannot be challenged by way of a writ petition, my lord. That is a division bench I have with me of Alipur Bar Association judgment, my lord.
That's regarding the general elections.
No, Alipur Bar Association elections, my lord.
Cited.
It is a registered cooperative society, my lord.
You
Judgment.
should have cited that when you took the point.
I was not having a copy of
Anyway,
this, my lord.
yes, fine.
I will make it, my lord. I will make it a part of the, my lord, my
In a
written notes, my
reply,
lord.
Mrs. Sengupta will desire.
Yes, yes, yes. This was
Copy to them. Give a
yes,
copy
yes,
to them.
certainly.
Yes, hand it over.
My lord, this is delivered on 5th of April
Give me the
2024.
para number.
Lord, you will kindly take, my lord, para 12, my lord, and its subparagraphs, my lord. Everything has been dealt, my lord. Para 13 and then para 15 are distinguished. The judgments cited by Mr. Chakraborty, my lord, has been distinguished, my lord. Para 15.5, my lord, Lordship knows that Mary Education Society judgment, my lord, that has been, my lord, quoted, my lord. বলছি দাঁড়া এক সেকেন্ড 19, my lord, para 19, 20 onwards, my lord. And also, my lord, paragraph 11, my lord. May I hand over the copy, my lord? This is on the point that, my lord, and a body registered under the Registration of Societies Act, my lord, is not a state within the meaning of Article 12, my lord. We are in a very similar position here, my lord. That point has been dealt with, my lord. Two more judgments, my lord, Lordship is aware, my lord, on the disputed questions of act. Many things have been said, my lord, and there are counterpoints on my merits, my lord. I would like to show those documents, my lord, but I will still take this point, my lord. Lordship knows, my lord, celebrated one, my lord. 1997, 1 SCC, page 156, my lord. This is State of Madhya Pradesh versus MV Vaishwa, my lord. Page 156. '16 onwards, my lord. May I hand over? It's a pen. It's marked. I'm sorry. And the other one, my lord, Lordship knows, my lord, Joshi Technologies, my lord. 2015, 7 Supreme Court cases, 7 to 8, my lord. Para 69 to 71. Only on the point of disputed question and why a writ court, my lord, should not, my lord.
Which para?
Para 69 to 71 of, my lord. The second one I handed over, Joshi Technologies, my lord.
Yes.
My lord, now coming back to the merits, my lord. Lord, you will decide all the points in one, my lord. I will come to the merits, my lord. Lord, you will kindly take my affidavit in opposition once, my lord. The first annexure, I will take your lordship annexure by annexure, my lord, and then I will correlate both with the pleadings we have made, my lord. The letter was, this is the letter, my lord. Lord, you will kindly see the email dated 4th of August 2022. Lord, you has got the date.
The first annexure is page 39.
No, my lord, page 46, my lord. I'm referring to, my lord. Page 46.
Yes.
But we will find one Tonmoy Mujumdar writes to STRRA 2016 at Gmail.
Yes.
STRRA is the ad hoc committee, my lord, which was, my lord, who is the mail address to Lord? She will kindly see, dear Mr. Shamim Alam, the reputation, my lord. But she has found that, my lord, on the top left-hand corner, immediately after the email addresses, my lord.
Shamim Alam's name I can't find. Where?
Yes, my lord. Page 40.
Oh, it's addressed to him. Yes.
Yes, addressed to, my lord. STRRA, this email was managed by Shamim Alam. It is not disputed anywhere, my lord. Rashi will kindly take first paragraph, my lord. You as the lead member.
It's managed as in, it was not sent by STRRA.
Yes.
They manipulated.
STRRA, it is, Tonmoy replies to STRRA.
Right.
STRRA, the email ID is managed by Shamim Alam. This was an admitted possession, my lord. So that is why the mail is addressed as dear Mr. Shamim Alam. As secretary. Undisputed. Not elected, it was ad hoc committee, my lord. Sir, madam,
Yes.
But we'll kindly take the first paragraph. You as the lead member of the ad hoc committee clearly understand and accept that the goal of the ad hoc committee of Siddha Town, Rajarhat, etc. is to look after the common facilities temporary till the registration of the Siddha Town Apartment Owners Association, based on which we have been entrusting the CAM funds. Millard, I'm not on that, Millard. Several complaints, paragraph 3, Millard. Several complaints of deficient services, etc. I'm not on that, Millard. He will conduct the recent, very last paragraph, Millard. Second and last, 6 and 7, you acknowledge that you will mandatorily update collection of status. And next paragraph is you will conduct residents meet at least twice, thrice a year. This is, so till that time, when I'm talking about this, Millard, elections were not even declared at that time. Then Lord will kindly, Millard, take, Millard, the next page, Millard. This is the minutes of the meeting of the general meeting of the owners of Siddha Town, Rajaran, pursuant to clause 3. Now, here, Millard, Chiranjeev goes, Millard, the election officer, presiding officer, he goes, he collects form 1, Millard, comes back, Millard, and he was entrusted by way of an email that you will host a special general meeting in terms of bylaw 8 and so on and so forth, Millard. This is that notification, Millard, that minutes of the meeting, Millard. We had a detailed discussion about the recent activity around our association formation, conveyed all the residents.
What is the point, Mr. Kushal? Come directly to
Now, point is, Millard.
Because the 3 specific points have been taken by Ms. Sengupta.
Yes, my point.
The first one is post-election cancellation.
Yes.
Has happened.
Yes.
Second is the ground is
Yes.
bad.
Yes.
Because Bina did not vote.
Yes.
Plus it did
Yes.
not have an effect.
Yes.
And the last one is that the sole member you respondent number 6 wrote as the sole member, which was not dehors statute.
I am on the fraud that has been perpetrated in front of the court, Millard. I will, from the documents, I will prove, Millard. On from the document, that is.
Directly to those documents.
I will,
Don't read
Millard.
the entire thing narrative.
I will, Millard. Lord, will kindly, Millard. Now, I would place reliance on page 48, Millard. I'm not going into that, Millard. My opposition. I'm only relying on my opposition. Lordship will 9. Now see, Millard, the presiding officer writes to the competent authority at page 50. At paragraph 3, members at the meeting, absolute majority, etc. Millard. I'm not on that also, Millard.
These days, whatever you are on.
Interestingly, Lordship will kindly see at page 53, Millard. That's a document dated 5/2024. The second paragraph, Millard, I will read the first 2 paragraphs, Millard. This is in furtherance to the communication dated 27 January 2024, wherein your kind attention was drawn to the fact that a high-handed attitude of the presiding officer in informing the modalities of the election single-handedly, as per his whims and fancies, instead of a collective decision without allowing any member to raise question, etc. Your kind attention is also drawn, the next paragraph, to the fact that the upcoming election has been proposed to be organized in absence of any arrived at decision reduced in writing, and demand the same has been turned down to steer down the election phenomena to suit the erstwhile ADMC headed by his secretary, Shamim Alam. This was given by a list members who wanted to participate in the election, and some of them did, and they won. In spite of...
Mr. Kushal, you are one of the signatories here?
I will just take the instruction. I believe so, but that's my instruction.
What is your name?
Paushali Kole, something. Paushali. No, Millard. There are 3 members who have signed this. I'm sorry, Millard.
At the left-hand margin, there is something also. I don't know what that is. Anyway.
So that is probably apartment cell somebody has received.
Kole is not there.
No, not here, Millard. Lord, you will kindly take page 60 once, Millard. Millard, competent authority, Millard, replies to this at page 60 of that letter.
Yes.
Presiding officer, with reference to the caption subject enclosing the copy. I'm sorry, Millard.
I'm there, yes.
Of the above mentioned letter to the complainant, president of the association is hereby directed to submit a reply, etc. Millard.
This is not the decision.
No. This is in respect to the content, the letter I just.
This is an acknowledgement, yes.
Yes.
Then what happened?
Now, my lord, will kindly. Yes, this when the letter went to the competent authority writes back to the presiding officer, there's certain complaints, please look into it. That is that letter. That will kindly take page 61. Here now the real issue comes in, my lord. That will, this is the modality of the election that was decided, my lord. That will kindly straight away come to voting process for manager, column 3, Roman 3.
Yes.
Voting will be done in person.
This is also annexed to the writ petition.
Yes, why I am saying this. Voting will be done in person only at the same time. No online or other modes are allowed, full stop. Except those more than 80 years old and completely unable to walk to the election area, full stop. If he stroke she wants his caste, may contact the facility office by 8th March and give his name for casting the vote. Accordingly, EC members will visit the flat personally and will have his vote in a closed envelope. This is the interesting part, my lord. Now, Lord, will kindly take the next page, the typed page, my lord. No.
What is the number of the page?
Page 63. So, my lord, what I understand from the rules, my lord, is the person who wants his vote to be collected for home collection will write to the facility or whosoever or to the EC, and EC will go and collect. That is what I understand from the rules. And above age 80. Now I come to Veena Singh. Veena Singh firstly is not 80. She's 46. Lord will kindly see who is writing this mail. STRRA. To Siddha Saidul. Hello, team. As requested by the resident, you are requesting you to provide the detail to EC to collect her vote from home. Lokshi will take the affidavit in opposition reply filed by the election presiding officer. Who is writing this mail, my lord? Shamim Alam. Is Shamim Alam a member of the election committee? No.
They are only requested to provide detail to
Cannot. We can't.
What is the bar?
There is
somebody, anybody and everybody, Mr. Ghoshal, can request this EC that please go to her home and take.
No. He or she wants to cast
What
this
turns
vote.
on this, Mr. Ghoshal? What turns on this?
The turns, what turns on in this is that Shamim Alam tried to manipulate the election. Roshi will kindly say, if I go by the rule.
One voter, Veena, because they will.
Yes.
EC will go to. He did not collect the vote. He asked the EC to go and collect. So if Veena was of the opinion, she wouldn't give the vote by.
May I understand, my limited understanding, Millard. What I read from the rules, I will go by it, Millard. It says if he or she wants to cast her vote, will inform. How can Shamim Alam on behalf, if I want to cast my vote, I will go
from through somebody?
What is the authority letter? Has they annexed a single page?
What turns on this? Suppose he did this, dehearts this law. Then what depends? I mean, the results of the election depend on this. It vitiates the election.
You are asking for the home ballot where I have not authorized X to go and collect it on my behalf. I have not authorized.
This was the only ground of vitiating?
Yes, only ground for cancellation. That is the reason. That is the reason his candidature got cancelled. Interestingly, when all this, a lot of things have been said, he has been put in a room, etc. There were police personnel present on the day of polling. Was an FIR lodged? Answer is no. Did any other member lodge an FIR saying that there has been a ruckus and I am feeling uncomfortable? No. Did the police started an investigation with regard to the ruckus in the election? Answer is no.
Very good. Yes. What else?
Lord, will I kindly take page 64 once. This is the document which my learned friend has showed. Veena writes first that I have not voted. Then Veena writes again, I have not requested, authorized Shamim Alam to send any email. This is where this is the reason Shamim's candidature got cancelled, my lord. This is one of the main reasons. I cannot, my lord, project myself to be a messenger of somebody who has not authorized me. It is like going and casting a postal ballot vote of somebody who is in an election duty and casting a vote which in turn mandates false voting, my lord.
What else, Mr. Ghosh?
Let me kindly take the next page, my lord. Raman Singh writes to the presiding officer, husband of Beena Singh. The second paragraph, to my surprise, it has been brought to my knowledge that the above mentioned email has been sent by Shamim Alam as accepted by the presiding officer of the Election Commission. It is astonishing that the EC did not bother to verify this with either me or my wife, although all channels of communications were open.
EC had collected the vote of Veena?
No. EC had gone and she said that I will not vote. But this act,
very well, Mr. Ghosh, I get your point.
This act, I am on the conduct. Person who seeks equity should come with clean hands. This is the conduct of the writ petitioner. Interestingly, I will show the affidavit in opposition. There are documents, there are conflict of interest. One of the residents, who is an appearing counsel advocate over here, she was also a member of the election committee. Can she do this? A serious conflict of interest. I'm not taking the name, I will only show the page. Amongst us. So this is where we stand today.
Mr. Ghoshal, if a person, if she was a judge, I could have understood. What is the, if a person can appear in person and project her own case? Why?
She is not projecting her own case.
She is a member of the association. Of what?
Of the election committee. She resigns from the election committee and then she accepts the brief of the presiding officer. Is it not conflict of interest?
Have any solid points, Mr.
These are all
in your written notes of Argo.
I will. These are all disputed questions, my lord. And my lord, I still again come back to this, my lord. If there are disputed questions, my lord, can my lord, the writ court intervene into this, my lord? Go into this. Somebody has gone, somebody has not gone, my lord. All these are subject matter of trial. And the act does not have any progressive control with regard to any association for that matter. It says you need to do certain things and it stops there. There is a power to remove difficulty under bylaw 39 of the bylaws. Interestingly, they have written to the authority, competent authority. Competent authority has not interfered.
They have written.
They have written. What I find from the affidavit of the presiding officer, not the writ petitioner. They have written. Now, interestingly, they have not gone into that. So today, all these questions, all these issues, my lord, I will only highlight only one short line paragraph of the judgment I have already given Alipur Bar Association, my lord.
Yes.
Paragraph 23, my lord. Para 22 and 23, my lord.
Yes.
And also paragraph 11, I will go through it, but these are the two paragraphs I would like to cite, my lord. Having held that the writ petition under Article 426 against the Bar Association is not maintainable, saving the exception discussed supra, we do not propose to embark on the decision regarding the merit of the case. The appeal is therefore allowed and the interim order is set aside. The writ petition having held to be not maintainable, all the orders passed in the writ petition and the interim order passed in this appeal become non-est in the eye of law. The election having held as per the schedule in the notice dated 27 to 2024, the result of the election be published by the election officer forthwith. Any party aggrieved by the result of the election or any party desirous of raising an election dispute, if so advised, may move to the common law forum, competent civil court for redressal. But this has been passed by a division bench, my lord, dealing with regard to an election of a body which is registered under the Societies Registration Act, my lord. Para 11 they have mentioned, my lord. Now today, my lord, where we stand is
This is also under the registered under the Society Registration Act.
West Bengal apartment ownership at almost parimeteria, my lord, almost parimeteria, my lord. So this is the teeth and substance, my lord. Today, my lord, lordship will kindly see. But my junior says that I should read out paragraph 11, my lord. I will take 1 more minute, my lord. Coming to the fact of the case, it is admitted at the bar that the Alipur Bar Association is a society registered under the West Bengal Societies Registration Act. It is neither a creature of any statute, nor it is discharging any statutory duty. It is an association of advocates working in the vicinity of Alipur Court and other areas. The articles of association or the bylaw of the Bar Association on perusal does not reflect any public duty to be performed by the Bar Association, except the fact that it is an association to maintain discipline regarding payment of enrollment of fees, etc. Here, pausing here, my lord, this association is also not discharging any public function. It is for the recreation and management of the internal society, hosting Durga Pujo, Kali Pujo, Dol Utsav and all Rabindra Jayanti, maintenance, etc. my lord. No public functions, my lord. It is an I'm sorry, my lord.
Public law element is not there.
There's no public law element, my lord. Nowhere in the article of association or the bylaw any statutory direct duty has been enjoined to any of the members, office bearer, or committee of the Bar Association. It would be gainsaid that election to any of the authority coming within the ambit of Article 12 and discharge of public duty by such authority are two different things. To our knowledge and experience, we have seen election dispute relating to election to Senate and syndicate of government universities used to be filed in civil court for the simple reason that the complexity of the issues that may arise in an election dispute jurisdiction under Article 226 of the Constitution of India is not an appropriate jurisdiction to come to a just conclusion and to do complete justice. If therefore, if there is infraction or arbitrariness in discharge of public duty by an authority coming within the ambit of Article 12, necessary and competent remedy is the petition under 226 of the Constitution of India. But so far as the election dispute is concerned, we do not think the High Court is competent authority to delve into such issue. We shall elaborate our decision through discussion of the judgment cited by the counsel. Now here, my lord, even in this pretext, my lord, I will, my lord, what has fallen from the Honorable Division Bench, I will, my lord, join issues here. Because there is no public duty, no public function, and the authorities also have no pervasive control. Authority under bylaw 8 says that you do certain things in a certain manner, and then the curtain drops there. They become functions of issue. And now, what is the relief sought? Relief is not sought in the writ petition in the prayers against the competent authority. A relief is sought against the presiding officer who is a private individual. He has not taken or put on a cloak of a statutory authority by getting delegation of power from the competent authority. Is not the case. It was never the case. So, how can, in a writ, somebody comes and seeks cancellation of election or counting or whatever by way of a mandamus against a private individual? Those are my submissions, my lord. I will, and disputed questions, my lord, I will not trouble, Lordship will, the judgments are
That's
there.
also there in parallel.
Yes, yes, lord.
And otherwise also that's settled. If it's a disputed question of fact requiring evidence, then it could.
Yes, 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 yes.
There are a line of judgments, 1 or 2 judgments, recent judgments. Writ court should not shirk its duty merely on the ground that it's a question of fact. But if evidence is necessary, then definitely that applies.
Precisely here, I rest my
Settled
case,
law,
my lord.
settled.
Deeply overwhelmed, my lord. I'm sorry, my lord.
Can I just take your lordship to the my affidavit which I
I'm sorry, my lord.
Cannot be free for all, Mr. Rai. You have made your submissions, nothing further.
paragraph numbers.
Form sheet has not been submitted.
Put it in a written notes of arguments. I've told you.
In my opposition, my lord, I will also, my lord, I will not trouble your lordship, my lord, page 20, my lord, paragraph.
Yes, what have you said there?
Yes, my lord, double U and double V, my lord. This is, my lord, double T, W, and double P. My lord, these are what we submitted. The form 3. The form 3 was sent by the election officer, whosoever was there, my lord. Now, interestingly, is my lord, we also had wrote to the presiding officer regarding certain things, irregularities, my lord. We did. We also did, my lord. It is not, I will be candid.
Post-election, can it be cancelled? Can a candidature be cancelled post-election after the election is held? That was the first point taken by her.
The results, the election procedure is concluded after the declaration of results. Now, during the continuance of the election, if something surfaces, but I have little experience in election, not much, but I have come across situations, my lord.
You have got experience from the other end, from the end of the executive. So you are amenable to the jurisdiction on your experience. Yes.
But there were situations, my lord, when candidates tried to, my lord, force and enter into polling booths, my lord. The presiding officer has the power.
During the elections, candidature can be cancelled.
Yes.
Before declaration of the result.
Yes. And my lord, why I say this, my lord, there were instances where somebody tried to, my lord, infiltrate the polling booth, if that's in a panchayat or some elections, my lord, many years back, my lord. The presiding officer has all the powers to cancel the candidature then and there, and send a report to the returning officer.
In this case, who cancelled the candidature?
The presiding officer cancels.
He says he was forced to.
No complaint lodged.
That's a disputed question.
Yes.
Very
Requires evidence. Reena Singh's point is also that
what is
Reena Singh is not a party. I'm saying so much.
What is your answer to the other issue? Is sole member of election team, can he do it? Can he send?
Millet, until and unless, Millet, everybody has resigned, Millet. And what are the reasons of resignation?
Everybody had resigned here.
No. No.
Then can one sole member of the election team send it?
Technically, yes, Millet, because the election commission of India, Millet, during the pendency of this election process, 2 of the election commissioners, Millet, Lordship was resigned. Even then, the notification went through immediately after reappointing 2 other members, Millet. The election member could have reappointed somebody, or he could have taken the honors because the elections, voting pollings were concluded and results were to be declared. Except Magnolia, he sent everything. He did not send Magnolia. There was nothing wrong on his part. He did not send Magnolia.
So Magnolia was sent with your name.
Magnolia was sent, but because I was the only person.
He did not send Magnolia. Then there would not be an issue. Your name was sent for Magnolia.
Yes, I'm sorry, my lord. I stand corrected. So today, this is where it stands. Huh? So these are the discussions, my lord. I will file a short note, my lord.
Yes. Yes. You're for what? Competent authorities. What is your version?
Dispute and takes that
Tell me your point, Mr. Bushonli. Don't develop it here.
We have acted on the terms of the court order. Ad hoc committee has acted upon, Miller, and we have followed that. And not only that, Miller, say as per each Miller, the dispute is interstate dispute is between the 2 groups, Miller, in that Miller, the groups, Miller, flat owners association. What the competent authority will do, Miller, here? They have already entrusted them to proceed with the election and all. Now, if they are unable to complete it, then competent authority has nothing to do in that regard. And we are just the custodian of that documents, as far as this form 3 is concerned. That has been recorded in Rule 8.
Let me hear the reply. Yes. Reply.
Lord, first of all, according to my learned friend Milord, that yes, the petitioner made the request, but petitioner was not the decision-making authority to decide that whether the election commission team will go for collection at home or not. Petitioner just requested as secretary of ad hoc committee functioning.
How do you deal with no public law element being involved here?
Yes, I'm coming to that, Milord.
That is the most important point.
Yes, the first point is that the petitioner made a request But petitioner was not the decision-making authority. It was upon the presiding officer whose name was approved by the competent authority. They were sent to the competent
Let's say
authority.
you made a request on behalf of somebody, Shamim. Yes. On behalf of the respondent of 7, on behalf of the petitioner.
On
But
behalf
the
of
petitioner and her husband later disowned that they had given you any authority.
my lord, this is
Why not for that conduct your candidature should
my
go?
lord, this is after election. And also, Lordship, kindly have a look to the letters, the following letters. That first, the Bina Singh said that I did not.
I
go
did
for-
not make any request. Husband expressed surprise. He also reiterated.
I did not make any request to Sami Mahmood. Not it was not said that I did not cast his vote. The respondent number 7 said that let's just kindly have a look to her conduct. That he said that I went there when the presiding officer refused to declare the candidature as cancelled. I again went to Bina Singh and took another letter from him.
Whatever
that I
they
did not
did, that
submit.
does not mitigate your offense in
My lord, this is-
representing that
My lord,
she had requested through
My
you.
lord, yes, my lord, on the last occasion also, when this ad hoc committee was also elected committee in 2022. Now, my lord, this ad hoc committee election, the Bina Singh also requested Sami Walom that I have a sinus problem. My husband is not staying here. So kindly ask them to take my vote from home collection. And then also, Sami Walom made the request and Bina Singh gave it. My lord, same thing, my lord, in 2022 and 2024, in both the years, Veena Singh verbally requested Sami Walom.
I hope that is in there in your reply.
Yes, my lord.
Which page?
My lord, it is, my lord, I have made this at the annexed with the presiding officers because they were sent to the presiding officers, opposition, affidavit in reply, page 66. And I have also made.
Your reply to opposition of 4.
Oh, yes, I have also here. My reply to the in both the places, it is there.
I've taken up your reply to respondent of 4. Which page?
Yes, my lord. Just a minute, my lord. এক সেকেন্ড খালি আমি একটু দেখে নিচ্ছি কোন জায়গাটায় বলেছি ওটা বলেছি তো বটেই অ্যানেক্সার করা হয়নি বলা হয়েছে Yes, my lord. Paragraph 11 of my reply. Page 6.
Reply not to respondent of 4. Then to respondent of 7.
7. My lord,
You said I repeatedly asked to reply to 7 or.
Respondent number 7. I'm sorry, my lord.
No, it's all right. So respondent of 7, para 11. That
Para
reply.
11.
Yes. Very good.
My lord, I state that Mrs. Veena Singh also requested the petitioner in the last election of ad hoc committee held in 2022 to take her vote by home collection. And the petitioner also sent an email to that effect and her vote was collected by home visit. No problem arose in 2022 election. Mrs. Veena Singh also cast her vote by home collection this year too. The request was forwarded by the petitioner before the team.
I've read it.
Yes,
Shamim.
and
Very-
annex, I also annexed page 44, both the letters. So, my lord, this is
I'm really sorry to interject, my lord. Kindly seize page 44 and 45. 44A. 44 and 45A. It's the same email.
Right.
Great.
Anyway, let us continue.
Lordship,
Ms. Shanita,
kindly-
how do you deal with public law element?
Yes, my lord, just my lord, 44A also mentioned that due to sinus problem, she could not come and both the years this request was made.
Seen it.
Subsequently,
Seen it. Seen it.
persuasion made her to be like this, my lord. And public law element, yes, lordships, kindly have a look to this. Yes, my lord, the petitioner, the respondent number 7 has given 3 judgments. One is of Secretary Alipur Bar Association.
Yes.
My lord, this is a society registered under the Societies Registration Act. My lord, there are several judgments that the society is registered under the Societies Registration Act for their internal complaints where no public law element is involved, it is not maintainable. But in this case, my lord, this is not registered under the Societies Registration Act. My lord, the provisions in the Apartment Ownership Act are not pari materia with the Societies Registration Act.
What is the public function you discharge?
The public function, my lord, the public function is that the total election is held under the statutory rules. The statutory rules is the bylaws of 2022. So when bylaws 2022 does not provide for cancellation of candidature after election, when that has been done, then verbally, there is no order from the presiding officer. In fact, total thing was done due to indecision of the presiding officer. The presiding officer did not pass any order. Just to avoid the mob and heckling, after 4:30 the election was over. At 10 at night the counting was done because they did not allow the presiding officer and the election team to count any of the ballot boxes. And so the public law is here when there is a rule in this field, that is the bylaws, and the bylaws does not provide for cancellation of candidature,
Right.
then the cancellation is bad and is really attracts the public law domain. Milord, kindly have a look to the act. Milord, this is not under the Societies Registration Act, does not give, in fact, give an unfettered power to the registered societies because they are governed by their own bylaws. But these apartment association, they are governed by bylaws which are statutory
Yes, of
bylaws.
course, you place the provisions also.
Yes, my lord.
Yes, elections.
Well,
Yes.
these are the statutory bylaws, and the bylaws of the society under the Societies Registration Act is not a
Understood. Need not
statutory
repeat,
bylaw.
Ms. Sengupta. You have repeated,
No, I am not
repeated
repeating.
thrice.
I am not repeating.
Yes.
It
So I
is
get your
repeated.
point. So I'll close the arguments on this.
Yes, my lord.
When can you file your written notes of arguments? How soon? Bullet points. Soft bullets.
16th bullet.
16th one.
Because my
Today we are on 6th only. Why 10 days? File it in 3-4 days. I mean, I can take it up at best next Monday.
Monday.
Next Monday, you'll get the
Next Monday.
Wednesday also.
Yes, ma'am. Next Monday.
Heard oral arguments of the parties, full stop. The matter shall be placed in the list on May 13, 2024, under the heading to be mentioned for the purpose of filing of written notes of arguments and conclusion of hearing.
Well, at 2 p.m., my lord.
Pardon?
Today it is at 2 p.m. So, my lord, on that day also at
No,
2 p.m.
to be mentioned in the
mentioned early in the
written
morning.
notes of arguments, it will be over.
Deeply obliged. ma'am.
Thank you. Thank you all. Yes.
So,
No question of any trouble at all.
deeply obliged. I appear along with Mr. Chatterjee. and
ওইটা তো
Mr.
আমাদের।
Point. Which has come from Bina Singh, that is also Nawab Bina Singh. Because the body of the letter does not, my lord,
Then
does
it's
not
due date.
signature.
It should go to a suit court first.
Absolutely.
Going on to all these things.
Definitely put it in a written note.
Absolutely.
Each point succeeds.
Absolutely.
I shall not, I shall not.
I have never heard it, my lord. I will put it. Deeply obliged.
Next.
Funny, that is my. I did 31, but I could not get the chance to get the matter. Well, and if it is any
No, Mr. Hati. No, Mr. Hati. No upgradation. Next.
Lordship.
Any original side mentioning?
Lordship, apologies to trouble your Lordship. Lordship, on Friday at 4:30 p.m., your Lordship, I mentioned before your Lordship.
Yes, you mentioned.
Lordship, I mentioned before your Lordship regarding a matter which was missed by because Mr. Mukherjee couldn't appear, and the matter was sent to the monthly list. Lordship, it's appearing on 1513, and the Lordship, it's very urgent. Your Lordship, on that day.
That is an appellate side matter. Again, you are mentioning at the original side mentioning time.
Lordship, the appellates are the court officers are present here.
Next,
Lordship.
call on the list.
The original side mentioning.
Yes.
Lordship, I was
No appellate side mentioning at this hour. Definitely
Lordship
not.
was present in the morning, your Lordship.
Yes, Mr. Banerjee, what is your mention?
Item number 34 of today's original side list. Lord, in the unlikely event it's not called, if it could be given some precedence, I'll tell you.
That is more unlikely.
But there is an order by which the West Bengal Housing Board has to give 2 tanks of water to the Housing Association. Every day I spend 400
More
rupees.
urgent matters are being refused now.
Lord, from my
No, this upgradation creates a ruckus, Mr. Banerjee. Every day they will be mentioning no. I'll take up in due course. Yes, call on the list.
May I have Malad's kind, Malad, to mention Malad item number 6 of your lordship's list, Malad.
Yes.
Malad, the matter has been is listed today, Malad. If the matter could be posted on Thursday, Malad, 9th of
You're
May.
for the other side.
I'm appealing for the petitioner, my lord.
Malad,
Agreed.
Since it's on the personal ground, I'm not objecting.
When should
but
I keep it?
My lord, in this
Thursday,
matter,
Malad, 9th
here
of
also
May.
adjournments have been taken. So I was just requesting, my lord, if this
Thursday then?
at least the matter could retain its position on
I
Thursday.
cannot assure that. It will, yes, in the hearing list, it will be in the same, I mean, order. 6th act order record koro. The matter is taken out of turn on being mentioned for an adjournment by the petitioner, full stop. On the prayer of the petitioner, let the matter, on the prayer of the petitioner and on consent of,
Malad, it will be respondent number 1.
Respondent
Prayer of
number
the-
1, my lord.
sorry, on the prayer of the respondent number 1 and with consent of learned counsel for petitioner, let the matter stand adjourned till May 9, 2024. Hearing এর এই পজিশনেই থাকবে ওটা।
Grateful,
My
Malad.
lord.
Thank you.
Deeply obliged.
Call on the list.
Item number 1, court application.
Yes.
Vishwambar, Saran and another versus Central Bank of India and others.
Yes.
My lord, I appear for.
Another LSC issued.
No, no, my lord, this is, my lord, this has come, my lord, these are the two matters. Lordship would recall, Lordship had passed an interim order in one, which was, my lord, a challenge to the review committee order, where, my lord, at the preliminary stage, we had shown to your Lordship, my lord, the reasoned order had not come. Then my lord was pleased to stay the operation, and with the direction upon the bank, my learned friends fairly submitted they would provide us the order. The order has come. Lordship had given the liberty, my lord, to file a supplementary affidavit and challenge the finality. We have done so, but I must indicate it was served 1 day out. The affirmation was 1 day delayed. And my lord, the other is, my lord, this was from the review committee. And my lord, an earlier challenge was made, my lord, to the identification committee report, which was, my lord, pending before Justice Sarkar, my lord, Shampa Sarkar. So, my lord, we have got that since, my lord, the review committee challenge was there, and my lord, now the regular determination is there. That has been released, and that's, my lord, the two matters are, my lord, all connected with the same plan.
Good.
Lord, item 1, in fact, is the is 633 of 2023, writ petition 633. That is, my lord, the challenge to the first committee's report.
Which one you are first taking?
Item 1.
You have felt the You have felt the side. Yes. So would you like to move the IC challenge first, the first committee challenge first?
My lord.
Well,
My
if
lord.
that goes, the RC
Yes,
also.
my lord, everything will go because, my lord, in the review committee, my lord, the challenge to the review committee is not much. They have not given any reasons. They have not given, my lord, they have not even quoted the finding of the independent, the identification committee. They have simply copy paste, my lord, the show cause notice and have said this is a transaction audit report allegations, and they just said that we are confirming it. That's all. And no hearing was given.
Yes.
My lord, Lordship.
So far as no hearing was given is concerned, my learned friend's client, they first immediately against the
First committee.
committee, they filed a writ petition here, and they didn't obtain any stay or anything against that committee order. That's why bank waited for 1 year. They could not bring any.
They did
stay
not
order.
file any representation also, rejoinder.
No, there they have filed.
If
in
they
first
filed,
committee,
why didn't you hear them? If you passed an order, you could-
that after considering order was passed, that identification order they have challenged in first review. This
in
review
any
is waiting
event,
but
Ms.
there
Doshi, I am
was no
taking up the
stay.
first challenge first. So review committee, I'll come later. If they
No, my
succeed
lord,
in the,
what my learned friend is saying that in review committee before review.
I understand,
they-
Ms. Doshi. I am not taking that up on merit. I am not taking his contentions to my mind. First, I am taking up the challenge to the first committee report. If the first committee they win, then second writ
Has to
petition
go.
automatically. And if they lose here, then they'll have to satisfy me. Then I'll hear you on the review committee answers also. Let us hear the first. Yes. Yes, Mr. Chaudhary, what are the?
Well, this Vishamba Saran matters, my lord, arise out of a company called Visa Power. I'll just in 5 minutes give the background. It will come back to your lordship. I mean, admitted position, Visa Power was a defaulter. There was a consortium of bank. The primary business of the company of Visa Power was setting up a thermal power station, my lord, somewhere in Madhya Pradesh. Then, my lord, that they had a coal block allocated. Supreme Court order comes, all allocations automatically goes, and then, my lord, because of that, my lord, in the midst of a thermal power plant which was being constructed, my lord, the main substratum, the coal block going away, company goes into, my lord, dire straits, and, my lord, the situation is beyond repair. Now, Vishamba Saran and, my lord, the petitioner herein is a director in Visa Power. There are proceedings initiated by the consortium of banker in respect of which central bank is also a part of that consortium, having 5% exposure. There are proceedings in the DRT. My lord, in the NCLT, my lord, under the IBC proceedings, in the committee of creditors, central bank is again there. It was being represented by the lead bank. The proceedings in NCLT, my lord, it was at the instance of Bank of Maharashtra. So, my lord, they were at that point of time lead bank. Subsequently, Punjab National Bank became the lead bank. Now, my lord, in the NCLT, when, my lord, the committee of creditors were conducting, the provisional liquidator, who subsequently becomes the liquidator, my lord, appoints a forensic auditor. Now, why I say this? When the provisional liquidator or the liquidator appoints a forensic auditor for the purpose of, my lord, allegations under section 66 of the IBC Insolvency Bankruptcy Code and 45. That is, my lord, fraudulent transaction and preferential transaction and undervalued transaction. These are the three categories for which a forensic auditor is appointed. Appointed at the instance of the liquidator. And the liquidator is representing the entire body of the creditors, committee of creditors. The liquidator is representing that. Now, in that forensic audit report, well, there are 5 allegations which are made against Visa Power. What are the 5? That certain fixed deposits were encashed and the proceeds were given to somebody else. There were allegations that cards were sold at undervalue. There were allegations that there was a tenanted property and you have surrendered the property at not a proper consideration. 5 allegations were there. Now, all these allegations and that report, my lord, we challenged it in NCLT and said that this report cannot be relied upon so far as the proceedings under 66 or 45 or that is concerned. Because this report is only on the basis of mere allegations which the creditors have made to the forensic auditor who has simpliciter collated the data and have come to a conclusion. There is no independent finding either by the forensic auditor or there is any independent material. But our challenge is upheld by the NCLT, upholding 2 things, quoting, my lord, from the auditor's report itself, that the auditor report itself is with the disclaimer that it has not made any independent finding, and shorn of any independent finding, you cannot make out a case under either 66 or 45 or well, that challenge failed. Well, liquidator takes it up in appeal to the NCLAT, which is the appellate authority, and my lord, the appellate authority also confirms the order of the NCLT. So this is where, my lord, the forensic audit report, my lord, comes to an end. But the banks, what they do, right from the lead bank to, my lord, there were 4 to 5 banks, based on the forensic audit report itself, my lord, they initiate proceedings under the willful defaulter scheme. And the allegations are identical allegations to that of the allegations contained in the forensic audit report. Identical. In other words, it is the exact allegation which is there in the report, and on the basis of this willful default, one after other bank, my lord, does it. My lord, we successfully repelled all the banks so far as the other banks are concerned. so far as the lead bank is concerned.
It means the first committee report was set aside.
My lord, repealed means the proceedings at whatever stage, my lord, the proceedings, my lord, it has been quashed and no further proceedings were there. On the basis that you cannot rely on a forensic audit report simpliciter unless you have independent finding of your own, because it is on the RBI guideline. And the forensic audit report was not at the instance of any of those individual bankers. It was at the instance of the liquidator, and my lord, the order of NCLT and NCLAT is res judicata so far as the bankers are concerned, because my lord, in a way the liquidator was representing all the banks. So you are unsuccessful in the proper forum, but on the indirectly you are trying to initiate proceeding through the RBI guideline relying on the self-same report. This is, my lord, the crux. Now, my lord, ultimately after the last challenge made, my lord, vis-a-vis, my lord, Punjab National Bank, who had then become the lead bankers, my lord, when, my lord, an independent decision was asked to be taken and again it was remanded to the identification committee. Well, the identification committee, after considering the order of NCLT of Punjab National Bank, comes to a finding that no, this cannot be proceeded with only on the basis until and unless the bank has some independent material. And Miller, the proceedings for willful default is dropped.
In that matter, those FIRs were quashed also, probably.
No, my lord, FIRs were, my lord, so far as classifying me as fraud is concerned, my lord, the banks had taken, my lord, separate steps, my lord. There are many banks which had taken of their own. I believe even, my lord, Central Bank has also won fraud classification proceedings. We'll come to that later.
Yes.
My lord, here, my lord, banks had proceeded, my lord. There were three-pronged attack: LOC, fraud, and willful default. All three were resorted to by most of the banks. And we have, my lord, been successful so far in, my lord, resisting that. Now, my lord, so far as Central Bank is concerned, this is the fourth round of litigation.
These setting asides were not challenged before it forum?
No. Because, my lord, all the setting aside, my lord, each court, my lord, every time it has been set aside, whether by your lordship's order or, my lord, orders of coordinate bench, my lord, it was actually, my lord, sent back to the committee concerned.
Have independent.
Yes, to give either to consider or to have, if they have any independent material. My lord, willful defaulter, my lord, other than forensic audit report, if they have independent material, they can very well classify me as a willful defaulter. Yes. So, my lord, every court, my lord, everywhere, my lord, the bank has been said that you consider independent material or you consider the reasons that the show cause, in response to the show cause the client has given, and then take a decision.
Right.
So, my lord, when this was going on, ultimately the last, my lord, the lead bank comes to a definite conclusion that no, we don't have any other material other than this forensic audit. This has already been set aside by the National Company Law Tribunal and confirmed by the Appellate Tribunal. Unless and until the bank has an independent material, we are not going to act on this, and the lead bank drops the proceeding. Now, this is the last of the bank. Central Bank is the last of the bank, which continued, notwithstanding all the others. Now, my lord, first time, my lord, it gave a show cause in 2020, which is at page 147. Lordship will kindly come to that show cause. I will only refer to it because Lordship will get the allegations. My lord, that is at page 147. 31st December 2020. But earlier show causes and replies were given, my lord. I am not troubling your lordship. This is the last show cause.
Yes.
In respect of which, my lord, everything emanates, which is the subject matter of the challenge. The lordship will find term loan of 90 lakhs, outstanding 40 crores.
Yes.
Then, my lord, kindly see after that tabulation, with reference to the above, we are giving herewith the reason or justification for reporting as willful defaulter. This is at the show cause stage.
This is the same report, FAR. Deloitte report?
Yes, same. My lord, there is nothing. Transaction audit was given to Deloitte by resolution professional. This is very important. So, bank has no independent finding, bank has not engaged that resolution professional.
No,
Because-
mere engagement, non-engagement by the bank does not mean that the bank does not. I mean, suppose somebody else engaged, then also the report can furnish a basis for
The
that.
reason why I am saying this is,
Yes.
ultimately, my lord,
It was set aside.
ultimately the identification comes to a committee comes to a conclusion that Punjab National Bank may have dropped the proceeding. We have an independent transaction and we have we may have these are separate transactions for which we are holding you liable. That is why I am showing this. The show cause is on the self-same report.
But there are different components. PNB components are different from central bank components in the show cause.
My lord?
The PNB.
No, both rely on the forensic audit report. Everything forensic audit. Well, nothing, no other independent finding.
Now, does the forensic audit report distinguish between the transactions of the petitioner with PNB?
No.
Central bank.
But forensic audit.
There can be separate components. They can be justified.
No. Forensic audit report does not give any report bank wise. Forensic audit report has given an omnibus report, raising 4 to 5 allegations. And that allegation, kindly have a look at the forensic audit report, Lordship will get that idea. Page 229. Lordship will find that the report is of Deloitte, and this is of 24th August 2018. And Lordship will bear in mind this show cause notice is coming in 2020 after the entire chapter in NCLT NCLAT is over. So after the creditors fail on getting proceedings under section 66 or 45 quay the liquidator, they start individual proceedings on the self-same report. In other words, what they could not achieve directly, they try to do it indirectly.
Yes.
Now, in visa power, Lordship will find straight away, kindly come to page 241.
And these clauses are also there. Did not independently verify and all.
Yes.
The usual clauses actually.
Yes.
241, yes.
241, kindly come to observation, then under observation, page 241, Lordship will find under numeral 1, subheading, fixed deposit of Visa Power Limited, liquidated by banks to pay off the loans of Visa Energy Ventures Limited, that is parent company of Visa Power. This is one allegation. This is, my lord, one, fixed deposit of Visa Power. Then the transaction details were given.
What is SBBJ? State Bank of
State Bank of Jaipur.
That has merged with Central.
That has merged with, my lord, State Bank of India.
Very good.
Well, I am not troubling your lordship with the transaction details. Kindly see above that. Well, item 1 lordship has found.
Yes, I've seen that. And transactions are also primarily with Jaipur and
yes.
PNB.
Well, the allegation. Central Bank has nothing. Well, these are all omnibus allegations. And every bank is thinking that my money has been utilized.
Certain details have been given. Transaction details in A under 1. Suppose specific transactions have been referred to. Visa Power Limited had fixed deposit receipt aggregating such and such with State Bank of Bikaner in Jaipur. That's why I was looking into those also. If there is something for Central Bank which can distinguish between banks.
If there is something from Central Bank, my lord, they will come and say they don't have to rely on the report. They can come and say, I had given the money, you have utilized my money to route it to somewhere else.
Even then, this
But
can provide.
Lordship can take it from me so far as this, it does not involve central bank at all.
No, I don't find
Because,
that.
my lord, they were only 5%. The main bankers were, my lord, State Bank of India, Bank of Maharashtra, and, my lord, subsequently Punjab National.
Primarily that, yes.
Now, I am only showing your lordship, my lord, the heading.
Yes, I understand that.
My lord, the headings, lordship will find it is exactly, my lord, the same.
Same as?
Same as, my lord, what is there in the show cause notice. For instance, if lordship comes
Yes, right.
page 247,
Hmm.
item 4, transfer of advance recoverable from Visa Realty to Visa Power Trading Company Limited. And then the transaction detail is there. Now, lordship comes back to the show cause notice, which is at page 147.
Mm-hmm.
Last paragraph. 5 allegations are pointed out.
Yes.
First allegation is, and these all are on the based on the Deloitte report by the resolution professional.
Hmm.
And in fact, they are quoting the observation of the auditors. Lordship will find 147. Some of the transaction audit report was given.
That is admitted. Some of the observations are as
monthly rent agreed for the premises so and so, and so and so. So, my lord, this is, my lord, at
so that the moment they have admitted that I am quoting from auditor's report, so you need not place the corresponding.
Lordship can take it from me. There is no other independent allegation.
Say that, yes. And then the bold letters
after
come.
quoting the auditors from the auditor's report,
Page
there is a
148,
line in
yes.
the bold at
Yes.
page 148. From the above, it is clear that funds have been diverted from the system by the borrower. Then reason and criteria, unit has defaulted in its meeting for payment and repayment, and finance was availed, and so on. Now, my lord, I give a reply which is at page 167. My lord, auditor's report was all along with me. But, my lord, I had asked that if you have any independent document, you please furnish that to me if you are relying on anything else. Now, my lord, this was the reply given on 18 January 2021. I just show your lordship 2 paragraphs. The second paragraph, I have referred to my earlier objection, second paragraph at 167.
No, where was the occasion for an earlier objection? When
Well, there were earlier show cause notices given based on this.
those were set aside.
Those were set aside, or, my lord, they had not proceeded with further.
But you have independently given your reasons here also.
Yes.
Apart from
Yes.
para 2. Yes.
This is, my lord, in response. There is no single show cause which I have not responded. I have responded to all. Second paragraph. It is extremely strange to note that although my letter of 4th November, I had duly responded to each of the allegations as mentioned.
We can skip this because they have obviously given it because of the setting aside on non-prosecution of the previous one. You see, it's strange that I have to write again.
Yes, I have given that.
Previous reply becomes academic.
Yes.
Yes.
Then, my lord, para 3, one thing to be noted, I also find that the meeting of the Empowered Committee and Grievance Redressal Committee are claimed to have been conducted by circulation. Then, my lord, straight away kindly come to. Lord, I have referred to my earlier letters. Now, Lord, here I have referred to the RBI Master Circular. Kindly come to, my lord, page 168.
Yes.
Second paragraph. Further, the Grievance Redressal Committee, although noting that I had provided my representation of 4th, has failed to consider the dealings and objections raised by me in my letter, wherein each and every allegation which were raised by you in support of criteria laid down in 2.1.3b of RBI Master Circular has been appropriately dealt with. By my said letter, I had duly stated that the company in liquidation had received the total loan of 732 crores, and as per fund flow statement attached to the audited balance sheet, the total assets including capital work in progress in the said company was more than that amount. I had also stated that each and every penny received by the borrower company was utilized towards the project. Further, it was also pointed out to me that your letter of 16th December, you have stated that transactions relating to the fixed deposits are not even related to your bank. My lord, exactly what my lord pointed out. And as such, your allegation that I am a willful defaulter on the basis of such fixed deposit is contrary to your stand in the said letter. Then, my lord, I deal with it. I refer to my earlier letters and kindly see the last line. Without prejudice to the aforesaid, you are requested to provide me each and every document and or evidence relied by the committee to enable me a proper effective hearing. If they had any other independent document, my lord, we ask them for the documents. My lord, they don't provide me the documents. Then, my lord, they carry on, my lord. They issue a personal hearing notice, my lord. At that stage, my lord, I come to court. My lord, then comes the order, the first order, page 180. The order of my lord Justice Mantha. Page 180. My lord, we come up at the stage when they, without supplying the documents, my lord, they
give a
fix
notice of
hearing.
hearing. Yes.
My lord, our main grievance is that if you don't give us the documents, it will be an empty formality. My lord, kindly straight away come to page 183. My lord, identification committee had passed a finding in the meantime. I am not troubling your lordship with that since the order is already setting it. Well, kindly straight away 183, last two paragraphs. In that view of the matter is remanded back to the identification committee to consider the representation of the petitioner dated 4th November.
It appears from this that the identification committee had decided in the meantime.
Yes.
So that is set aside, remanded.
Yes.
To consider your reply.
Identification committee shall pass a reasoned order. Any order that may
Absolutely,
be.
Mr. Chaudhary.
Yes.
Yes. To
Then, my
consider
lord,
your reply.
my lord, again, my lord, after this, my lord, another round of hearing with the identification committee, my lord, they try to proceed without, my lord, providing me any of the documents that they are relying upon.
Yes.
Then, my lord, kindly come to page 214.
Yes.
This is the second communication of the committee, my lord, so far as personal hearing is concerned. This is after the order of, my lord, Justice Mantha of 20th May. My lord, lordship will find that at the reference section only.
Yes.
High Court order of writ petition dated 20th May, 214.
Right.
Then, my lord, challenging this, my lord, when they again don't provide us any document, my lord, we again come up before this High Court.
Now, at that stage, the forensic audit report was also not handed over.
My lord, forensic audit report, I had it, my lord, but they are not saying that, my lord, I am not relying on anything else but only the forensic audit report.
Achha.
So, my lord, to cover up, my lord, we had said that you have any other document because, my lord, moment they have any other independent document, I am to meet that challenge. Otherwise, my lord, I fall in the trap. My lord, kindly come to, my lord, the last two paragraphs of page 216. Committee has scrupulously followed the directions of RBI in identification committee on account of willful default, and decision was made clearly on the basis of supporting reasons stroke documents. The allegation that the committee has not considered independently is not based on fact. The decision was taken on the basis of documentary evidence, including transaction audit report. Not very important. So there is documentary evidence and transaction audit report is one of such documents. Then, my lord, the next para.
No, this was the decision of the identification committee. Or what?
Yes, my next para will make it.
Yes.
In view of the above facts and circumstances, committee found no irregularity as alleged by the petitioner in their representation and unanimously decided to proceed with the declaring of willful default against the erstwhile directors, guarantors of the company Visa Power. Representation of 4th November are thus disposed. This is for your information and petition. Now, this, my lord, this communication of 30th June was the subject matter of another challenge.
Justice Sarkar this time.
Yes. And now, my lord, kindly see Justice Sarkar's order. Page 220. Order dated 23rd August 2022.
Yes, all documents are not given, so set aside.
So, my lord, the allegation is that I have passed the order based on entire documentary evidence, including transaction audit report. And my lord, at 226, second paragraph, starting with the word under such circumstances.
Yes.
Under
right.
such circumstances, the order dated 30th June 2022, declaring the petitioner number 1 as willful defaulter is set aside and quashed. The bank shall provide the documents sought for in the representation dated 4th November within a period of 3 weeks from the date of communication of the order. The petitioner number 1 will file a supplementary representation or reply to the show cause notice in addition to the representation of 4th of November within 2 weeks. Identification committee shall decide the issues in terms of 3B of the mechanism of identification. Once such exercise by the identification committee is completed, the provisions under clause 3C shall be set in motion. Petitioner number 1 shall make himself available for a personal hearing, so and so, so and so. Court has not gone into the merits. Now, let kindly see after this, the compliance is page 228. What they give us are two documents. Number 1, Lordship will find at page 228.
That is the forensic audit report.
Copy of forensic audit report 229, which was always there, and I have also communicated on that.
These 2 minutes of the meeting?
Minutes of the meeting to examine and identify willful defaulter, my lord, that was also, my lord, always there.
That was an internal meeting prior to
56.
identification committee
Yes,
order.
the review committee meeting. I am sorry, my lord, the grievance committee meeting. 256, Lordship will find that. Because, my lord, this document was an enclosure to the show cause. Well, the show cause that I showed to your lordship at page 147, well, it is an enclosure to that.
But this is an additional document.
No, this was there as an annexure to the show cause.
Oh,
it is also there at page 150 as an annexure to the show cause.
very good.
So both these documents are there with me. Other than these two, there is no other document. But my lord, I showed your lordship the earlier committee report finding was on documents including this.
Yes.
So now, my lord, after Justice Sharka's order, we come to a point where there is no other document other than the transaction audit report. Now, after this, my lord, we write a representation at page 260. In fact, my lord, I was given a hearing and I write a detailed reference. 277, lordship will straight away come. 277. Oh, yes, my lord, in fact, I stand corrected. Kindly first come to 260 and then come to 277. Just to show, my lord, in compliance with, my lord, Justice Sharka's order, my lord, I give the representation and I also make a supplementary representation in apropos after receiving the documents.
Right.
260.
Where you obviously reiterate.
Yes. My lord, I reiterated and now, my lord, I give a detailed reasoning again. Apropos this, dealing with the merits also. And then, my lord, we quoted from the transaction audit report, extensive quote that the auditor's report, the disclaimers and also on merits, and then, my lord,
Page
260. And then, my lord, I go there. I'm sorry, I did not go there physically. Virtual hearing, my lord, I attend. And, my lord, whatever transpired in the virtual hearing, whatever submissions I made, I put it in writing, which is at page 277.
What is page 264?
264, I'll come back. In the meantime, Punjab National Bank, I'll come back to that. All right, since my lord is at page 264, Kindly see, my lord, this is
There the PNB dropped it.
9 December 2022. My hearing is in January 2023. December 2022, the lead bank drops the proceeding.
November 20.
Yes. Well, this is important because
Yes.
my lord, lordship will find in 264, 9th November letter, lordship will find the last paragraph. Sorry, the second last paragraph.
264.
264. In the middle, lordship will find three names have been written: Visa
Yes,
Power,
yes, yes.
Vishamba Saran, Vikas Agarwal. After that, lordship
Right.
will find show cause notice was issued. Kindly see the allegation. Diversion of fund as per transaction audit report of Deloitte. Following instances were observed. Visa Power had paid advance so and so. Then siphoning of funds. Kindly see. Audit report found fixed deposit of Visa Power were liquidated by banks.
Yes, same, and the second last paragraph of page 265, Mr. Chaudhary, I've seen.
Yes,
So that
unauthorized
is-
so and so. And then, my lord, kindly come to 266.
Right.
The order of the Committee for Identification of Willful Defaulters.
Right.
The Identification Committee headed by the Executive Director consisting of other members, that is General Manager and Chief Deputy General Manager, on the basis of deliberation and records available, decided to drop the present willful default proceeding against the borrower and directors, that is Visa Power, Vishamba Saran and Vikas Agarwal, with liberty to zonal Shastra to re-examine the willful default aspect in account of the basis of independent documentary evidence, if any, which proves willful default as per RBI circular. This supersedes the order of identification committee, so on. And lord, the reasoning was, my lord, the setting aside in NCLT. That lordship will find at the immediately preceding paragraph, my lord, page 265, last paragraph. Deliberation
Yes,
of the
second
committee.
last and last paragraph. Right.
So, well, this comes in December 2022. It was in my hand. It's a 9th November order, which comes to me in December. So, when the hearing of central bank takes place, well, in the hearing, this order is placed that, look, the lead bank has already done this, which was leading your consortium. Well, that I have also recorded. Now, if lordship comes to page 277, because, my lord, there is no recording as to what I am submitting. So, my lord, after the hearing, which was by video conference, I wrote a letter and I recorded and I sent it, which is of 16th January, my lord, I write it. 277. The second paragraph. I appeared before the said committee today pursuant to your notice and the order passed by the Honorable High Court. Then kindly, at the outset, I feel extremely humiliated, so and so. Well, he says that it is not a willful default, but the project failed because of the Supreme Court order. And then, my lord, after giving the reasonings, which I am not troubling your lordship, my lord, kindly come to page 279, last paragraph or the last two lines.
Yes.
I may now also add that Punjab National Bank, the lead bank, having exposure of 20% in VPL on the basis of this very report of Deloitte, had formed prima facie opinion on willful default. However, upon submissions made on behalf of the company in liquidation, the Identification Committee of PNB has taken note of the order passed by the National Company Law Tribunal, Kolkata bench dated 25th July 2019 and affirmed by the National Company Law Appellate Tribunal, New Delhi, and dropped the willful defaulter proceeding with its letter dated 9th November 2022. And I also rely on the same. Copy of the letter of 9th November of Punjab National Bank is attached. I also rely upon each of the objections submitted by me earlier. So, my lord, other than on merits and my earlier representation, this was also the additional. Now, kindly come to the impugned order of, well, it is communicated to me, it is at page 283, but the communication letter is at page 281. The 21st February 2023 letter communicating. This is the, I straight away come to the order, my lord, because the order has been annexed. 283. Heading minutes of, my lord, the meeting starts at 12:25 p.m. My lord, the persons present have been mentioned. Then lordship will find, this is They have recorded what has transpired
Narrative
earlier.
of the previous events.
Yes, 284, Lordship will come.
Yes.
Second paragraph. Mr. Saran, Director, Mr. Agarwal and Shubroto Trivedi attended the personal hearing through VC on 16 January 2023. Then the following three are present. Chairman of the committee inquired why the company, its directors or guarantors should not be declared as willful defaulters based on the transaction audit report or reasons recommended by the department as under. And my lord, the reasons are, my lord, verbatim copy paste from the transaction audit report. Nothing new has been there. Then my lord,
And the
after
show cause. And the show cause.
and the show cause. 285 Lordship will find.
Yes.
Mr. Saran informed the committee he has submitted a detailed reply to the bank through various representation of 4th November, 4th December and 13th September. Also, he informed the committee that the transaction audit report prepared by the auditor is inaccurate, non-conclusive and cannot be relied upon in a proceeding as declared by the auditor itself. No independent examination and or finding has been arrived at by the bank, which is completely contrary to RBI guidelines. Further, he informed that the Committee for Identification of Willful Defaulters at Punjab National Bank on 9th November dropped the willful default proceeding against them and re-examined the willful default on the basis of independent documentary evidence. Copy of the representation of 13th September of Saran was placed before the committee. Reply representation of 13th September reads as under. Then, my lord, they quote my September representation verbatim.
Yes.
280
At page 287, they have also taken note of those clauses, disclaimers.
287, it is quoted verbatim, my lord. It's a copy paste.
So the declaration, the
Right up
disclaimers.
to 288. First
87,
paragraph.
the disclaimers have been quoted.
Yes, yes. They quote it verbatim, my lord. Entire letter
Oh,
quoted.
right.
Up to 288, first paragraph.
Yes.
Then, my lord, after the first para, there again starting from the perusal of the aforesaid clauses, it is evident that transaction audit report prepared by the auditor is in. This is also, my lord, part of my report.
No,
Non-conclusive, this is mine. No independent so and so. Then, my lord, committee's observation and comments. This is the only finding they have. Three findings.
Yes.
Committee analyzed the reply representation and made the following observation. Mr. Saran has submitted that the security deposit paid for the premises is a recoverable security deposit and was not paid out of finance received from the lenders, but from surplus fund generated through equity infusion. Also, the alleged relinquishment of the right to furniture is not utilization of finance received from lenders. The FDRs referred were not created out of finance received from the bank, but out of the bank guarantee amount furnished by L&T. And similarly, capital amount was not paid out of the finance received from the bank. It is observed that the contention made only on general terms without submission of any proof of evidence.
This was on diversion of funds.
Yes.
Siphoning and
Well, at fixed deposit is with a nationalized bank. Security deposit is refundable by the landlord. And when this is there, at no point of time, they said that you corroborate this because, my lord, before the NCLT, all the documents were furnished. This being the allegation, all the documents were furnished. Well, the second is, my lord, more bizarre. Kindly see item 2. Borrowers on receipt of requisite relevant document as required in the representation have only put forth. In general, that transaction audit report is inaccurate, non-inclusive and cannot be relied upon, but has not submitted any foolproof document in countering the specific allegation leveled by the bank. There is no specific allegation other than transaction audit report. And item 3. Contention of Mr. Saran that Committee for Identification of Punjab National Bank has dropped the willful defaulter proceeding against them and requesting the bank also to drop the proceeding against them on similar ground is unacceptable, as the order of PNB will not be binding on other banks. Will it agreed? And moreover, the transaction may not be similar and may entirely different of each of the banks.
But surprisingly, I did not find any reference to any transaction with regarding central bank at all.
Well, at central bank, no transaction is there, but kindly see the last line. Transactions here may not be similar and may be entirely different with other banks. They have no other transaction at all.
That's exactly why I said that, because this might have been valid if there were certain allegations
That
vis-a-vis
is why, my lord, we also insisted, because, my lord, we are aware
documents, more
that last minute, my lord, something will spring up, a document will be sprung and say, on the basis of this, we are condemning you. So, my lord, we were categoric that you provide us whatever you are relying upon. Now, after Justice Sharka's order, it is categoric that they don't have any other document other than the Deloitte transaction audit report. And, my lord, that has already been, my lord, kindly have a look at the NCLT order just for completion.
the one setting aside the
Yes, page 42 it starts. It's an order of 25th July 2019. That is prior to the show cause, which is in 2020.
Yes.
Show cause is 31st December 2020, 1.5 years earlier. My lord, after, my lord, the company law appellate tribunal affirmed this order, my lord, they really, my lord, to pressurize us, they started independent proceeding.
Mr. Chaudhary, at page 43, the date of the order is blank. I mean, what is the
My lord,
date?
it is 25th July. Lordship will find that at the last. My lord, I don't know why. Yeah, in my copy it's blank. At page 54, my lord is pleased to come to 25th July. Now, my lord, in this,
Yes.
let kindly come to, just to show, my lord, what is the similarity. Kindly come to paragraph 4. The liquidator received audit report.
Yes.
On the basis of that report, he filed this application. And, my lord, when the liquidator here is, the liquidator is representing collectively all the creditors, including Central Bank of India. This order is binding on Central Bank of India and is res judicata so far as all the banks are concerned. Which is one of the reasons, my lord, PNB also dropped it. They can't, my lord, what they directly could not achieve, they can't do it indirectly. The tribunal and the court is saying this cannot be relied upon, and, my lord, the bank officers are saying, no, this is what I am condemning you on this. This is, my lord, the irony of the situation. So, my lord, this is para 4. Liquidator broadly lays questions about 4 transactions. Well, kindly see the 4 transactions. Page 45, Lordship will find in the first paragraph itself, part of para 4, under Roman 1, Roman 2, Roman 3, and Roman 4. Roman 1 is liquidation of fixed deposit by the corporate debtor in order to pay loan of other company, Visa Energy. Item 2, security deposit recoverable from Visa Energy Venture by corporate debtor, which respondents failed to recover. Item 3, transfer of advance recoverable by corporate debtor, which was assigned to Visa Realty, and then sale of vehicles to related parties. Then, my lord, allegation was 144 crores of fraudulent transactions are there, and these are the 4. My lord, after this, straight away, kindly come to page 47, para 9. I heard learned counsel so-and-so and so-and-so for respondents and heard so-and-so. I have gone through the record. Then, the submissions are recorded. Now, kindly come to para 13. The learned counsel brought to my notice the explanation offered by the respondent numbers 1 to 3 to the auditor's report. Then explained each and every point called in question. He submitted that all transactions were bona fide. It cannot be said that the respondents, when the respondents did those transactions, they had foreseen the corporate debtor would be pushed to CIRP. It is his submission that order to direct the respondent to pay such huge amount towards contribution without there being any evidence cannot be passed. Only on the basis of the inconclusive audit report to substantiate, my lord, case law. Then, my lord, the independent findings come in para 14 onwards. There cannot be any dispute about the fact this application is based only on auditor's finding in his report to the liquidator. In para 2 of the application, the liquidator made it clear in the following words. Well, then part of the report is quoted. Para 15. It appears that the liquidator made allegations against the respondent that they did some fraudulent, undervalued or preferential transaction only on the basis of observation of the auditor in the forensic report. Copy of the report is produced as Annexure 4. Perusal of it shows report does not support the contention of the liquidator that the auditor has observed that the transaction in questions are either undervalued or preferential or fraudulent. It has been observed by the auditor as follows. My lord, over here, my lord, the disclaimers that we did not independently verify and all these are quoted, then kindly come to para 16. So first finding is the report itself is not saying that. Second findings, 16. It is seen from the perusal of the report that the auditors were not certain while recording the finding that the transaction they investigated can be fraudulent, undervalued or preferential. So on the basis of such report, without any other independent material on record to support the contention of the liquidator, this authority cannot direct the respondent to make contribution of such huge amount towards assets as requested by the liquidator. Then kindly come to Millard, page 52, paragraph 19. In my considered opinion, the liquidator, having no other material except the findings of the auditor, which do not allege anything against the respondent, his prayer for directing the respondents to make contribution cannot be allowed. Besides this, the liquidator is so and so. And Millard, one more paragraph, I trouble your lordship, paragraph 22. Considering the materials on record, I hold there is not enough material to draw inference respondent did some transaction which are preferential, undervalued, fraudulent in nature, and such transactions were made despite the fact that directors of the corporate data could foresee that by virtue of those
This is a bit besides the point because this does not.
This is it.
But the TR has been straight apart. Yes.
Now, the appellate authority's order is at page 55. They took it up in appeal. I'm sorry, not they, my lord, the liquidator, Mr. Goel, took it up in appeal to the NCLAT. At the threshold, my lord, they dismissed it. We are not inclined to decide whether undervalued valuation that will. They say you don't have any material, don't waste our time. We last line is sarcastic. Don't waste the time. But this order reached its finality because, my lord, the liquidator did not take it up to Supreme Court. Now, my lord, in law, the effect of this is that so far as transaction audit report is concerned, the findings of the NCLT as confirmed by NCLAT stands. And my lord, it is binding upon the entire committee of creditors whom the liquidator represented. So one creditor individually cannot take a stand that others can drop, but I will maintain it. Because this decision, the finality and the conclusion regarding the report, which, my lord, NCLT says discloses nothing. My lord, is binding on each and every creditor. And it is perhaps this reason, because, my lord, the PNB order does not disclose it in so many words, but the lead bank dropped it. And the only distinction or the distinguishing feature of committee of, the identification committee is Punjab National Bank has done it. We are not bound by the decision of Punjab National Bank. Up to this, I can accept. But to say that the transactions for central bank is different, well, that is completely erroneous on the face of it.
Not
And
different, maybe different.
And may be different.
Might or may.
May be different. May be different. And 1 and 2, they are saying you are not supporting your case that the audit report is vague or with proof of document. You are merely making an allegation. What better than giving the order itself? I have given all the orders are there. With my representations, my lord, each and every representation have been saying this.
All the orders means? What
But the order of NCLT,
Oh, those.
NCLAT, everything was placed before them, not in one, but earlier representations and everything. Well, kindly come back to page 301, my lord. Part of the master circular which start at page 299.
Yes, 301.
Lord, in the show cause notice, Lordship would recall, my lord, which is at page 148. The only allegation is, my lord, 2.1.3b. A willful default would be deemed to have occurred if any of the following event is noted. I am at page 301, my lord.
Yes.
B. Unit has defaulted in meeting its payment or repayment obligation to the lender and has not utilized the finance from the lender for the specific purposes for which finance was availed of, but has diverted the fund for other purposes. Look, they have been unable to show that this was the purpose, this was not done, but my fund was diverted for another thing.
And diversion has been elaborated in 2.2.1 also.
Yes, 2.2.1, it has been elaborated, yes. That the whatever allegations of diversion.
Apart from card and furniture, what was the other allegation?
That fixed deposit and
Fixed
Visa
deposit,
NLT.
What have you done with the fixed deposit?
Fixed deposit, Millard, I have, as if I have
LHD?
taken the bank's money
Oh,
and
yes. You
deposited
said
it with another nationalized bank.
Very.
And Millard, the other allegation was that I have paid advance of 75 crores was paid, utilized by Visa Resource Limited, who is a related entity of mine.
Subsidiaries group.
Yes.
How did you deal with that?
But we have given all the particulars, Millard. In reply, Millard, I will tell you.
Just that portion.
That I showed your lordship at page 277.
Yes, you can show me from anywhere because you have said it several times before them.
Yes. Will kindly come to page 279.
Yes, 279.
Third paragraph.
Right.
The capital advance made to Visa Realty mentioned in the fourth and last observation was given to VRL to ensure smooth implementation of the project and was paid by the lead bank only out of the trust and retention account maintained with the lead bank and was paid with the knowledge and consent of all the bank. Look, an amount of this amount, 77 crores, I did not pay it in cash. It was paid by the lead bank through the trust retention account as part of my business. And Millard, the next paragraph, Lordship would see it may further be noted 2 out of the 4 observations, second and fourth stated in the minutes are not even faithful reproduction of the observation made by Deloitte in its report. The said 2 observations have been totally distorted by the branch office to try and justify making its recommendation. It is a further matter of regret department has blindly concurred with the said distorted observation without even bothering to check whether or not observations made by the branch office were faithful reproduction of the Deloitte report. Unfortunately, even the committee did not apply its independent mind to the recommendation of the branch office or to the concurrence of the department and has merely approved the recommendation without deliberation or discussion. This is evident from the fact that the members of the committee considered the minutes by circulation and there was no discussion or deliberation for the members to apply their
Mr. Chaudhary, these are your better points. I am on your worst point. I mean,
yes.
In my perception. Now, let us come back to that because this is the only point I can find where you can have a little less scope of, let us come back to that page 301 thing. So 301, 2.1.3 small b, that takes us to the next page, which is diversion of funds, which has been elaborated.
Yes.
Now, let us come to this C. C is transferring borrowed funds to such and such or other corporates by whatever modalities.
Yes.
But in this, no prior consent or knowledge is not a factor. Even if with consent you had transferred, I mean, does it alleviate your diversion? Because in certain other,
if my lord, kindly visualize, this is my lord, this is without consent, because my lord, if I am my lord transferring funds from my trust retention account, which is under the lead bank, my lord, what is a trust retention account? That my lord, when a consortium lending is given, my lord, the main operations are done through one account. So my lord, that is the trust and retention account where all money should come in and all money should go out of that. So if a money is going out of the main account, which my lord, the consortium of bank is authorizing, where is the question of diversion? And my lord, I can understand that. Then my lord, on what basis do they say it is central bank's money? My lord, here, my lord, the central bank, my lord, the central bank has to come to two findings, my lord. I go back again to 2.3.1b, 2.1.3b. Two findings have to be there. You did not utilize the money I had granted for this purpose. Instead, you did it for this. And my answer is that the money that you had given was completely utilized. My capitals at that point of time was much more. I showed that to your lordship.
Yes.
And the second is, you are saying I have diverted it. I dealt with the auditor's report, and my lord, on merits, I say.
You took the loan from the consortium.
My lord, there is no doubt, my lord. I had
Central is one of the components of the consortium.
I had taken loan from, my lord, 7 or 8 bankers which were of the consortium. My lord, if the coal block would have been there today, it would have been one of the, my lord, biggest thermal power project. Thermal power project construction, my lord. Why this, my lord, this L&T, my lord, L&T, my lord, they had in the section 9, my lord, they had a bank guarantee. L&T, my lord, terminated their contract. We invoked the bank guarantee because, my lord, the project was terminated midway. Moment the Supreme Court order came, L&T realized that it will, my lord, it will be a non-starter. It terminated the contract. So, my lord, we invoked a bank guarantee. That bank guarantee amount was kept in a fixed deposit. But we have said that it's not central bank's money. And then if that bank guarantee amount has been given as security or, my lord, utilized for the company, that is also disclosed. Where is the question of willful default?
But suppose, Mr. Chaudhary, central bank's money, you did not, it was not central bank's money as such, individually. But even then, central bank was a part of the consortium. And if you committed this willful default at all, that was with the money of the consortium, of which one of the components is central bank. I mean, then why cannot it, even without there being any specific allegation vis-a-vis the accounts of the central bank or the funds of the central bank, the loan is from the consortium of which central bank is a part. So how can we say that central bank does not have a say in it, even if the accounts of the central bank?
No, my lord. What is falling from your lordship?
Yes.
If the central bank or any bank, if they can show I have taken the money and let us say I have transferred it to my account.
Subsidiary, that is what is playing in my
My
mind.
lord, if it is coming to a, that was the specific finding in the forensic audit report. My lord, at that point of time, my lord, Visa Power,
independent of the forensic audit report, also you have not denied that that was parked there, but you have given a reason that it was
yes,
it
is through the trust retention account, my lord, from the main account. My lord, Power is dealing with setting up the thermals. Realty is, my lord, in charge of the subsidiary constructions which are coming around the thermal plant. The part of it, that's another. Through the trust retention, my lord, if I had any malintention, will I divert the money through the trust and retention account?
But Mr. Chaudhary, you fall within the definition. Diversion of funds means should be construed to include any of the undernoted occurrences, which includes transferring borrowed funds to the subsidiaries, group companies, or other corporates by whatever modalities.
Correct.
You satisfy this fully.
No. But I transfer it for some other consideration not relating to the business of the company. Kindly see the RBI circular once again.
Yes, I am on that only, 301.
Kindly come to 301 first.
Yes.
Unit has defaulted in meeting its payment or repayment obligation to the lender and has not utilized the finance from the lender for the specific purposes for which the finance was availed.
No, but C is also there. You have siphoned off.
But that is not his allegation. 2.1.3b, it's very specific. The show cause lordship will go back. Kindly come to
Apart from B, there is no.
nothing. Well, kindly come to the show cause. Page 147 at page 148. For other purposes, my lord, in 2.1.
It's the only clause.
And for other purposes.
So you are saved.
Right, my lord, I can assure your lordship, my lord, in this, there has been no foul play. It's an unfortunate thing we couldn't meet that, but my lord, it is like this. If now somebody goes to the site, my lord, they would see, my lord, a thermal power plant with the chimney, my lord, set up, with the base being there, my lord, abandoned and barren.
No, on that aspect, Mr. Chaudhary, I can fully sympathize with you. I mean,
because, my lord,
right.
if the coal block is, my lord, what happened? Overnight, my lord, the creditors stopped further finance when the coal block was taken away by the order of the Supreme Court.
Yes.
So, if 600 crores or 800 crores of rupees had already gone into, the construction is incomplete, the company is left in the lurch. Now, my lord, just since my lord is on that, my lord had expressed my
no,
lord.
I've got my answer also, in fact, probably. I mean, 2.1.3 B contains the expression for other purposes that is there very much. So in that context only, we can read 2.2.1. The entirety of 2.2.1 is on diversion of funds. And diversion of funds is referred to in B. 2.1.3b.
Yes.
B includes the expression for other purposes, which has to be there.
Yes.
As you rightly pointed out, it has to be for other.
Correct.
That component also has to be there, even if it is parked in the subsidiary account. Very good.
Well, there is no allegation I had given it for purpose X. That purpose X has not been done. Instead, purpose Y. Mere diversion also will not qualify as willful default. You have to show that you had taken the fund for me, let us say, for erection of the chimney. If the chimney has been erected and let us say there is diversion, can they come up and say that because, my lord, I have utilized the fund over there and I have answered their query? Well, in the second writ petition, since, my lord, I have already placed on facts, I just show one order so it will complete the entire chain. Well, because if I succeed over here, my lord, second is a formality because, my lord, this is the supplementary affidavit.
Right.
This is pursuant to my lord's order. Supplementary.
The supplementary affidavit contains that review committee order.
Yes.
Because they
Right.
initially had served only a communication.
Well, the communication that was initially served was only a cryptic, my lord, intimation that was given to us.
Yes.
Lordship's order, 1st April 2024, Lordship has recorded, my lord, the gist of the submission. My lord, straight away I take your Lordship. The Lordship will find the order starts at page 9. Rather, my lord, I will not call this an order at all, but be that as it may, since this has been served as an order. My lord, this is just an approval of the review committee which was dealing with 21 cases together in one go.
Yes.
So, Lordship will find
in supplementary affidavit, this ground they have not taken. That they have given in a whole with so many others. That ground they have not
That's
taken.
a new ground here.
This should not have been.
I take that ground. Yes.
Well, I am only making an observation from this.
Where is the order?
No, now, my lord, kindly see page 10.
Yes.
There are 21 companies. I am item number 1, SAM Kolkata, Visa Power Limited.
Yes.
Stressed asset management.
The SAM is Stressed Asset Management Kolkata. Sam Kolkata is stressed asset. So Visa Power, and then just below that page at page 10, Visa Power. Lordship will find Millard, where the details are there. Kindly come to page 11. Item 14, stage 1 approved on 14 September. Details of show cause notice 8th October 2020. I have shown your Lordship, that's at page 147. Details of representation or rebuttal received from the borrower, my lord, 4th November, 20th November. My lord, the 23 representation is not there, be that as it may. My lord, these two at least are there.
I've read up to the end of that chart, but then where is the order?
Yes.
Page 12.
Page 12, serial
12.
21.
Yes, 21 I've seen.
Yes. There is
Same
nothing
five-
else. This is
same
the
five-
order.
Yes. Huh?
This is the order. Page serial 21. Transaction audit report was given by Deloitte. Observations are under 1, 2, 3, 4. Then last two lines. Based on the above point, it was concluded that funds have been diverted from the system by the borrower. Criteria for declaring unit has defaulted in meeting of its payment.
Are you sure this is the entire order regarding you?
Well, this is identical to page 284. My lord, that's a copy paste. They simply copy paste in their format and put it. There is no other independent finding. There no other companies coming. I'm coming to that. I'm coming to that.
Page
34.
Yes. And then after this, same finding for all the 21 companies, then page 34. We propose to review the decision in respect of the above entities. Resolution, if approved, the following resolution to be passed, and resolution is, it is passed. Completely contrary to Jha developers, no reasons, no independent appreciation of mind, no application of mind.
Yes, Ms. Joshi. Prove yourself not to be your surname.
Hmm?
Yes, what is your case?
Representation.
Look, my first submission is this, that before NCLT it was very much categorically put to the notice of learned judges over there that the report which is given by Deloitte should not be used as a basis to lodge a criminal complaint or claim for damages. Now here, this is not a criminal, this report is not used for a
Which is the page number of that NCLT order?
page, your lordship will take page 46.
No, I'll because
Page 42, it's order.
46. You are placing page 46. Very well.
Page
Thank
46, pay right. My representation was recorded by the Honorable NCLT.
Where was
page
it
46.
stated that it will not be used
Paragraph
for
8. Page 46, paragraph 8.
yes, paragraph 8.
The respondent further contended that even the special auditor Deloitte in their report made it clear that their finding and observation in the report should not be used as a basis to lodge criminal prosecution or claim damages unless further investigation are being carried out. Here, instant proceeding is not a criminal proceeding or not a recovery proceeding. There it is before NCLT, this situation came up because the liquidator had claimed certain amount from the company and then that heavily relied upon the Deloitte report. Now, my lord, I'll be taking your lordship at page. My learned friend has taken your lordship to every detail, so I'm not going through and repeating all these things.
But Ms. Joshi, in the report there was something else also, not only criminal. In the report itself, which has been quoted in the first committee order,
Yes.
not only criminal regarding.
But willful default is altogether a different proceeding.
No, it's not
where
criminal.
No one is here there to recover any money, but it is this, my lord, this willful default why it has been introduced by RBI only because the person who are using public money and then they make in many various way default, and then they come out of that, and again they will go for another loan and another money, and that is why civil has been created.
Civil
and
has-
they are from willful default. If a person is declared as willful default, then he will not get any public fund. In
Ms.
fact,
Doshi, before you part with this point, this criminal complete, this is not a please come to page 233 once. Page 233 of the writ petition. This is volume 3 of their writ petition.
233.
Yes. That is the report itself.
Yes, my lord.
If you look at last line of para 2 onwards, para 4, 5, it may contain information obtained from third. We have relied upon information and did not independently verify the accuracy. They say any user who, and they also say Deloitte has not made and does not make any warranties or representations to any user, has not prepared the report considering any potential needs of any user, does not owe any duty of care or responsibility towards any user in respect of this report. If the author says this, Ms. Doshi, how can one rely on this report? Even the author himself itself cannot rely on it solely for the internal use, not only criminal.
Then
But you have to overcome that also.
identification committee,
Yes.
the directors and the person who were called for, who represent, they say auditor, audit report prepared by the auditor is inadequate. Now, onus is heavily falling upon them. When you say it is inaccurate, they will have to say what is accurate.
What are the other allegations which could be made against them?
No, your bank is saying, before the bank they represented.
Yes.
Kindly, your lordship will take page 292.
To 92, yes.
Kindly take 294. Page 294.
Right.
Mr. Visambar Saran informed the committee that he has submitted a detailed reply to the bank through various representation, that is representation dated 4/11, 14/12 and 13/9. Also informed committee that the transaction audit report prepared by the auditor is inadequate, non-conclusive and cannot be relied upon. Fine. I agree with them. If it is actually there, then once I say it is not correct, then onus is on me to say what should be the correct, that they have not.
No. The transaction audit report incriminated this person. He says it's inadequate. Now,
If
what?
it is
How
your
can
saying,
he will make it adequate by furnishing further proof against himself?
you have a knowledge that what is accurate, what is adequate. Once I say that is the inadequate, that I have a knowledge what is adequate,
All right.
what is accurate, but no document of adequacy or accuracy has been produced.
Right.
My lord, then just everywhere they have taken basis as Deloitte report, and Deloitte says but nobody prevented them to go to liquidator, take out all papers of the company, look into it. There is nowhere their statement that our company's report, a company's entire set of documents are with the liquidator, and they can take an inspection and can put it to the notice, but they have not done so. They have only everywhere and anywhere they have relied upon Deloitte. Because Deloitte has said I can show you, your lordship, all these type of forensic report and otherwise also audited report. At the end of this report, auditors will say that based upon whatever.
Here at the beginning.
They have written. They write whatever paper is produced to us. We have report. We have.
Ms. Doshi, I don't understand why do the banks rely always on these forensic audit reports and not rely on, as you rightly said, why don't you rely on the documents lying with the NCLT? Take out certified copies, rely on those, and indict them so that they have an opportunity to deal with those.
No, my
You are
question.
relying yourself on the forensic audit report all along.
Yes, my lord.
That's the difficulty.
But I am giving their facts and figure. This amount has been used here, used there. It has not come back to the system.
You are the prosecution. You have to first clinch the issue to shift the onus on them.
My lord, your lordship will take 293. There I have given. No answer is coming to this 4.5 points. Monthly rent agreed for the premises rupees 6,85,000 and fixed deposit of 26 crore. Where that money gone? They are not giving answer. Now only says it is this bank money or that bank money. But once it is a consortium, it means it is a one coffer. And a company, when a borrower becomes defaulter, then whichever is bank, even if that money is not secured, to that bank they have a right to lay their hand over it. They can lay their hand over it. They cannot say it is color of money is not that this is Punjab National Bank, this is Central Bank, this is State Bank of India. It is all in one coffer. Now, no answer anywhere. They have given this. Okay, Deloitte has not given. Now you give answer that where this money has gone as a rental and 25 crore. Then, as an addendum, you have also relinquished the right on furniture lying in the office of VIL. The basis this, the argument, the amount of capital expenditure reflecting as furniture and fixture in the books of account of VPL should have been written off in 11-12. However, you have carried and continued this up to 16-17. Then how you have written off when and what amount? No answer. Visa Power Limited had fixed deposit FDR of rupees 77.48 crores. Now my learned friend says it is not central bank's money. Now, color of money is not there anywhere. It's one coffer. Even if my money is not coming, I know your money is there. I can lay my hands. Then 77 crore and 65 crore total, it comes to crore with, Punjab National Bank, respectively on 31st March 2000. These FDRs were subsequently liquidated on 13th May 2016 and 14th June 2016, respectively. Pursuant to the liquidation of FDR, amount of 132.21 crore. And they say we have given it to Visa Energy with the permission, whatever, but they have to account for it. We have given permission. I have sanctioned loan and I have given you money. That doesn't mean you are not accountable. So, trust we have given, this money has given from this or from there is not question. They have to give specific answer that today where this money is. Just trying to evade that it is not your money is not the question. Then the transaction of pledging FDR, subsequent renewal of guarantee and liquidation of the FDR to pay off the loan taken by the related party. This transaction, these are the allegations that you have taken it and somebody else's loan you have paid off. Then the Visa Power paid capital advances amounting 75.68 crores to the related entity which have been utilized by VRL by buying equity and preferential share. Now they say we have not purchased from this money.
Yes.
Then from which money you have purchased? They are bound to show that source. Yes, if you have not agreed, then from which money you have purchased? That source you have to say. That means you have some other transaction and out of consortium you are making other transaction from other sources. Have you disclosed ever? Have you taken any permission that out of consortium fund I am using money? Nowhere. No document has been shown. And that is why it has been, then their entire representation has been taken. I am on this that if they say it is inaccurate, it is not correct, then it is, onus is upon them, my lord, that they will have to establish that what is accurate. That nowhere, everywhere Deloitte report, Deloitte says this, Deloitte this, but what are your independent answer? Where from you have sourced all this money? That they have not. And that is why ultimately page 277, 297.
What was the other writ petition you said?
It is the
Review committee, my lord.
Oh, supplementary, apart from the supplementary affidavit, you have also preferred an.
No, my lord, when we, after the first,
supplementary affidavit is for the other second, which is filed in 2000.
No, this, when you filed WPO 212, that was against what?
communication of the review committee,
50.
communication of the review committee without supplying the order.
Very well.
After that, my learned friend supplied the order pursuant to my lord's order.
So
we have-
633 is first committee and
it is the
212
review.
is-
It is the review.
Yes.
So your lordship is hearing the finding of identification committee.
Both. He has
Yes,
placed both.
but now I am making my submission.
Yes,
upon
you
the-
have made your submissions. What else?
This is what now page 97 bank has given its detail. That committee for identification report, this, there has dropped willful because Punjab National Bank has dropped, so I will have to drop.
No,
That's their argument.
you say it's a consortium loan, so
Consortium, so
every bank can.
Any bank, any
You have
bank
said
can-
that, repeated that thrice.
Ah,
Color of the money,
yes.
color of the money argument. Yes.
So these are my arguments before your lordship, but one more.
Thank you. Reply one line.
One line, my lord, page 278.
278.
My learned friend, my lord, this is what the bank does, my lord. Nobody goes through it and they say you have not given it. This 26 crores, the first allegation,
Yes.
I did not even take finance from the consortium. Prior to that, I had made that deposit. It has been stated here. My learned
It
friend,
is stated, where is document, it's support.
Which
I'm
paragraph?
saying it is stated.
Which paragraph? Page
my lord,
278.
page 278, last paragraph. All points have been dealt with. And all the documents are there in the affidavit, which was there in the NCLT. I don't have to give them. They did not ask for it.
No, they have come out with this.
And where is their?
They have to satisfy your lordship.
Right.
They have to satisfy that. They've just given letter and said annexure A, B, C, D, but no annexure. In their representation, your lordship will find that all letters without any enclosure. They have given their representation letter here, but no annexure. What is there in NCLT? Your lordship is not looking into the record of NCLT, looking into the writ application. There they were bound to satisfy your lordship, producing all documents.
I should have passed an order like the NCLT. I like the attitude of the NCLT. And I'm not bothered with rent or car was sold.
NCLAT.
NCLAT. I mean, which page is that?
56. Page 56.
I
Immediately.
loved that actually. Page 56. Have you seen that order, Ms.
I've seen
Doshi?
it.
This is called attitude.
This is my submission. They have not come up with all proper documents and they have not produced.
Having heard learned counsel for the appellant, we are not inclined to decide whether the sale of a car is undervalued or not while sitting in appeal. Dismissed.
So
We should emulate this. Not in this case, maybe.
Well, we were not.
We'll start from somewhere else.
We had joined virtually, so our appearance. In fact, the learned counsel who was for the appellant there, he had started with when the court asked, what is the issue? He said, 2 cars which are valued, this has been undervalued for 3 lakhs. Mercedes valued, undervalued for 3 lakhs. That you want the company law appellate tribunal to decide undervalued valuation of car.
I
Now
really love that. I mean,
other issues have not
there
been
should
decided.
be live streaming of, there is live streaming of those things also.
now
At that point of time, no.
it was irregular, but it was irregular. But this is what had transpired.
The funny thing is that no other issues were heard or decided by appellate
You
court.
should have challenged that,
Yes, it should have.
but you did not have the guts to. after seeing that two-liner.
Yes, should have been a challenge.
Hard-learned counsel for the parties. Hearing is concluded and judgment is reserved in the matter.
Subsisting in the second read is till 15th, so my lord, till
Interim order granted earlier stands extended till disposal of the writ petition.
in the second read.
I'm taking both together. I'm passing a common order, so interim order granted earlier covers that.
Very good.
Thank
Lordship,
I'm obliged.
Thank
Lordship, apologies, Lordship, kindly grant the liberty to mention when appellate side
What is the
matters.
mentioning for?
Lordship,
What do you want?
Lordship, the matter to be, Lordship, actually the matter was heard on under the heading new motion. But Lordship, the respondents weren't present. The counsel appearing couldn't brief your Lordship, and your Lordship directed to appear in the adjourned motion. Lordship,
I cannot do anything on that. Sorry.
Lordship, kindly grant the liberty to mention. Lordship, it's appearing under adjourned motion. We just want to appear in the new motion, Lordship. Lordship, under the same heading.